Before proceeding with the questioning of our witness, I'd like to make two announcements. I'm pleased to announce that the committees have reached an agreement with the government of Israel under which we will obtain significant new information for our investigation. The Israeli government will provide us with financial and other detailed information relating to the Iran arms sale. Our staffs have already seen some of the information assembled by the government of Israel, and we are satisfied that it reveals important facts. In addition, the committees will be able to interview General Raphael Vadi, who has led the Israeli government's fact-gathering in this matter. We will be free to present the information publicly in an appropriate form and to use it to cross-examine witnesses before us. The principal restriction on this use is the same that the United States imposes on use of its own classified material. We will not publicly disclose information that would affect national security. The committees wish to express our great appreciation for the unique cooperation being extended by a sovereign nation at this vital stage of our inquiry. Without such voluntary assistance, relevant facts would not be available to us or to the public. And without these facts, our investigation could not be considered complete. Further, in connection with Mr. Cooper's testimony this morning, we are releasing this morning the deposition testimony taken by our staff of the legal advisor of the State Department, the Honorable Abraham D. Safir. Do you wish to say something?
Thank you, Mr. Chairman. I just concur in your statement with regard to the agreement reached with the government of Israel and join you in expressing appreciation to the government of Israel for their cooperation.
Our first witness this morning will be Mr. Charles Cooper. Mr. Cooper, will you please rise? Do you solemnly swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Mr. Norton, or Miss Norton, I'm sorry.
Good morning, Mr. Cooper.
Good morning.
Your title is that of Assistant Attorney General for the Office of Legal Counsel, is that correct?
That is correct.
Can you tell us when and where you graduated from law school?
I graduated from law school from the University of Alabama School of Law in 1977.
And after that, did you clerk on the Fifth Circuit?
I did for Judge Paul Roney.
And after that, you had a clerkship with Justice Rehnquist of the Supreme Court?
That's correct.
And when did you join the Department of Justice?
In the summer of 1981.
And where were you assigned?
I joined the Civil Rights Division as Mr. Reynolds, Brad Reynolds' Special Assistant.
And
It wasn't a matter of assignment, it was a matter of accepting his job offer.
And how long were you in the Civil Rights Division?
In the neighborhood of 4 years, thereabouts.
When did you move to the Office of Legal Counsel?
In November of 1985.
Could you tell us what the Office of Legal Counsel does?
Certainly. The Office of Legal Counsel assists the Attorney General. Its primary function is to assist the Attorney General in his role as the chief legal advisor to the President and to the executive branch. In that capacity, we provide legal advice, by and large, to components within the Department of Justice, as well as to all of the executive branch agencies. Our normal relationship is with the general counsel of the various agencies, but certainly we provide advice as well to members of the cabinet.
So part of your job includes giving the President legal advice?
Yes.
And before you can render such legal advice, is it important for you to have all the facts before you?
It is certainly important to have as thoroughgoing a grasp of the factual background of a legal issue as possible.
Mr. Cooper, did you have any knowledge of U.S. sales of military equipment to Iran prior to November 1986?
I did not.
Had you heard of any finding in January of 1986?
Prior to November?
Yes.
I did not.
Were you ever consulted prior to November 1986 on the law regarding arms sales to Iran by the United States?
No.
Now, after the Iran sales became public, about the first week in November, did you become involved in researching the legal issues?
Yes, very shortly thereafter.
Okay. Can you tell us how this came about?
I'd be happy to. My recollection is that at a management retreat that the Justice Department was having on November 7th, the weekend actually of November 7th, the Attorney General mentioned to me, really quite in passing, that the controversy that was then beginning to be reported in the papers, and which I had taken note of, incidentally, regarding the arms sales, alleged arms sales at that point to Iran, would be in all likelihood generating some work for my office, and he just basically wanted to give me a heads up on that point. I think he told me to, at some point, get in touch with Paul Thompson, or to expect a call from Paul Thompson, who was then the General Counsel at the NSC.
Did the Attorney General note any specific legal areas that concerned him about the arms sales?
No. On November 7th, as I say, this was really a passing conversation, a heads up. We did not discuss any substantive legal issues at all.
Did the Attorney General tell you on November 7th that he had been involved in the January finding?
It's entirely possible that he had, but I don't think so. I don't think our conversation was very fleeting, as I say, and it just was not adorned with any details.
Did the Attorney General tell you that he had researched the matter before and had some work product for you, or some sort of opinions that he had done prior to November 7th, 1986?
Not on November 7th, to my recollection. It was certainly not long thereafter that I became acquainted with the facts that you were suggesting now.
Right. Did you become acquainted with those facts from the Attorney General or from Mr. Thompson?
In all likelihood, both of them, but I remember more crisply at this stage my conversation with Mr. Thompson to that effect.
Did the Attorney General discuss the staffing of this research with you? In other words, how many people he wanted to be involved in it?
Well, I have a general recollection, yes, that we did discuss staffing, because the question was, the issue he impressed upon me was one of the greatest sensitivity and the greatest importance, and about which all appropriate security should be taken. He suggested he wanted me personally to be integrally involved and to limit the staffing as much as possible, and he suggested that I limit my staffing, if I could, to one staff lawyer assisting me in the project.
And that would be one lawyer from your office, is that correct?
Yes.
And did that turn out to be Mr. McGinnis?
I did, not long at all thereafter, give Mr. McGinnis a heads up of much the same kind.
Could you tell us what Mr. McGinnis's legal background is, please?
Yes. Mr. McGinnis is a graduate, as I recall, of the Harvard Law School. He had an extraordinarily distinguished career in law school, a member of the Law Review, as I recall, and certainly stood out academically. He also is a graduate of Oxford University in England. I frankly cannot recall his undergraduate degree, but it is equally impressive, I'm sure. Mr. McGinnis spent a year clerking for Judge Starr, Kenneth Starr of the Court of Appeals here in the District of Columbia. He then worked, I think, for in the neighborhood of 2 years with Sullivan and Cromwell, a law firm in New York City, before joining the Office of Legal Counsel. He actually has more seniority in the office than I do. He was a staff lawyer in the office before I arrived.
And Judge Kenneth Starr is a former...
May I interrupt? Mr. Cooper, you may find it a bit more comfortable if you would raise the mic and bring it forward.
Thank you, Mr. Chairman.
I'm sorry. Please proceed, Ms. Norton.
Thank you. And Judge Kenneth Starr is a former counselor to the Attorney General, isn't that correct?
He is. To Attorney General William French Smith.
Yes.
Right.
Thank you. Now, you said that the Attorney General suggested that you call Mr. Paul Thompson to get some of the legal and factual background of the arms sales.
Either that I call him or that I expect to call. The upshot of it is that he and I would be in touch on this question, yes.
And were you?
Yes, we were.
And did you meet with Mr. Thompson?
I did.
Do you recall when that was?
Well, my best recollection for the first meeting that I had with Paul Thompson is November 12th.
And by the way, Mr. Cooper, you prepared after the fact a handwritten chronology of your activities from November 7th through about the 26th. Is that correct?
I did, very soon after the fact.
And for the record, that is CJC Exhibit Number 1. Please feel free to refer to it in any of the questions. Was this meeting with Mr. Thompson at the Department of Justice or at the old Executive Office building?
It was actually in the West Wing of the White House.
And did you meet with Admiral Poindexter?
I did, for a very brief period of time before I had my conversation with Commander Thompson. I've met and had some chit-chat with Admiral Poindexter. I'd never met him before, and so I sat down with him for a few moments.
Did Admiral Poindexter know what your purpose was in being there?
Oh, yes.
How do you know that?
Well, he did not state that he knew why I was there, but I have to assume that I was in his office chatting with him. It's inconceivable that he didn't know I was there to discern and learn facts relating to the Iran arms sale. I mean, it was just obvious that he knew why I was there.
What did Admiral Poindexter say about the facts relating to the Iran arms sale?
My best recollection is that we did not, Admiral Poindexter and I, get into facts. My recollection is that was something I was going to take up with the General Counsel, who was going to relate to me the facts as they had thus far been able to gather them. Keep in mind that prior to this meeting, I had had some telephone conversations, at least one, and probably more, with Mr. Thompson, in which my purpose, that is learning the facts that surrounded this initiative, the Iranian initiative, was well known to him, and he was making clear to me that there was an effort, a very intense effort within the National Security Council by the people most knowledgeable to gather those facts and to share them with me as soon as possible.
Did you, in fact, Mr. Cooper, nag him a little bit in order to set up this meeting so you could get some facts?
I certainly think it's fair to say that I, by this time, had nagged Commander Thompson to get the facts, not so much to set up a meeting. I just wanted the facts, and I was given to understand that a chronology of the facts was being created by the people most knowledgeable, and I was looking for a chronology, much more importantly than a meeting.
Were you told who would write the chronology?
I was ultimately. I cannot say that I knew at that point who was writing the chronology, other than that the people who were in the best position to develop a chronology were developing it.
Now, when you met with Admiral Poindexter and Paul Thompson, was it your understanding that they were going to provide you all of the facts they had at the time so that you could render a legal opinion?
Of course.
And after your brief meeting with Admiral Poindexter, did you and Mr. Thompson meet alone?
We did.
And did he produce for you a finding?
Yes, he did.
Could you tell us from where he produced that?
From some location that I took to be a secret place, either on his desk or close by to his desk. It was in a sealed envelope, and I was given to understand it was the only existing copy of this finding. And in a way that impressed me, I guess, and perhaps was designed to impress me with the very extraordinary sensitivity of this document and of this matter.
Did it appear to be the original?
Yes, it did, and it was offered to me as the original and only document.
Now, was this finding the January 17th, 1986 finding?
That is what I now know it was, and it was dated January 17th, yes.
Did Mr. Thompson show you any other findings?
No, he didn't.
Did Admiral Poindexter show you any other findings?
No.
Did Mr. Thompson mention that there were other findings?
It's possible that he did, but I have no recollection that I learned that there were other findings at that point. It didn't make an impression on my memory if he did.
Did Admiral Poindexter mention if there were other findings?
I would have to make the same answer, although it is with a much greater doubt, I think, that I would say that he showed me or discussed any finding with me. Perhaps he did, though.
Did Mr. Thompson tell you who had drafted the November 17th, 1986 finding?
No, I don't think that he did. I don't think that he did. I don't think we discussed the question of who actually sat down and was the principal draftsman. I did certainly understand from Mr. Thompson that the finding was the product of a deliberative policy-making effort involving the President and the appropriate national security cabinet members, including the Attorney General, who examined legal issues that surfaced during that policy-making period.
Did he tell you that Michael Ledeen also had information?
Yes, he did. I do well recall his mentioning Mr. Ledeen's name. It was in the context, I think, of him suggesting that somebody's going to have to talk to Michael Ledeen about all of this, because he is a very significant source of information about the whole Iran initiative. It was my distinct understanding and impression that Paul Thompson was not a source of personal knowledge about the details or facts regarding the implementation of the Iran initiative, and that he was suggesting that as the people who were knowledgeable were creating the chronology and gathering the facts, that Ledeen is going to have to be consulted.
Now, Mr. Cooper, around this period of time, did you begin to research the statutes involved in the legal issues that might have been presented by the arms sales?
Yes. During the period from immediately prior to the 12th and after the 7th, but I think the 7th was a Friday, and I'm quite certain I did not sit down with Mr. McGinnis until Monday, whenever Monday was. We kind of groped around, frankly, in the code, trying to identify the statutes that would pertain to such an event as we were given to understand by the media reports had taken place.
Now, did you basically conclude that there are two legal ways of transferring U.S. arms to another country? That is, the Arms Export Control Act and the National Security Act.
Well, we our research led us to the conclusion that there are at least two, and that those are two of them.
Could you tell us, in terms of the Arms Export Control Act, what your understanding is of the requirements of such country-to-country, government-to-government transfers?
Well, it is my recollection, and I have written some lengthy legal analyses on these questions, but my recollection at the moment is that the Arms Export Control Act carries with it a number of restraints upon such arms transfers to other countries, and among those restraints are things such as the foreign country must satisfy some certain policy objectives. In other words, that the arms be basically for defensive purposes, that kind of thing. As well as some other criteria. I think the thing that we focused on was retransfers from a country that had purchased arms from the United States to a third country, and the restraints that might encumber such a transaction, because that is what we were given to believe had taken place. And among the kinds of restraints that encumber a transfer like that are things like getting presidential consent. The first country must get presidential consent to a transfer to a second country, and that presidential consent can be forthcoming only if there is a commitment from the second transferee country that it will abide by all the kinds of restraints that were placed upon the first country, that the president report transactions of a certain magnitude. I think $14 million is the statutory figure. These kinds of restraints. It's clear that arms exports under this act have a number of restraints connected with them.
So, in reference to the Arms Export Control Act and these transactions, that is the arms sales from the United States to Israel and then to Iran, in particular a third country transfer then to Iran, would you agree that the third country, that is Iran, must be approved by the United States as a recipient for these arms by an appropriate authority, and also that Iran would have to certify to the United States that these arms would be used for purposes consistent with the Arms Export Control Act?
For any arms transaction that to which the Arms Export Control Act applies, I understand those to be the requirements.
Now, was it your understanding that there was a ban on direct sales from the United States to Iran at this time?
Yes, I certainly was acquainted with an executive order that blocked, that is, froze Iranian assets, as well as arms in this country that Iran had already purchased and paid for, as I later understood it. And not long thereafter, I was acquainted with an 1986 amendment that suggested that there should be no arms transactions, amendment to the Arms Export Control Act, to the effect that there should be no arms transactions to any country that has been designated as a terrorist country and by the Secretary of State. And I also learned that the Secretary of State had designated Iran as such.
So in order for there to be a lawful exchange of weapons or a lawful receipt of weapons by Iran, of U.S. military weapons, there would have to be some sort of affirmative presidential public exception to the Arms Export Control Act, or at least a public assertion that now it was policy, the president had approved a policy to send arms to Iran. Would that be a correct statement?
I'm hesitant about the public, but I think that's probably right. But I don't otherwise quarrel with the statement, so long as it's kept uppermost in mind that one must conclude that the transaction was an Arms Export Control Act transaction. And as we discussed earlier, there are other, in my opinion anyway, at least one other means by which arms can be transferred by the United States.
And that would be under the National Security Act?
Yes.
Okay. Can you tell us what the National Security Act would require in reference to an arms transaction between the United States and Iran?
Well, the National Security Act governs intelligence activities, including covert intelligence activities, and its principal requirement, at least the requirement that we focused on, were the congressional notification requirements for a significant anticipated intelligence activity, I think is the phraseology used in the Act. Beyond that, the restraints that I've cited about the Arms Export Control Act, I do not understand to apply under the National Security Act.
Nevertheless, the National Security Act would require a finding by the President for such arms transfers. Is that correct?
It would require a finding for such arms transfers. Actually, it's not the National Security Act that requires a finding. It's the Hughes-Ryan amendment. And the Hughes-Ryan statute amendment, so-called, requires a finding any time the CIA is involved in any intelligence activity abroad other than intelligence gathering, and yes, if the CIA was involved in a covert arms transaction, a finding would be required.
And it also requires congressional notice, is that correct?
Yes, the Hughes-Ryan amendment refers explicitly to Section 501 of the National Security Act, which is the provision that outlines congressional notice requirements.
And would you agree that the finding should be, of course, made prior to any of the covert activities being done?
That is my opinion.
Now, did you at some time between November 7th and 13th provide the Attorney General with a notebook containing the various statutes that we've discussed?
Yes, I did. I cannot tell you with any precision when that was, but it was in the early going of this matter.
Did you ask the Attorney General during this period of time whether indeed he had participated in the January '86 finding?
Yes. Oh, yes. Well, I can't tell you I asked him, but that became known to me very early on.
And did he tell you whether or not he had received any legal opinions or done any legal research during the period in which, in January, the finding was being debated?
Yes.
And what did he tell you about what research he had done?
He advised me that Mr. Sporkin, Stanley Sporkin, the General Counsel of the CIA, had done an examination of the legal issues that had surfaced back in January 7th, I think it was, when the Attorney General was made aware of those legal issues, and that the Attorney General had reviewed that analysis, had examined, in fact, the National Security Act, the congressional reporting requirements, and had concluded that Mr. Sporkin's analysis was sound, and apparently had indicated that it was his opinion that the project could go forward on the basis that was then established.
Other than relying on Mr. Sporkin's opinion and reading the National Security Act, did the Attorney General inform you whether or not he tasked anyone at the Department of Justice to do research in January of 1986?
On the contrary, he made clear to me that he had not staffed this matter out at all, but had performed this task personally. And he did so amidst clear references to the extraordinary sensitivity that he understood, and apparently all the individuals who were involved understood this matter to require.
And did you provide to him a legal memorandum outlining some of the statutes on or about November 13th, 1986?
Yes, I did. The memorandum actually was provided to him no earlier than November 14th, but we completed it on November 13th.
And would this appear as Exhibit Number 2, CJC Number 2 in the exhibit book?
Yes, it is.
Now, on or about November 17th, did you receive a draft chronology from the White House?
Yes, I did.
And did you, Mr. Cooper, provide to the select committees all of the chronologies you had received from the NSC during this relevant period of time?
We have.
Thank you. I direct your attention to Exhibit 3 in your exhibit book. The first page of which I understand is irrelevant to the subject at hand, and the chronology actually starts on the second page. That is the page dated November 17th, 1986.
Right, that's correct. This first page I now recognize, but it is indeed irrelevant to the exhibit.
Now, directing your attention to page 4 of that exhibit, and this is Exhibit 3. First of all, the handwriting in the left-hand margin, is that yours?
No, it's not.
Or do you know whose it is?
I don't know whose handwriting that is. I have to conclude that this marginalia was authored by somebody at the NSC, because I believe that I'm quite confident that this was on the document when we received it. I would also hasten to add that I cannot conclude with any confidence at all that we received this particular version of this chronology on the 17th. But we did receive a version. We have two versions in our files. One is cleaner and does not bear this marginalia and these interlineations that are revealed on this document. So I just can't tell you when we got one and when we got the other.
Of this version, Mr. Cooper, if I could direct your attention to the second paragraph and read from it, if I may. In September of 1985, the Israelis advised that they were close to achieving a breakthrough in their contact with Iran and would proceed unless we objected. It is important to note that the U.S. had long been aware of Israeli efforts to maintain discreet contact with Iran and to provide Iran with assistance in its war with Iraq. Despite long-term U.S. efforts to convince the Israelis to desist, Israel continued to provide limited military and industrial technology to Iran. The U.S. government judged that the Israelis would persist in these secret deliveries despite our objections because they believed it to be in their strategic interests. And then going on August 22, 1985, the U.S., through the U.S. citizen intermediary, acquiesced in an Israeli delivery of military supplies, 508 tows, to Tehran. We were subsequently informed that the delivery had taken place at the end of August, though we were not aware of the shipment at the time it was made. U.S. acquiescence in this Israeli operation was based on a decision at the highest level to exploit existing Israeli channels with Tehran in an effort to establish an American strategic dialogue with the Iranian government. Now, Mr. Cooper, was this your first information that there had been a shipment to Iran prior to the November 1986 finding?
The November, yes. The chronology that we received on or about November 17th was the first time that I had any knowledge that arms transfers from any country related in any way to this matter had taken place prior to the issuance of the finding, or at least the January 17th finding.
So up until you got the chronology, Admiral Poindexter did not tell you about the 1985 shipments, and Mr. Thompson did not tell you about the 1985 shipments. Is that correct?
That is my distinct recollection.
And if I can direct your attention to page 5 of the same exhibit, The first full paragraph reads, "In late November 1985, the Israelis, responding to urgent entreaties from the Iranians, provided 18 basic Hawk missiles to Iran in order to improve the static defenses around Tehran. The Israeli delivery of Hawk missiles raised U.S. concerns that we could well be creating misunderstandings in Tehran and thereby jeopardizing our objective of arranging a direct meeting with high-level Iranian officials. These missiles were subsequently returned to Israel in February 1986 with U.S. assistance." Mr. Cooper, is this the first you ever heard of a November 1985 Hawk shipment?
I do believe it was. I believe I heard through my assistant, Mr. McGinnis, who was, of course, reading these chronologies as they came in, and much more closely than I was. But yes, I can recall very well that he shared this information with me and recognized its significance.
Once you recognize that there were 1985 shipments, can you tell us what the legal significance and the legal problems that those pre-finding shipments brought to your mind?
Well, we identified two potential legal issues that were raised by these shipments that I can recall now. First of all, it appeared from the information that we had that these shipments were in all likelihood encumbered by the Arms Export Control Act. We had assumed, and we tried not long thereafter to find out for sure, that TOW missiles and Hawk missiles, and I assure you neither of us had any idea what these armaments were, but we assumed that they were the kind of armaments that were the kind that Israel could only have obtained through the Arms Export Control Act process, and therefore encumbered by the various restraints upon retransfer to another country. That was not our major concern, I have to confess, however, because if Israel violated the statute, that, I guess, was Israel's problem. That was not something that immediately concerned us. The major concern that we had, frankly, was that the Arms Export Control Act places a reporting requirement upon the administration or the executive branch to report violations of the Arms Export Control Act, and to do so, I think the term is immediately. So we became concerned that these apparent violations may not have been reported immediately, and whether or not there were, we began to examine whether or not there were, what kind of reasons there might be underlying this, and whether those reasons would be, would excuse the failure in some way or another, if indeed there was a failure.
And in regard to the National Security Act and Hughes-Ryan, in other words, if these were sales that were covert activities of the CIA in any way, or the CIA involved, what was your concern about the 1985 shipments?
Well, I don't know whether this particular chronology references potential CIA activity in the November Hawk transaction. But if not in this one, in the very next one we got, there was reference to CIA activity in that. And November, if that took place in November, the question obviously arises whether or not that activity was in violation of the Hughes-Ryan Amendment, which requires a finding, and requires a finding, in my opinion, prior to the time that the activity is undertaken.
When you learned of these 1985 shipments, did you tell the Attorney General about them?
Yes, I certainly did. I can't tell you what amount of time elapsed, but I did not tarry. I told him at my next opportunity to do so.
And do you recall what his response was?
His response was like mine. one of surprise and concern. He was entirely unaware of this activity. It was my clear understanding and impression.
Once you learned about the 1985 shipments, did you call Oliver North or John Poindexter or Paul Thompson or Robert McFarlane to find out more about them?
Well, I'm certain I didn't call Mr. McFarlane. I'm certain I didn't call Mr. Poindexter. I probably called Mr. Thompson, however, and it's my general recollection that I did.
Did he offer you any more information on the 1985 shipments?
I'm sure that he didn't, because he was not, at least I did not know then, and I don't know now, that he was a repository of any personal knowledge relating to these matters. And it was my understanding that he wasn't, but throughout this, he impressed upon me, and I fully understood that the people who were attempting very on an urgent basis to gather all of the information were doing so, and that the chronologies and their understanding of the facts, particularly these facts that relate to Iran, was sketchy, and they're doing the best they can. So it was not with a high level of confidence that I accepted this portrayal or this understanding of those events, but I certainly came to accept the proposition that events of this kind, arms transactions, had taken place prior to the finding.
Do you know whether or not, once you told the Attorney General about the 1985 shipments, whether or not he called Colonel North, Admiral Poindexter, or Mr. McFarlane to inquire about them?
I don't know the answer to that. I don't recall if I ever did know, but I certainly don't recall now.
And is it your understanding from the paragraph which I read of that exhibit that the position of the National Security Council when drafting this chronology was that the Hawk shipment in November was done without U.S. permission, and that the U.S. Disapproved of it and eventually arranged or prompted the return of those missiles? Would that be a fair interpretation of that paragraph?
Yes, it would, and that understanding of the event was ratified and reemphasized not long thereafter in the next chronology.
Okay. Turning now to November 18th, did you attend a meeting at the White House?
I attended a meeting, and it would have been around that time, and I am advised by the staff that they have placed the date on November 18th, and I certainly don't resist it. That sounds about right to me.
Could you tell me where the meeting took place?
Yes, it took place in Mr. Wollason's office, Peter Wollison, who was counsel to the President.
And who was at the meeting?
Certainly Mr. Wollison, and certainly me. From there, my certainty flagged somewhat, but I do believe confidently that Abe Sofair was there from the State Department.
Could you tell us what his position is, please?
He's legal advisor in the State Department, which is analogous to the general counsel position. I also do confidently recall that Mr. Doherty was there, Dave Doherty. I'm distinct in my recollection of that. So also, I believe, was Mr. Garrett, Larry Garrett of the Department of Defense. He is the general counsel there. Dave Doherty, by the way, is general counsel at the CIA. And Paul Thompson, I confidently believe, was there.
What was the purpose of this meeting?
Well, I think it was a general purpose meeting for the general counsels of the most relevant agencies to visit on this matter of the Iran arms transactions. It also was an opportunity for those of us who were not acquainted with the process of findings, of developing so-called findings in the intelligence area and communicating them to the Congress could be described by Mr. Doherty. It also became a session in which the general counsels complained and criticized for the lack of information that they were getting on the whole matter.
Whom did they criticize for the lack of information they were getting?
I think the NSC, in the person of Mr. Thompson, though the criticisms were not personal, as I understood them.
Would you say it's fair to characterize that Judge Sofair was a bit irritated that he was not getting more information from the National Security Council?
That is a fair characterization.
What did Paul Thompson tell the people at this meeting about the 1985 shipments?
My general and impressionistic recollection is that he basically told them the same thing he had been telling me, which was they're doing the best they can, and the people who are in the best position to develop those facts are doing it feverishly, and they'll just do the best they can. That's a confused and complex chain of events.
Did Mr. Doherty or anyone else in the room during that meeting mention CIA involvement in the 1985 Hawk shipment?
I'm drawing a blank from my memory. If I could consult the note I took at that meeting, which I know is one of your exhibits,
That's
it might help.
Exhibit CJC4.
I do not see any reference here, and I don't recall any.
Now, turning your attention to the next day, November 19th, the President had a press conference in which he described the Iran arms transaction. Did you watch that press conference on television?
Yes, I did.
And did anything the President said in the press conference concern you?
Yes, it did.
Could you tell us what that was?
At some point in the press conference, excuse me, the President made a statement to the effect that there had been no third countries, that we had not been involved in any way with a third country in this matter. And I think he was responding to a question that had identified the third country, but I don't recall that. In any event, all of the information that I had received to that point, including the information post-finding, post-January 17, about which there didn't seem to be a whole lot of disagreement, and about which I was reasonably comfortable in terms of the legal positions. I was entirely comfortable. So I understood confidently that to be an error.
What did you do when you became concerned about the statement about no third country was involved?
I immediately called Commander Thompson at the White House. I was in my office watching this, and I got through to him immediately, and he was in his office. And
what did he tell you?
He knew why I was calling, and I didn't need really to articulate my concern, and he told me that a correction would be forthcoming instanter.
And to your knowledge, was a correction forthcoming?
Oh, yes. No, I searched the papers the next morning, and indeed it had been corrected.
Do you know what the Attorney General's reaction was to this confusion about third country, the third country remark?
It was identical to mine, I understand. the following day told me that he had placed a call as well to the White House contemporaneously with mine and had made known his view that if the President is in error, the correction should be made immediately.
Now, the next day on November 20th, did the Attorney General invite you to a meeting at the White House?
Yes, I can't state with confidence that he invited me on the 20th. It may have been on the 19th, but I think I became aware of that meeting on the 20th, and we did attend it on the 20th.
What was your understanding the purpose of that meeting would be?
To meet with Admiral Poindexter and Mr. Casey, as well as, I take it, others who were going to meet and try to go over their testimony to the intelligence committees the following day. They were scheduled to testify and to share as much as they then could and knew about the Iranian initiative with the relevant committees of Congress, and we were to go and participate in that meeting.
And did you know whether or not the Attorney General indeed changed his plans in order to attend that meeting?
It is my understanding that he did. He had planned to leave town earlier in the day and not attend the meeting. I do understand, and I think he did, change his plans, I think primarily in the aftermath of the news conference.
So he considered this session a serious enough thing to warrant his attention that day?
I think his concerns, yes. He did, obviously.
Do you recall what time of the day the meeting occurred?
Well, my chronology says 1:30 to 3. All of my chronology times are the best I could reconstruct, but I certainly don't have a refreshed recollection on it. 1:30 to 3, I guess.
Who was at this meeting to draft Mr. Casey's, or to go over a draft of Mr. Casey's testimony?
Again, my chronology identifies, and this is consistent with my present memory, Casey, Director Casey, Colonel North. There was somebody with Director Casey. I recorded in my chronology Mr. Gates, but I cannot see him in my mind's eye, but there was somebody there, and I think it was Mr. Gates. The Attorney General, myself, Mr. Thompson. And I think that's all. I can't be entirely certain, however.
Did you have an advanced copy of the draft testimony?
I don't believe that I did. I believe I received a copy of the Director Casey's prepared or proposed testimony at that meeting.
Do you know who drafted it?
His prepared testimony?
Yes.
I actually guess I never did identify precisely who prepared the document, but I assume it was people at CIA with NSC assistance, I should think. But frankly, I don't know.
Now, calling your attention to exhibit number 5, and this would be the second page of Mr. Casey's draft testimony, and I'd like to read from the second paragraph and on regarding what Mr. Casey anticipated testifying to in Congress about the 1985 Hawk shipment. In late November 1985, the NSC asked our officers to recommend a charter airline, the reliability of which we could vouch for, to carry some cargo from Tel Aviv into Iran. And then it's blanked out, was told that there was some urgency about this in connection with a meeting in Geneva between an Iranian official, the expatriate intermediary, and a private U.S. citizen. And then the source is blanked out, recommended a proprietary of theirs called blank. This little airline regularly took on commercial ventures, did not know what was being moved. When the plane got to Tel Aviv, the pilots were told the cargo was spare parts for the oil fields and was to go into Tabriz. Our blank decided that in order to protect the plane, our blank should be asked to get flight clearances into Iran. On November 25, 1985, the plane dropped the cargo in Tehran without knowing what it was. The Israelis were unwitting that the plane was a CIA proprietary, and the airline charged a normal commercial rate, which was approximately $127,000. Our Associate Deputy Director of Operations authorized the flight because of the alleged urgency of the requirement, but, and then this is crossed out, in consultation with the Deputy Director, decided that we would not provide any future support of flights into Iran in the absence of a finding. We didn't learn until sometime in January 1986 that the shipment involved 18 air defense missiles and that it was later rejected by the Iranians on the basis that it was not what the Iranians had ordered from the Israelis. In this affair, our air proprietary had been made available to accommodate a delivery requirement in which the NSC was interested, and the shipment was billed and paid for at the normal rates charged by our air proprietary.
Before you ask a question on that, Ms.
Yes.
Naughton, I would point out, I think, a place in your reading where I understand the document to be slightly different. The sentence is on page 2, and it begins, "This little airline regularly took on commercial ventures," and you read it, "did not know." I think the sentence is actually two sentences, and it's a period after ventures, and that the next word is, "we did not know."
Thank you, Mr. Coburn. I think that's probably correct. So,
And I think that is a reasonably significant distinction.
for the record, those words are crossed out in handwriting, correct, and a capital W inserted.
I think that's
So
right.
that the sentence was changed to read, "This little airline regularly took on commercial ventures, period. We did not know what was being moved." We referring presumably to the CIA.
Presumably, that's how I have read and understood the sentence.
And the draft also said that the CIA was not aware that it was Hawks until January of 1986. Is that correct?
That's right.
And the draft also said that the Hawk missiles were rejected by the Iranians and returned by them. Is that correct?
Could you invite my attention again to that?
Yes, on page 3, the first full paragraph, that the missiles and that it was later rejected by the Iranians on the basis that it was not what the Iranians had ordered from the Israelis.
You are correct.
All right, now that differs from the version and the chronology you had received from the White House, which said that it was the U.S. that did not affirm the transfer of arms to Israel. Is that correct?
That's correct.
And now this version says it's the Iranians who didn't want the missiles. Is that correct?
That's what it says.
Now, was there an insertion to this language proposed at the meeting to go over the draft testimony?
Yes, there was, and in fact, it was the insertion that that was the focus of everybody's attention with respect to this November episode. It was not the paragraphs that we have just gone over. All of the attention that related to the November episode, and there was a considerable amount of it during the meeting, was focused on the insertion. That was the dominant document, actually, with respect to that episode.
Fine. Let's turn to it then, and that's CJC Exhibit Number 6, entitled Subject CIA Airline Involvement. Could you tell us first, before we go into it, who presented the arguments proposing this insertion?
It really wasn't the situation was that the insertion was the discussion of the issue that we were going to examine. That was under examination. It wasn't, let us replace the other discussion with this. It was as though the other discussion didn't even exist in the document. I do not recall having had any conversation focused at all about whatever was said in the document we just examined. This was the only one, and I don't recall who proposed it. The documents were handed out, actually, as I recall, contemporaneously with one another.
So the insertion was handed out at the same time the draft was, that you recall?
Actually, I think it was, I picked up the insertion and a draft on the couch, so they had already been handed out when I got there.
And in terms of who explained the facts relating to the insertion, who in the room was basically the chief spokesperson for the insert?
Lieutenant Colonel North was truly about the only person who had much discussion at all about this episode, the only one contributing any factual knowledge
Thank you.
that I recall.
Now, going down to the 6th paragraph on the insertion, which is CJC Exhibit number 6, if I may read that into the record, it states, "To the best of our knowledge," and then there are some handwritten delineations, "neither the Israelis nor the Iranians knew that they," and then it says, "was dealing with a CIA proprietary, comma, nor did airline personnel know what they were carrying. No one," first of all, the original language read, "We in CIA did not find out that our airline had hauled Hawk missiles into Iran until mid-January when we were told by the Iranians." And the first part of that sentence is crossed out in handwriting, and instead is written, "No one in the USG," assuming U.S. government, "found out that our airline had hauled Hawk missiles into Iran until mid-January, when we were told by the Iranians." Now, Mr. Cooper, who proposed the change in that language from "no one in the CIA knew it was Hawks until January" to "no one in the U.S. government knew it was Hawks until January"?
Lieutenant Colonel North, and it is my distinct recollection that he was the author of all of the interlineations that you see on this page.
And when Colonel North made the assertion that no one in the United States government knew that they were Hawk missiles until January of '86, in this proposed testimony to Congress, did anyone in the room dispute that fact?
No.
Did Mr. Poindexter dispute it?
No.
Did Mr. Casey dispute that?
No.
Did they remain silent?
They reacted the same way I did, or at least that was my impression, that, okay, if that's the way it was, then fine. I mean, they did not appear to me to have any personal knowledge of this matter.
And they accepted that change, is that correct?
Yes.
What was your impression of the deference that Mr. Poindexter and Mr. Casey gave to Oliver North in your observation of this meeting?
Well, I did not, no impression was retained on my memory in particular of any deference that they gave him. They gave him the deference that one gives to a person who has superior knowledge of the facts, or has the only basis for having any knowledge in the facts, whether that's because they've been reported to him or because he personally knows. But he stated this with authority. The no one in USG found out. In fact, he wanted to, I can recall crisply, that he wanted to eliminate the inference that someone in the United States government knew about this, even if the CIA didn't.
So Mr. North's position was that if the document read "no one in the CIA knew of it," that would infer that someone in the government did.
Yes.
And he wanted to erase that inference. Is that correct?
Yes, and I thought if that was correct, that we certainly ought to do that.
Now, in your deposition, do you recall telling us that Mr. Poindexter and Mr. Casey gave absolute deference to Colonel North during that meeting?
Well, I would be surprised if that's my formulation, but the record will speak for itself. I do not, with respect to factual matters, everybody in the room was deferring to North. Yes, if that's the sense in which I use the term. But it was not like these men, these cabinet officials, were somehow in awe or taking some kind of a particularly deferential or respectful position vis-a-vis North, although they quite obviously knew him very well, and he was comfortable around them, and they were comfortable around him. I'd never met, I don't think I'd ever met anyone there except, well, I certainly hadn't met North before, and I don't believe I'd met Mr. Casey before that time. I was deferential to them, I can recall that.
What was Mr. North's position or assertion during that meeting regarding why the missiles were returned by Iran?
His assertion was consistent with the chronology that we have previously discussed, and even more consistent with a chronology that we have not discussed, which is the 1120 chronology. But the upshot of it was that we, the United States, were upset about this transfer of 18 Hawk missiles because it in some way interfered seriously with our own efforts and our own plans vis-a-vis Iran, and that North had been tasked in no uncertain terms to get those Hawks back, and that it is my recollection, he used the term jawbone to describe how it was that he got the Hawks back from the Iranians.
So in North's version to this group meeting to draft Mr. Casey's testimony, he stated that the Iranians wanted to keep the Hawks, and indeed he had to use some persuasion to get them back from them. Is that correct?
That is accurate.
Now, I direct your attention to CJC Exhibit Number 8, which is a barely legible Prof note. Mr. Cooper, were you aware of such Prof notes' existence during this period in November of '86 when you were tasked to draft legal opinions?
No, Ms. Naughton, I continue to believe that the first time I'd ever seen a document of appearing as this one does or being described as a Prof note was when you showed this document to me earlier this week.
So Admiral Poindexter never told you of such Prof messages at any time, is that correct?
Oh, yes, that is certainly correct.
And Oliver North never told you of any such Prof messages at any time, did he?
No, he did not.
Let's go through this one. And this one's dated November 20th, 1985. It is a note from Oliver North to John Poindexter, and it's regarding private blank check, which was the code name. It's a wrap-up as of 20:30 hours, stating the Israelis will deliver 80 modified Hawks at noon on Friday, 22 November. These 80 will be loaded aboard the 3 chartered aircraft owned by a proprietary which will take off at 2-hour intervals for Tabriz. The aircraft will fly overflight through the blank en route to Tabriz. From appropriate arrangements have been made with the proper blank air control personnel. Once the aircraft have been launched, their departure will be confirmed by blank, who will call blank, and it goes on to explain the arrangements. The second paragraph states, there is a requirement for 40 additional weapons of the same nomenclature for a total requirement of 120. $10 million as payment for the first 80 has been deposited in the appropriate account. No ACFT aircraft will land in Tabriz until the AMSIT's American citizens have been delivered to the embassy. The Iranians have also asked to order additional items in the future and have been told that they will be considered after this activity has succeeded. All transfer arrangements have been made by Dick Secord, who deserves a medal for his extraordinary short notice efforts. Mr. Cooper, this seems to be describing on November 22nd, 3 days before the Hawks were delivered to Iran, that Mr. North was indeed instrumental in the delivery of these Hawks through Israel to Iran. Is that correct?
It certainly does.
And yet, when he made the assertion in the room, preparing to draft testimony before U.S. Congress, and he stated that no one in the United States government was aware that these were hawks until January of 1986. Admiral Poindexter did not dispute that, did he?
He did not.
And Mr. North never withdrew his assertion during that meeting, did he?
No, he didn't.
And I direct your attention to CJC number 9, which is another Prof message 2 days later on November 22nd, 1985. And I won't read it because it's complicated involving the arrangements, but will represent for the record that it involves the arrangements of the snafus that they encountered in trying to get the hawks delivered ultimately to Iran. Mr. Cooper, had you seen a copy of that message prior to my showing it to you in your deposition?
I had not.
And I direct your attention to exhibit number 10, which is a Prof message on December 4th, 1985, again from Oliver North to John Poindexter, subject private blank check, the second paragraph of which reads, "The attempted transfers of 18 Hawk missiles went awry because the Iranians were in fact seeking a weapons system that would be capable of stopping Soviet reconnaissance flights along the Iranian-Soviet border and on the Iranian-Iraqi border. Meaning Gorbanifar, reported that these flights occur regularly and as deep, that's a hard word to read, as 40 miles inside Iranian airspace. Because Schwimmer and Ledeen were unfamiliar with the operational parameters of the Hawks, they agreed to ship 120 weapons that were totally inadequate to meet the requirements established by the Iranians. This delivery has created an atmosphere of extraordinary distrust on the part of the Iranians." Mr. Cooper, had you seen a copy of this Prof message prior to my showing it to you in your deposition?
No, I have not.
And it is clear from this Prof message, is it not, that Mr. North is stating to Mr. Poindexter that it was indeed the Iranians who were displeased with the Hawks.
Oh, that seems quite clear.
Was it your impression from the drafting session, then, that the position Mr. Casey was going to take at his testimony was that the U.S. had opposed the shipment of Hawks and indeed had to send, or Mr. McFarlane had to send Oliver North to Jawbone to get the Hawks back?
I understood that to be the facts, that nobody disputed. Whether or not that was going to be imported in the testimony, I just don't remember. If the testimony that he ultimately gave reflects that, then I guess it is, but I just don't recall.
But at any rate, CJC 10, the Prof message of December 4th, indicates quite clearly it was just the opposite. The Iranians didn't want the missiles.
That's clearly what it reveals, and certainly that's what I learned not long thereafter.
Turning your attention to exhibit number 11, which is a chronology prepared by the CIA and sent to the White House. As exhibited in the upper right-hand corner, the words Ollie North-JP, John Poindexter's signature, directing your attention to page 2, the second full paragraph, which reads, "In November 1985, as the next step in the operation, the NSC arranged for Israel to send 18 Hawk missiles to Iran. However, the Israelis neglected to remove the Israeli markings from some of the missiles. This oversight, plus the fact that the Iranians had been led to expect that they would be receiving blank Hawk missiles, led to a huge disagreement which caused further developments to grind to a halt." Now, While you were in that drafting session or any time before that, had you ever seen a document which said that the NSC had arranged for this November hawk shipment?
No, I do not believe I had.
And Colonel North, during that drafting session meeting, did not say, did he, that the NSC had actually arranged for that hawk shipment?
Quite to the contrary.
And Mr. Poindexter did not dispute that, did he?
He did not dispute that no one in the United States government even knew about it.
Going then to exhibit number 12, which is the finding drafted by Mr. Sporkin of the Central Intelligence Agency and dated 26 November 1985. I direct your attention to a cover letter which is transmitting this finding from Director Casey to Admiral Poindexter at the NSC, stating, pursuant to our conversation, this should go to the President for his signature and should not be passed around in any hands below our level. Further, it states, the text of the finding, that I have been briefed on the efforts being made by private parties to obtain the release of American hostages held in the Middle East, and hereby find that the following operations in foreign countries, including all support necessary to such operations, are important to the national security of the United States. Because of the extreme sensitivity of these operations, in the exercise of the President's constitutional authorities, I direct the Director of Central Intelligence not to brief the Congress of the United States as provided for in Section 501 of the National Security Act of 1947 as amended until such time as I may direct otherwise. And the description of the operation is as follows. The provision of assistance by the Central Intelligence Agency to private parties in their attempt to obtain the release of Americans held hostage in the Middle East. Such assistance is to include the provision of transportation, communications, and other necessary support. As part of these efforts, certain foreign materiel and munitions may be provided to the government of Iran, which is taking steps to facilitate the release of the American hostages. All prior actions taken by the United States government officials in furtherance of this effort are hereby ratified. Mr. Cooper, had you seen this document before the drafting session on November 20th, 1986?
No, I had not.
Would it be fair to characterize it as clearly a finding which states that arms and other support will be given by the CIA in exchange for the release of the hostages?
I would not quarrel with that description.
And it describes, does it not, prior actions which may have been taken by U.S. officials.
Yes, it does.
And it is dated 26 November 1985. Is that correct?
Well, the cover letter is the finding itself. I would be surprised to see that the finding itself was, because I did see this finding during the weekend fact gathering, but I never saw this cover to my recollection, and I think I would have noted that.
Presuming that the contents of the cover is accurate and that the finding is being sent with the cover sheet, the finding therefore had to be transmitted on or about November 26, 1985. Is that correct?
It is, and it certainly squares with other information that I received during the weekend.
And it is to Admiral Poindexter from Director Casey. Is that correct?
That is accurate.
And it describes arms for hostage activity and refers to prior actions taken.
It does.
Is that correct? And yet, during that session, in the drafting of Mr. Casey's testimony, when Oliver North asserted that no one in the United States government knew of the Hawk arms transactions prior to January of '86, Mr. Poindexter did not object, did he?
That's true.
And Mr. Casey did not object, did he?
That's true as well. I guess I would point out, though, that there were people apparently under the impression, certainly I was under the impression early on, that the Israelis delivered oil drilling equipment, and that was something that was contained in various chronologies, and not hawks. But
Well, Mr. Cooper, do you see the phrase oil drilling equipment anywhere in this finding?
oh no, no.
There
certainly
is
not.
the word munitions, however, correct?
Oh yes.
Right. And while you sat there at this session drafting Director Casey's testimony, did you know that indeed there were CIA cables that CIA headquarters had received which related that the pilot of this aircraft piloting the Hawk missiles had indeed cabled the CIA through the air traffic controller, that the CIA had picked up the pilot's comments that indeed he knew he was carrying military equipment? Were you aware of those cables, Mr. Cooper?
I certainly wasn't. I was the next morning, however, or at least I picked up my first suggestion of that fact.
Now, could you tell us again why it would be significant legally if it had occurred indeed that this Hawk shipment had the assistance of the CIA and possibly the National Security Council and a finding had not been made?
If the CIA assisted in such an intelligence activity, it would require a finding.
And to your knowledge, there was no finding prior to January of 1986, is that correct?
That is correct.
Now, after this session in which you met to revise Director Casey's testimony, did you proceed into Mr. Wollason's office?
Yes, I did.
And while you were there, did he receive a call from Judge Sofair from the State Department?
He did,
And while you were there, did you speak to Judge Sofair?
briefly.
What did he have to tell you about this issue?
What he told me was that he was very worried and concerned, something to that effect, about the information that was then apparently going to be provided to Congress the following day. He did not want, however, to discuss the matter further with me, and I think that Mr. Wollason was on the phone with me at the time, so with us, on a non-secure line. And so that was about the end of my conversation with him. He then called back on the secure line.
In Mr. Wollason's office, to Mr. Wollason's office?
Yes.
All right. And did you talk to him on a secure line?
I did not, to my recollection, but Peter Wollason did.
And did he relate to you what Judge Sofair's concerns were?
Peter did.
What did he tell you?
Essentially that the State Department believes that we did know that there were hawks. I shouldn't say hawks because I don't think hawks was introduced in the conversation at that point, but that there was something other than oil drilling equipment, and in particular arms, on that Israeli plane, or involved in that November episode.
Did Judge Sofair indicate where he got that information?
Yes, that the secretary could recall a telephone conversation. I don't remember whether he said November 18th, but certainly before January, and I think in the neighborhood of November 20th, 18th, 20th, around there, could recall a conversation with Mr. McFarlane, in which Mr. McFarlane told him there were arms on that plane, and essentially described the whole arrangement.
Do you know whether or not that conversation had been recorded in any way?
The secure phone call?
No, no, Mr. McFarlane's statement to Secretary Schultz, if there had been any notations taken of that.
I did not know then. I did know when I returned to my office some time later and talked with Abe myself.
Now, when this was raised, that perhaps Mr. McFarlane had told Secretary Schultz prior to the shipment that it may be military equipment, did that raise concerns in your mind?
Oh, yes, it did.
Why?
Because I had just left the meeting literally moments before in which representation was made to the effect that no one in the United States government knew that there were hawks on that plane until January. And the report that Peter Wallison had given us was not consistent with that. Now, I should add, Peter, I don't think fully appreciated at the moment the nature of the information that he'd received, because he was not in the meeting that I was in, wherein a different understanding was discussed and agreed upon.
Do you know whether or not anyone checked with Mr. McFarlane or Colonel North regarding what Judge Sofair had told you?
I understand that Mr. Thompson did. Mr. Thompson was in the room with me and Peter when these events transpired.
And do you recall what he told you Mr. McFarlane's position was about that conversation?
Well, in the meeting with Peter Wallison, in Peter Wallison's office, I remember outlining in the firmest, courteous terms that I could formulate to Mr. Thompson that this was a very serious discrepancy and that it would obviously have to be ironed out before Congress was presented with the information that we previously had been given to understand was the fact. There was no argument from Paul on that. He fully agreed, and I urged him to get in touch immediately with North and explain to him that there's a serious cloud over the accuracy of the statement that he made. Get in touch with McFarlane, since McFarlane is allegedly the person who told the Secretary of State. And when I left the meeting, it was my understanding he would do that. I ultimately contacted him by the phone, and he said that he had done that.
And when he told you he had done that, what was the response he had received from Mr. McFarlane?
I don't think, my understanding is not that he talked with Mr. McFarlane. It is that he had talked with North, who in turn had talked with Mr. McFarlane.
At any rate,
But
this is about quadruple hearsay, but at any rate, what was the substance of what they came back with regarding the statement that Secretary Schultz knew it was hawks?
They're sticking by their understanding.
Now, did you speak to Judge Sofair later that day when you got back to the Department of Justice?
Yes, and I really don't remember whether it was prior to the Thompson telephone conversation or after, but I did certainly speak with him.
And did he inform you that Undersecretary Armacost was going to be joining Mr. Casey in his testimony before the House and Senate Intelligence Committees on November 21st?
He did.
And what did he tell you Mr. Armacost would say if Director Casey made the statement that no one in the U.S. government knew that they were hawks?
Well, we're taking things just slightly out of order. What happened was when I talked with Abe, I think I called him and I said, Abe, are you certain that this is the recollection? And he said, we have a note. We have notes, contemporaneous notes to that effect. And he also told me the word hawks is in the note. And so when I talked to Paul Thompson, I reiterated and reemphasized that now there is additional reason to accord credibility to the Secretary of State's understanding. But yes, he did also tell me that he was going to be present with Mr. Armacost, I think it was Armacost, somebody in any event, as counsel for the State Department, and that if the inaccurate information was displayed before Congress that he would be bound to insist that his client immediately state his contrary understanding.
And in other words, if Director Casey were to say no one in the U.S. government knew it was Hawks, what was Mr. Armacost going to say in his congressional testimony?
Well, I concluded that he was going to say that is not consistent with our information, although Mr. Sofair and I did not talk about the no one in the U.S. government formulation. However, we knew together what the disparity was.
Did Judge Sofair indicate whether or not he felt that he would have to leave government if indeed Director Casey made this statement?
He made a statement to the effect that essentially if the events that he described did in fact unfold, that he felt it almost certain that he would leave government.
Why?
I can only, he did not elongate on his purposes, but what I inferred was that he could not abide such an event. He obviously had a whole lot of confidence that indeed the Secretary of State's understanding of the facts was the correct one, and that individuals who probably knew otherwise were going to state an incorrect statement of the facts. And I concurred with him that there would be a lot of us who left government under such circumstances as that.
After you talked to Judge Sofair, did you notify the Attorney General of this discrepancy?
I did, but I have to tell you that I tried to assuage his concerns, that is, Judge Sofair's, along those lines, because it was my view that the event that he was concerned about would never happen, that the Attorney General would ensure that it never happened.
Did you call the Attorney General?
I did.
Where was he?
He was in West Point at a banquet of some kind and making a speech.
And when you did get a hold of him, did you tell him what Judge Sofair had told you?
I did, after a lot of effort to get a secure phone call with the Attorney General. I outlined the events that we have just gone through.
And what was the Attorney General's reaction?
He agreed entirely with my urgent suggestion that he return as soon as it was possible and try to take responsibility for getting his arms around this Iranian initiative and ironing out any and all discrepancies and getting to the bottom of it.
Did the Attorney General give you any instructions?
Yes, he did. He said he would return, he would cancel his trip to Harvard the following day and return to the office early in the morning, that I should be in touch with Poindexter, advise him not to make the statement that was then under cloud of uncertainty, and that I should also make known to Director Casey somehow, perhaps call Dave Doherty, all of which I did.
Did you speak to Admiral Poindexter that night?
I did.
This would have been Thursday night, is that correct? The 20th?
Yes, it was Thursday night, quite late by that time, I believe.
And did you describe to Admiral Poindexter what Judge Sofair had told you about the serious discrepancy in the proposed Casey testimony?
I don't think that I did, but I had described it to Paul Thompson. And Paul Thompson, I understood, would be in touch with Poindexter and make clear that Poindexter should not say what it is that he had been prepared to say. So I did not, I just, it is my recollection anyway that I just outlined that there was a discrepancy.
By the way, in preparing for Mr. Casey's testimony, it's true, is it not, that Admiral Poindexter was also going to brief the members of the intelligence committees at the same time. Is that correct?
Oh, yes, That's exactly right.
And during the drafting meeting, was Admiral Poindexter preparing an outline of his briefing that would correspond with Mr. Casey's testimony?
That was my understanding.
Now, when you spoke to Admiral Poindexter late on Thursday night, did he give you any more facts about the Hawk transaction, or did he explain away the discrepancy to you?
Oh, no. No, I continued to understand that he had no personal knowledge to bring to this question, just that if there's a discrepancy, fine. Of course, I will refrain from saying whatever it is we're not confident is correct.
Ms. Naughton, this might be a good place to just take a short break. We'll take a brief recess for about 5 to 10 minutes.
Thank you, Senator Rupp.
Jack Lemon's still over there? Not photographic. He was the managing editor. Came from the Washington Post.
Oh, but I've only been there 3 weeks.
You've only been there 3 weeks and they send you here? What are you, a summer intern or something? 3 weeks they send him over here. They don't have any confidence in their staff. What's a hire a hero just for this, right?
All the way down to Baltimore.
It's in all the heroes here. His hero calls. All heroes.
Carl Clark. Carl Clark.
Who?
It's my new name. C-A-R-L, as in
Carl
Clark.
Clark. Oh, Clark. I thought he was saying quick, page.
Yes, yes, we did.
And I direct your attention to CJC Exhibit number 13, which you identified in your deposition as your working draft of the draft chronology, as you had marked OLC 2. And I direct your attention to page 6 of Exhibit 13, which describes the November hawk shipment.
Yes.
And it describes in part, in the middle of the second full paragraph regarding that shipment and the state of U.S. knowledge at that time, that we, the U.S. government, we were assured at the time that the Israelis were going to try oil drilling parts as an incentive, since we had expressed so much displeasure over the earlier tow shipment. Mr. Cooper, did Colonel North or Admiral Poindexter refer to oil drilling equipment during your meeting on the 20th of November?
I do not recall that,
All
but
right.
it's possible that they did, but I don't recall it.
To your knowledge, was this version, that is, now it's oil drilling equipment, was this the first time this version came to your attention?
In this chronology,
Yes.
well, it's the first time I can state with confidence it came to my attention, but it's possible that I'd heard oil drilling before that. Oil drilling equipment was something that came repeatedly to my attention in this thing.
Are the notes on Exhibit 13, page 6, your notes?
Yes, yes they are.
And were they taken in the course of your study of this document over several days?
Yes, they were.
Now, turning your attention to Friday morning, November 21st, 1986, did you go to the CIA early that morning?
Yes,
And did you meet with Director Casey?
I did.
And did you explain to him that there was a discrepancy in the statement that no one in the U.S. government knew they were hawks?
I did.
And what was Casey's reaction?
Well, it was not. It was one that didn't resist that proposition in the least. In fact, the sentence that I was most concerned about was one that Mr. Doherty, with whom I spoke in the neighborhood of 11 or 12 the previous night, had already focused on and had already, according to him, deleted. So there was no argument about it. I did not. It was perfectly fine with everybody that we delete that sentence if there was a cloud hanging over its accuracy.
Did Mr. Doherty explain to you at any time why they deleted that statement?
Yes, he did. And I must say that within the last 2 or 3 days, my memory on this has been refreshed by Mr. Doherty, but indeed I do recall it very, very well now. He related to me that in their own efforts to try to piece together the CIA's activities, that is, the General Counsel's Office efforts, they had been in touch with Stanley Sporkin, and that Judge Sporkin had advised them that he knew that there were arms, perhaps not hawks, but he knew that there were arms on that plane within a few days at the maximum of its of the event. So they knew immediately that the statement relating U.S. knowledge to January couldn't be accurate, and as I understood it, out of caution, they just struck the whole sentence, and that, of course, satisfied me.
Okay, so the change in the CIA's testimony, the genesis of which was Judge Sporkin's comment, correct? And
That's
did not
my
emanate
understanding.
from the DCI.
It did not emanate from the DCI. No, it emanated from Judge Sporkin. It didn't emanate from the same source, State Department, that I had reasons to doubt it.
Now, directing your attention to Exhibit CJC number 7, we have here an excerpt of Director Casey's testimony before the House Permanent Select Committee on Intelligence on November 21st of 1985. And if you'll bear with me, we will read the relevant portions of what exactly Director Casey told the Congress on that day. I'm reading from Exhibit 7 towards the bottom of the page. The CIA's involvement began in late November of 1985 when the agency was there asked to recommend a reliable airline that could transport bulky cargo to an unspecified location in the Middle East. This requirement specified that the carrier had to be reliable and able to move rapidly, quickly. A proprietary of ours, which regularly took on commercial ventures, was designated. When the plane got to Tel Aviv, the crew was informed that the cargo was spare parts for oil fields and that it was to go to Tabriz. Our blank back in Washington decided that in order to protect the plane, our blank should be asked to get flight clearances into Iran, and this was done. On November 25, 1985, the plane dropped the cargo in Tehran. To the best of our knowledge, neither the Israelis nor the Iranians knew that they were dealing with a CIA proprietary and believed it to be just another commercial charter airliner. The airliner was paid the normal commercial rate, which amounted to approximately $127,000. And then later, on page 45 of the transcript, in response to Mr. Bielenson's question, has there been beyond that, through Israel, for example, any major transfers of arms to Iran? Mr. Casey's response, well, we suspect there have been, and we do know that the Israelis provided some weapons to them before we got involved. But that is in a very complicated way. Some of that has been aborted. Some of that has been adjusted so that we take responsibility for the 2008 tows plus the Hawk missile parts. Mr. Bielenson, have the Israelis made any shipments that require notification or require permission from the U.S. before transferring to Iran? Do you know? Mr. Casey, there was one shipment that was made in the summer of '85, which we heard about later, that for a time, in order to keep this thing going, we waived or didn't take action on the failure of the Israelis to get the necessary permission. And we have since, I believe, straightened it out. And that is, I believe, a reference to the August tow shipment. Mr. Cooper, in that testimony, do you see anywhere where Mr. Casey told the Congress that indeed there was a November 1985 shipment of Hawk missiles?
No, I do not.
Now, after you left the CIA on the morning of November 21st, 1986, did you go back to the Department of Justice?
Yes, I did.
And did you meet with the Attorney General?
I'm sure that I did, yes.
And did he indicate, did you discuss with him the idea of him going to the President to get authority to gather facts in order to straighten this out?
Absolutely. We had discussed it as well on the secure phone call Thursday evening.
And did indeed the Attorney General meet with the President that morning?
He did.
Do you know whether or not he met with anyone else that morning at the White House?
It's my understanding that Mr. Reagan was with the President during the meeting.
Anyone else?
That's all that I had when I did this chronology or have now recollection of.
And what did the Attorney General tell you that the President had told him regarding the situation?
What did the President tell him? I'm sorry?
What did the Attorney General tell you that the President had said regarding the situation?
Just that absolutely he agreed with the Attorney General that that the Attorney General should undertake to gather the facts and straighten out any wrinkles in our state of knowledge about this initiative and to proceed forthwith.
Was it ever discussed between you and the Attorney General or anyone at the Department of Justice that you should just perhaps ask the President if he authorized these 1985 shipments?
It certainly wasn't discussed at that point, no. But ultimately, obviously, at the conclusion of our effort, the Attorney General's effort, to gather the facts, the Attorney General fully intended to ask the President the state of his knowledge of the facts on this.
So that was to be the last step?
I think that the Attorney General went there for permission to do this, and with a reason for wanting to undertake this task, one of, well, it's obvious. And I don't think that he planned, we didn't discuss it, but I certainly don't think that he planned to begin his effort to find the facts by interviewing the President on this.
Do you know whether or not the Attorney General asked the President if he knew they were hawks on the shipment?
I do not. It's entirely possible that he did, but I have no recollection of that fact.
Were you given a deadline for reporting back to the President?
Yes, the President wanted the Attorney General, if at all possible, to report back to him by Monday, the following Monday, because a NSPG meeting had been scheduled in which everybody could discuss this whole matter. That is, everybody on the NSPG could discuss the Iranian initiative. And it was my understanding it was going to, the President anticipated it would be a stern session.
Now, later that day, on the 21st of November, on Friday, did you interview Robert McFarlane?
Yes, certainly.
And who was present when he was interviewed?
Me and the Attorney General.
And I direct your attention, if you need it, to exhibits number 14 and 15, which are your uncompleted report of the interview and your notes of the interview. Did Mr. McFarlane say that he knew about the Hawk shipment prior to November 25th, 1985?
No, he did not.
What did he say about the Hawk shipment?
Well, my recollection does not supplement very much the notes that I took at the time, but or at all, frankly. But he indicated he did not know that there were Hawks on the plane until substantially after the November transfer, and I think he represented that he didn't know until May, when he came back into the government to complete a diplomatic mission on behalf of the President.
So he disclaimed prior knowledge of the Hawk shipment. Is that correct?
Yes.
Did Mr. McFarlane mention to you the diversion of the Iranian arms monies to the Contras?
No.
Did he mention with you any plans to alter or destroy documents at the National Security Council?
Most certainly not.
Did he and the Attorney General discuss at that time the possibility of oral findings?
No. Not in my presence.
After the conclusion of the interview and you left the room, did Mr. McFarlane stay back and talk to the Attorney General briefly?
He did. We left together, but he then wheeled and basically went back into the office with the Attorney General.
And they spoke alone together?
Yes, very briefly.
Did the Attorney General tell you later what Mr. McFarlane had said to him?
He did.
What did he tell you?
I have only a general recollection to the effect that Mr. McFarlane said, you know, I'm trying and I'm hopeful that I can keep the President's interests uppermost in this. I'm trying to protect the President, something to that effect.
Did you discuss Mr. McFarlane's interview with the Attorney General after he left? After Mr. McFarlane left?
Briefly.
And what did you conclude or think, or what was your impression about his credibility during the interview?
You know, I would like to back up just a tad, because I haven't read the Tower report, but the one snippet that I have read basically is the place where McFarlane describes that little meeting without me, and it sounds familiar to me in terms of the Attorney General's report, except I have no recollection of the Attorney General saying anything about the President's legal position. I'm sorry, now what was your other question?
My other question, I'll have to go back. Oh, yes. What was the impression that you had after the interview of Mr. McFarlane's credibility during the interview?
Well, let me preface this by saying I feel awkward characterizing my thoughts on that because I've had that conversation with Mr. McFarlane and no other. So I have no basis for making any judgments other than the judgments that I would accord him as a matter of presumption. But I have to also say that I did not leave the interview, nor did I take it during the interview that Mr. McFarlane was being entirely straightforward and entirely forthcoming.
Were arrangements made for a team from the Department of Justice to go over and review NSC documents?
Yes.
Do you know who made those arrangements?
Primarily, my assistant, Mr. McGinnis, although I was involved that evening as well on the phone.
NSC, to review NSC documents.
Oh, I beg your pardon. I did have another agency in mind. Yes, arrangements were made, certainly.
Did the Attorney General make those arrangements?
Yes.
Did he do that with Admiral Poindexter?
That's my understanding.
Were you present when the Attorney General called Admiral Poindexter to arrange to have NSC documents made available?
It's not my recollection that I was, but it's possible that I was.
Now, the next day, Saturday, November 22nd, did you and the Attorney General interview Secretary of State Schultz and his aide, Charles Hill?
We did.
Was that at the State Department?
It was.
And what did Secretary Schultz tell you regarding the November 1985 shipment?
He related an account that was quite closely similar to what I had been given to believe he would relate, that indeed there had been a conversation. He thought it was in person, in which, while they were in Geneva at the summit, Mr. McFarlane came to him and described to him a event in the offing that would involve the transfer of a quantity of Hawk missiles, and that it was contemplated that the American hostages would be released in consequence of that.
So Secretary of State Schultz was informed in advance of the Hawk shipment?
Well, that was his understanding, and he said the conversation took place on the 18th, so that seemed to be accurate.
Did Secretary of State Schultz indicate to you that this conversation was documented in any way?
He did. It may well have been Mr. Hill who indicated that, but in any event, Mr. Hill had notes. It was Mr. Hill who had the notes of the conversation. I had expected when we arrived that it was actually the Secretary of State himself who had taken notes, but that was not the case. Hill had taken the notes as the Secretary of State related the conversation to him.
And did you ultimately retrieve a copy of Mr. Hill's notes on this subject?
Yes, a couple of days later.
And for the record, that is included as CJC Exhibit Number 17. What was your impression, Mr. Cooper, regarding the extent of Secretary Schultz's knowledge regarding the Iran arms sales?
That it was a little more extensive than I had been prepared for, but that he was not an integral part of the implementation of that policy.
Now, at some point mid-morning on Saturday, did a Department of Justice team go over to review documents at the National Security Council?
Yes.
And who was on that team?
Mr. Reynolds, Brad Reynolds, and John Richardson.
Could you tell us their titles?
Yes, Brad Reynolds is the Assistant Attorney General for the Civil Rights Division. Or he was at the time, he still is. And Mr. Richardson, I think his title is Chief of Staff to the Attorney General. It may well be that at that time he was titled only Special Assistant. I don't know.
And after they had reviewed documents for a while, did you and the Attorney General meet them for lunch?
Yes.
Do you recall approximately when this occurred?
Well, I recall only what my chronology relates, and let's see. It suggests that the lunch took place around 12:30 to 1:45.
And when the lunch began, did you begin to discuss what you had learned in your interview with Secretary Schultz?
I'm sure that we did go through that with John and with Brad.
And later in the conversation, did Mr. Reynolds mention to you a memo that he had found in Colonel North's office?
Yes, it was not too far into the conversation, and he did mention a memo that he'd found.
What did he tell you about the memo?
Only that there's a memo that he had come across and obviously resolved to get a copy of, that suggested the possibility that some of the monies that had been generated and paid by the Iranians for the arms, a particular arms transaction, had been provided to the Contras, to the Nicaraguan resistance or something.
When Mr. Reynolds revealed this, what was the reaction of the other people at lunch?
Well, it was one of great surprise.
What was the Attorney General's reaction to that news that the funds had been diverted to the, or the possibility that the funds had been diverted to the Contras?
My recollection is that the Attorney General said something analogous to, "Oh darn," but it perhaps more strenuous than that.
Did Mr. Reynolds say whether or not he had found a cover memorandum to that, shall we call it the diversion memo?
No, he didn't.
Was there a discussion of whether there was a cover memo?
There was not at lunch.
Did
To
you-
my recollection, no.
Did you discuss who may have received the memo?
Oh, yes. Yes, we did. We obviously had in mind what this memo meant, whether it reflected an event that actually transpired. Keep in mind that the memo discusses this as a planned event, and who knew about it if indeed it transpired.
Did you also discuss the impact the memo would have if released?
I do not recall any discussion about the impact that the memo would have. I think in fact, I don't recall articulation at the table regarding the impact that the information, if in fact it was proved true, would have, but I don't think there was any doubt in anybody's mind on that.
Did you and the Attorney General discuss such impact later on the way back to the Department of Justice?
I can recall the Attorney General and I returning to the department in his car and discussing this new potential information. We both certainly, I can recall him expressing worry about it and concern. That's about it.
Could you be more specific in terms of why he was worried?
Oh, well, yes, I think we both recognized two things about it. It had legal significance, though its legal significance wasn't obvious to me, and I'm not sure it's still entirely clear to me, but it had political significance of a very large nature.
Did you discuss at that time the possibility of bringing the FBI into it now?
Oh, no, no.
Did you discuss whether or not to secure the documents at NSC?
No.
Did you know
Not that I recall. I mean, I don't recall any discussion along those lines from beginning to the end of this.
Did you know that Colonel North was present while Mr. Reynolds, Mr. Richardson were reviewing his documents?
Yes, during the lunch, both John and Brad had remarked that Colonel North was in an area proximate to them such that they could actually overhear him having telephone calls.
Right. And when they left for lunch, they left him in his office, is that correct?
That I don't recall. It may well be correct, but I don't recall discussion of that, and I don't know the answer to it.
Did either Mr. Reynolds or Mr. Richardson tell you that Oliver North had told them that he had retained an attorney?
I do recall discussion to that effect, and I have general recollection of that, yes.
Do you know whether or not the Attorney General spoke to Oliver North on Saturday afternoon?
No, I do not know that he did. I do not know that. In fact, it's my understanding, or I would doubt that he did, but I have no, he certainly didn't do it ever in my presence.
Well, did he
But
call-
let me back up, if I may, Ms. Naughton, because I think maybe, and I know this committee has time requirements, but it's important to understand the flavor, at least that I received, for the alleged statement that Colonel North had retained a lawyer. As I understand it, and as it impressed me, Colonel North at that time was coming in and out of the room where this document review was taking place, and he was attempting to engage Mr. Reynolds and Mr. Richardson in conversation, in chit-chat, light conversation, as I understand it, and mentioned in passing, perhaps even in joking, because he was joking around, as I understand it, during that time, that he had retained a lawyer, or at least that's my general recollection of that event.
Did the Attorney General speak to Oliver North that afternoon to arrange a time that he could interview him?
I don't, on Saturday afternoon?
Yes.
I don't know whether he did, but I suspect that he did. I mean, it's my general understanding that he did, yes, on Saturday.
Did you understand what Oliver North's objection was to the original time scheduled for an interview?
It is my general recollection that we had preferred or would have preferred to interview Colonel North Saturday afternoon, and that was planned, or at least that is my general recollection, but that for reasons that I have no recollection of, Colonel North could not accommodate us at that time, and in fact it was put over till Sunday. And in fact, on Sunday, I recall, it was delayed for some short period of time, like an hour, perhaps 2 hours.
And was that because he requested that he be given the time to go to church and spend some time with his family on Sunday morning?
And have lunch at McDonald's. That stays in my mind, yes.
Were you aware at some point that the Attorney General had gone to visit Mr. Casey at his home on Saturday evening?
Oh, yes, I certainly became aware. I don't know, I have no recall as to whether I was aware of it prior to the time he was going or as he was planning to go or even immediately after he had met with Casey, but yes, I do know he did that.
And did he tell you later what they had discussed?
Yes.
What did he tell you they discussed?
I have a general recollection of a discussion in which the Attorney General related the so-called Furmark matter, in which apparently Mr. Furmark represented individuals who were investors or financiers, and they were out some substantial sum of money. $10 million seems to occur to me, $10 million, and that they were complaining to Casey that they were out this money.
And Saturday evening, did you go to the CIA to conduct interviews of people involved in the transaction?
I did.
And did you also go to the CIA the morning of November 23rd, Sunday morning?
Yes, I did.
Did you meet with Director Casey briefly?
Very briefly, yes.
For what purpose?
To discuss whether a particular word, the name of a particular person in Iran, would be shared with me by Mr. Charles Allen, who I was then interviewing, and the upshot of it was that at that time it would not be shared with me. There was no sufficient and good reason for it.
Did Mr. Casey indicate to you he had called the Attorney General to see whether or not you should be given that name?
Yes, he had asked the Attorney General if it was really absolutely necessary, and the Attorney General didn't see why it was.
Now, later that afternoon on Sunday, did you indeed join the Attorney General, Mr. Richardson and Mr. Reynolds, in interviewing Oliver North?
Yes, I did.
Did that take place in the Attorney General's office?
Yes,
And did Colonel North come alone?
he did.
Did anyone ask him if he had an attorney?
No,
Did he say he had an attorney?
I do not recall there having been mention of any kind of his attorney or lawyers.
What did Oliver North tell you regarding the November 1985 Hawk shipment?
Well, we discussed we discussed it at some length, and he told us essentially that he had received a call, as I recall it now, from Mr. McFarlane, and was told to get in touch with Mr. Rabin, who was then in New York, because they were having difficulties with a shipment of some kind. And apparently they were, as I understood, they were having customs problems or landing rights problems in a particular country. My recollection is that, and again, I would defer to the notes that were taken copiously by John Richardson at this meeting, but my recollection is that he was told that Mr. Rabin sent an assistant of his down to see Mr. North and explain their difficulties, and that North was told that it was oil drilling parts that they were trying to move to assist in an effort that was consistent with our interests, the United States interests.
Did Colonel North tell you he had doubts about the story that it was oil drilling equipment?
He did. He indicated that he thought it probably wasn't really oil drilling equipments, but he also made the point that he thought he could pass a lie detector test to the effect that it was oil drilling equipment.
From whom did he claim he first learned that there were hawks on board that plane?
He said that jokingly, by the way. I'm sorry.
From whom did he first learn that there were actually hawks aboard the plane?
He identified, I think, two people who had told him they were hawks. Mr. Secord, who he identified as somebody whom he had enlisted to assist in this effort in November, and Mr. Neer from Israel, as having at some point advised him, but Secord apparently was the first person to advise him, and advised him in the immediate aftermath of the event.
Was Colonel North eventually questioned about the Contra diversion memo?
Yes, he was.
And who presented the memo to him?
The Attorney General. The Attorney General was the dominant interviewer by far during the time that he was there.
Can you tell us how he was presented the memo?
I can only tell you what my recollection of it is, and it's hazy, but it is my recollection that the Attorney General handed him the memorandum and began asking him some questions that had nothing to do with the diversion, questions that do not now stick in my mind, I do not recall having seen any during this period. I don't recall having seen any register on Mr. North's face that this memo had particular significance, but certainly it did when the Attorney General asked him about the Contra diversion.
Do you recall, as specifically as you can, what the Attorney General asked him?
I think the Attorney General was asking about finances that were involved in this whole Iran initiative, and he asked him about the monies that went to the Nicaraguan resistance.
What was Oliver North's reaction when the Attorney General asked him if any of these funds went to the Nicaraguan resistance?
He appeared to be visibly surprised and not expecting to hear that question.
Can you describe to us what his reaction was?
Well, I think my best recollection is that he paused for a moment, silent, before he responded, and then he responded that in a way that was responsive, and certainly did not. He acknowledged the transfer to the Contras, but it was just obvious surprise on his face.
Did he ask if there was a cover memo?
Yes, he did. I have a general recollection to that effect. Whether it was immediately, I don't recall, but he did ask that question.
And did the Attorney General ask Oliver North, should we have found one?
The Attorney General asked something to the effect, well, first of all, I think Mr. Reynolds said, no, there was no cover memo, and somebody, and I suspect it was the Attorney General, I think that it was, said, essentially, why do you ask that question? Is there a cover memo with this? Should we have found one? And North's response, again, to the best of my recollection, was, no, I just wondered, or something to that effect.
Did anyone in the room ask him if there indeed was or had been a cover memo?
I don't recall. It's entirely possible, and there was some conversation about a cover memo, but at some point we became, or at least I became satisfied that it was North's view that there was no cover memo. I also have a vague recollection that he, and I do recall that this is confirmed by the notes, that he offered to re-examine his files and the documents in the search for such a cover memo if there was one.
Did you ask him to do that?
I don't think we asked him to do it, but I don't think we told him not to do it or anything like that. He made the suggestion that I don't recall a reaction, frankly.
What steps did you take to find out if indeed there was a cover memo?
If there was a cover memo to the thing, I do not know all of the steps that were taken, but or at least I'm not sure that I know all of them. I do know that in addition to reviewing carefully again the documents, well, I guess I'm not sure whether the documents that we had received from NSC were reviewed again or not. But I do know that when we went to the White House on Tuesday morning, John Richardson was required and dispatched to do one last check on that question, actually not on the question whether it was a cover memo, but on the question whether there was any document anywhere in the NSC files that would suggest an understanding inconsistent or provide any inference inconsistent with what we then believed, which was that the only people in the United States government who knew about any Contra diversion were Poindexter, North, and McFarlane, who was then no longer in the United States government, and that was a view that was corroborated by Mr. Poindexter and all of the other people who were quizzed on it. So, but there was an effort there to make sure there was no document inconsistent with the view that we had come to, that in fact they were the only three who knew anything about it.
To whom did Mr. North say the memo was addressed?
I don't recall him discussing who it was addressed to specifically, although I do recall him saying it was for Poindexter, or that it had been given to Poindexter, or something to that effect, but that he did not think it had gone any further.
Did Colonel North say that he believed anyone else had seen it?
No. In fact, my recollection is to the contrary of that.
Did he say whether or not the President had seen it to his knowledge?
Yes. He did not think that the memo had gone to the President.
Did you ask him who in the government knew of the diversion?
Yes, we did.
And who did he say knew of the diversion?
He identified Mr. Poindexter, Mr. McFarlane, and himself in the government.
Okay. Did he also identify Mr. Secord?
Yes, he identified Secord, and obviously identified Neer, because it was his account that Mr. Neer had conceived of the entire arrangement, as I recall. He identified, I guess, a couple of other people as well who might know about this.
Do you recall who they were?
Yes, Mr. Calero,
Yes.
he thought, would know about it. He suggested Secord was the most knowledgeable, however, because I do recall that he did not know how much money might have gone to the Contras through that arrangement, but that Secord would know. And he could ask him.
Did he indicate to you that the money had gone straight from the Israelis to 3 Contra bank accounts?
I think that is what he indicated, yes.
And did he mention to you the name Lake Resources, or CSF?
I do not recall that name having been mentioned on that occasion. I guess it is possible it did not rate a reference in the notes, that as I recall, and it certainly didn't make an impression on my mind.
When you said that Oliver North stated that it was Mr. Neer's idea to divert the monies to the Contras, did he give you a reason as to why Mr. Neer would want the money diverted to the Contras?
Well, it was my understanding that Mr. Neer was portrayed as having been eager to assist the United States in its effort, and Israel, you know, as a staunch ally, was eager to assist the President in the United States in his effort to assist the Contras. And Neer approached North about it, but I also got the impression that they had discussed this problem previous to the idea.
Did Colonel North mention that he had altered documents?
No, he didn't.
Did he mention to you that he had shred documents?
Of course he did not.
Did he mention to you that he was involved in setting up a private Contra resupply operation?
No, there was no conversation about that, except to the extent that he made reference when he described the 3 accounts that he got from Calero, or that he gave to Calero, and he suggested that you know, this is how the Contras are helped all the time. But he didn't put it in the context of any network or any operation of his.
How did you leave it with Colonel North? That is, once the interview had ceased, was he told you'd get back to him, or was he told to start packing, or what happened?
No, it just ended. I don't recall any more arrangements having been made about talking to him further or anything like that. It just ended with, you know, without anything particular that would make an impression on one's memory. Except towards the very end of the meeting, he did make a reference to the whole revelation, really, about the Contra diversion, and described it as the only thing black about all of this. And I recall him expressing the hope that it was not among the things that would have to be made known publicly.
Was he given any assurances, any which way, whether or not this would be made public?
There was nobody responded to his comment that I can recall in any way.
After he left, was there a discussion as to whether or not this information would be made public?
No, well, there was never any discussion about whether it would be made public. There was a lot of discussion about when and what might happen when it was made public. The latter of which some of the speculations proved entirely accurate. But there was never any discussion about whether it would be made public.
Did you fear that the information would leak?
Yes, yes, we did.
And you made the decision at some point that the President had to announce the diversion, is that correct?
That decision was made on the basis of two reasons, or at least the fact that it would leak was only related to when it would be released, not whether it would be released. I think I can remember a lot of discussion about the fact that if this information is made public by anyone other than the President, that it would not be possible to convince anybody that the President had every intention of making it public. And so it was of utmost importance that these facts be revealed to the American people by the President.
Did you speak to Judge Sofair later that night on Sunday? Mr. Cooper, it's not reflected in your chronology, but Judge Sofair has testified in deposition that you spoke Sunday evening.
It's, you know, then his memory is superior to mine on that question.
Do you recall him telling you he was concerned about what appeared to be an extraordinary profit in the arms sale, and he was concerned that money had been diverted to the Contras because of the involvement of Southern Air Transport in both the Iran arms sales and the Contra resupply operation?
Okay, this is helping. This is helping. Now, whether or not that happened Sunday, I don't know. But I do recall a conversation with Abe to the effect that Southern Air Transport figures into this, which I don't recall having known prior to that. Certainly, if it did, it's not one of the. If that had been known to me, it's not one of the facts that had registered any importance with me. But Southern Air Transport was involved, and because of Southern Air Transport's relationship to Nicaragua, I think he even mentioned Hassenfuss in that conversation. He was very, very concerned.
So here you had someone from the State Department who apparently had not seen Oliver North's diversion memo, had not participated in the interview of Oliver North, who was calling you to say he thought things were fishy and that money may have gone to the Contras, given all the factors that he was aware of.
Yes, I mean, if this conversation took, the only thing I have any entire lack of memory on is the precise timing of that conversation. And I really don't remember him making clear the notion that the Contras might have gotten some of the excess money, but he certainly was aware that there was a lot of excess money in this thing.
Now, on Monday morning, the 24th, did you go to the State Department and retrieve Mr. Hill's note?
Yes.
And did Mr. McGinnis go to the CIA and do some more interviews?
That, I'm drawing a blank on that. I guess it's possible that he did, but I don't recall it, and I did not record it in my chronology, and he reviewed the chronology and improved it in some respects. So I don't know. I don't think so.
Well, did Mr. did Mr. McGinnis tell you at some point that there was a rumor at the CIA?
Oh, yes. Yes,
that,
he did do that.
that part of the Iran sales monies had been diverted to the Contras?
He did do that. I don't think he went out there, but we were in quite constant touch with Mr. Doherty's office. Mr. Jameson, George Jameson, and Mr. Doherty were working very, very closely and cooperatively with our effort.
By the way, to pick up something on Mr. Jameson, taking you back to Friday morning when you met with Mr. Casey regarding his testimony, after you met with Director Casey and he was on his way to the Hill, did Mr. Jameson whisper something to you at the close of that meeting?
He did pull me, he did approach me and make known to me that they had just received some indication, some suggestion that the pilot of the plane on November had known there was some kind of military equipment on that plane.
All right.
He
And that was,
did not elaborate.
he told you that on Friday morning before Mr. Casey went to the Hill to testify?
That's correct. That's my recollection.
Now, when Mr. McGinnis told you that there was a rumor at the CIA that the money had been diverted to the Contras, did you bring this information to the attention of the Attorney General?
I feel certain that I did, but I don't recall having done so.
Would it have been sometime in the frame of this weekend inquiry?
Oh, I should think it was. However, at that stage it was, it was confirmatory, not news. So if I did or when I did, it just escapes me.
Did the Attorney General go to the White House that Monday morning, November 24th?
Yes, he did.
For what purpose?
To report to the President as directed, and he told the President that he needed a little more time.
Did he tell him what he had discovered about the diversion?
Yes, he did, as I understand it.
What did he tell you the President's reaction was?
One of surprise. I don't recall him elongating on the President's reaction other than to say it was one of complete surprise and that the President was entirely unawares.
Was anyone else present for this meeting between the Attorney General and the President?
My understanding was that Mr. Regan was present at the time, yes.
Now, had the Attorney General spoken to others at the White House to ask them about whether they knew about the Contra diversion?
Yes, he did during that time frame on Monday.
And did he speak to these people alone or in the company with anyone from the Department of Justice?
I think he spoke to them all alone.
With whom did he speak?
He initially, well, I guess I can't tell you the order in which he spoke with these people, but he did speak with Mr. McFarlane, and it is my recollection that Mr. McFarlane was leaving, in fact, as I was returning from the State Department, was leaving the Justice Department because he did talk to him in the Justice Department. And he spoke with Mr. Poindexter, he spoke with the Vice President, he spoke with the President, he spoke with Mr. Regan.
And of those people, whom did he identify as having knowledge of the diversion of the funds to the Contras?
Mr. McFarlane and Mr. Poindexter.
And what did Mr. Poindexter say about his knowledge of that issue?
Well, I guess I might say that knowledge might be putting it a little high, because McFarlane reported to the Attorney General that he hadn't really ever been informed, but he had received hints, indications that he just didn't want to inquire into, and that he could not, essentially, he could not tell the Attorney General that he's taken unaware on this. But my understanding is he maintained he had not been told.
He had not been told outright.
Yes, he had not been informed.
At any point?
That was my understanding of his response.
And what about Admiral Poindexter? What did he say about the Contra diversion?
I'm sorry, I thought we were talking about Admiral Poindexter.
You mentioned Mr. McFarlane. We were, and you went to Mr. McFarlane.
I beg your pardon. I meant Poindexter.
All right.
The
Poindexter
event I just
had,
described pertains to Poindexter. Mr. McFarlane,
so Poindexter had hints, but he was never told outright.
that's right. He
And Mr.
couldn't deny that
McFarlane?
he knew, however.
And Mr. McFarlane?
Mr. McFarlane acknowledged that he was told outright, and that North had made him aware of that fact in May, I guess, when McFarlane came back into the government to execute the diplomatic mission to Tehran.
Do you know whether or not the Attorney General took any notes of these meetings with these gentlemen?
I do not understand that he took notes. I understand that he did not take notes.
Do you know any particular reason why he did not take notes?
I would imagine that the responses that the question he was going to ask and the response he was going to get were not going to be difficult to remember.
Later that afternoon, at approximately 2 o'clock, did you and Mr. Reynolds meet with Tom Green, an attorney?
Yes, we did.
I won't go into that. Senate counsel intends on questioning you about that meeting, Mr. Cooper. Then again, on November 25th, in the morning, did you go to the White House to draft the President's statement regarding the Iran arms sale and the Contra diversion?
I didn't really go there for that purpose, but that is certainly something I participated in.
All right. And with whom did you participate with in that drafting session?
Mr. Wallison and Mr. Thomas, Dennis Thomas.
Do you know, Mr. Cooper, when it was decided that Admiral Poindexter and Oliver North would be asked to leave the NSC?
Well, I know that when I arrived at the Department of Justice very early on Tuesday morning, after receiving a call at my home from the Attorney General to be there, that the decision had already been made. Poindexter had, as I understand it, he had even told the Attorney General the previous day, when confronted with his Contra diversion, that he understood this meant he had to resign. He fully understood that.
Do you know who actually made the decision that Admiral Poindexter and North should resign?
I suspect that, well, first, Admiral Poindexter apparently made the decision in recognition of what were the indisputable facts. I don't think anybody considered any other course. I'd be surprised if they did anyway.
And the Attorney General announced these facts in a press conference sometime noontime of Tuesday morning, the
Yes,
25th. Is that correct?
He did.
And sometime after that, did he task Deputy Attorney General Arnold Burns with securing the documents at the White House?
Sometime after that he did, yes. Not very long after that. I think immediately after he returned to the Justice Department.
So Tuesday afternoon, was that the first time that anyone from the Department of Justice, to your knowledge, had taken steps to secure the documents at the NSC?
Yes, it was, to my knowledge.
And did Arnold Burns do that immediately?
My recollection is that he did not. There was a meeting subsequent to the one wherein the Attorney General tasked Him, by the way, Mr. Burns is the Deputy Attorney General, and he is the typical point of contact with White House counsel, that is when Office of Legal Counsel is not. And so this was entirely in keeping with normal processes that he would be asked to do that. Later on in the day, I think it was the same day, I'm virtually certain of that, we had another meeting at which the Attorney General asked if that had been done, and Mr. Burns had confessed and felt very bad about the fact that it hadn't been done, but he had misunderstood the Attorney General's directive. He did not understand that he was supposed to do that immediately.
So do you know when that was finally done?
Well, I understood Mr. Burns to be exiting the office then and there to go and to make that known to Mr. Wallison.
Right. Would that have been Tuesday evening?
That is my best and confident recollection.
When was the criminal division of the Department of Justice first brought into this matter?
I think that the only thing I have any specific recollection of is when I met with people from criminal. On Monday night, John McGinnis and John had been during the course of that day, were examining the legal implications of the Contra diversion, particularly insofar as any criminal laws might be concerned. Tuesday, the following day, I outlined to the Attorney General that there were some criminal implications that couldn't be discounted, in my opinion, and the Attorney General actually I don't recall his reaction at that point, but in any event, the Attorney General had instructed Mr. Weld to get with me and for me to outline everything, that I had come to learn, so that Mr. Weld could bring his expertise, and as well as he brought with him Mr. Richards, who is an expert in these areas as well, and we discussed this at length Tuesday.
Mr. Weld, for the record, is the Assistant Attorney General for the Criminal Division. Is that correct?
That's right, and Mr. Richards is one of his deputies.
Did you attend a meeting the next day on November 26th, which included many Criminal Division professionals as well as some FBI agents?
This is on Wednesday?
Yes.
Yes, I did.
And did the Attorney General at that meeting designate Mr. Weld and you as the leaders of the investigation?
He did.
All right. Did that cause any consternation with the FBI?
It was my impression, vague impression, that it did, yes.
Could you describe that? What gave you that impression, and what do you suppose their concerns were?
I would be very reluctant to try to psychoanalyze the individuals in the room, but let me give you some flavor for the moment. The Attorney General and I, as well as others, had discussed how this matter should proceed. And of course, it should proceed immediately as a criminal matter, criminal investigation, using the FBI immediately. But we also recognize that in addition to the criminal implications, on which we were at that point, and in many ways still are, very vague and uncertain, in addition to those concerns, we had civil law concerns. In fact, all of the statutes that we had identified which potentially could have been directly violated, their substantive prohibitions, were civil statutes. So it was important that the information, it seemed to us, that was derived from the continuation of the criminal investigation be provided to me, the person who was responsible for examining civil legal implications. Hence, the Attorney General suggested that I would be a part of the investigative team. But I do recall an apparent unease about that by some of the people in the room. It's never been articulated to me if that was the fact, but the sense I got was such that I withdrew completely. I never did press the matter again, and I don't recall ever having attended the meetings and what have you that were then that then ensued by the investigative team, and not long thereafter the curtain fell on the department as a whole because NIC was requested, and at that time it is traditional for the FBI to more or less Chinese wall itself and its proceedings from the department. So that's just my best recollection for the whole episode.
Before that occurred, did the FBI ever brief you on their investigation or any of their interviews?
There was, before the curtain fell, so to speak. Yes, I do recall, well, certainly they interviewed me. They interviewed me and got from me my notes and the documents that I had come into possession of, and that Mr. McGinnis had very shortly thereafter. And I also do recall, I guess, attending one meeting wherein, and Mr. Burns chaired the meeting, as I recall, in which the progress of the investigation was discussed, and I can recall making a number of suggestions as to people they ought to chat with, based upon what information that I had accumulated during this weekend fact gathering.
Did you also assist in preparing letters to various executive branch agencies asking them to collect and preserve their documents regarding the Iran arms sales?
I did. I can recall having reviewed letters to various agencies to that effect.
Do you know when those were drafted?
I'm quite certain that it was on Wednesday, probably. In fact, I can recall a conversation to the effect that we should draft those letters and get them out, and that was Wednesday at this large meeting that you've previously described.
And do you know when they actually went out?
My understanding is they didn't go out until the following Friday, Thursday having been Thanksgiving.
And did you know, Mr. Cooper, that the FBI did not actually search or come to the White House to search for documents until Friday?
This was certainly not known to me at the time, but they did send the fellows with the rubber gloves in very soon, I was given to understand.
The Friday after Thanksgiving, is that?
Well, no, I tell you, I thought it was more promptly than that, frankly, but I just don't know.
Thank you very much, Mr. Cooper. Mr. Chairman, that ends my examination of the witness. I would move admission of exhibits CJC 1 through 20 into the record and DCI Casey's testimony before the House Permanent Select Committee on Intelligence on November 21st, 1986.
Without objection, so ordered. The hearing will stand in recess until 2 o'clock this afternoon.
I just about covered it.
The hearing will please come to order. Mr. Leon.
Thank you, Mr. Chairman. Good afternoon, Mr. Cooper.
Good afternoon.
If I may, I'd like to start off by going back over some of the questions, some of the topic areas that you were questioned about earlier, to amplify and clarify a few points, if I may. First of all, with regard to the chronologies, I believe you testified that there were a number of chronologies. that came into your possession and your office's possession over this 2-week time period, roughly, and you turned them over to us, did you not?
We certainly turned over all chronologies that came into our possession from whatever source. I think there were at least 3 different versions of the chronology.
And is it also your testimony that with regard to the chronologies, you did not find yourself constantly comparing them line by line, so to speak?
That's correct. I did not do that.
Is that because you viewed them as being a dynamic, something that was constantly evolving and being added to as a result of the work that was going on behind the scenes at the NSC to bring new facts to life?
It was my understanding that the effort at NSC was one that was obviously ongoing. It was hectic, and that the chronology, each succeeding chronology that we received, was a representation of their better and more perfect understanding of the facts.
And certainly prior to the events of November 20th, you had no reason, did you, to suspect that there was anything inherently wrong with those chronologies, or there was any effort being made to misstate the facts in them in any way, shape, or form?
I perceive no reason to believe that. I entertain no such suspicion.
In fact, after you left the meeting on the 20th with the Attorney General, and you were heading back to your office when you got detoured to go over to Mr. Wallace's office, you were proceeding, were you not, on the assumption that the chronology you had as of that date was pretty much a complete one, and that you could almost rely on that alone to finish up your legal analyses of the issues?
I was satisfied that the individuals were confident of the state of the facts that they had developed and had presented.
Now, you testified that after you left that meeting, you went over to meet with Mr. Wallison. Isn't that correct?
That's right.
And when you got there, Mr. Wallison expressed some concern on his part about his not having been invited to that earlier meeting that afternoon, hadn't he?
He did. I don't think in my earlier testimony that it was entirely clear that Mr. Thompson was with me and accompanied me to Mr. Wallison's office. But there were 3 of us in the office, and Mr. Wallison did indeed take the opportunity to make those points to Mr. Thompson.
Now, was it your sense that the White House counsel's office had been, so to speak, frozen out of that meeting earlier that day?
I wouldn't quarrel with that.
Now, you spoke with Mr. Wallison, and Judge Sofair called, and during the course of the conversation, you became aware of the conflict, potential conflict between Secretary Schultz's version of events and Mr. McFarlane's. And you shared that with Mr. Wallison, did you not?
With Mr. Wallison?
Right.
Actually, it was Mr. Wallison who shared it with me. He's the one who had the secure telephone conversation with Mr. Sofair, though, as I say, I don't think he did not fully perceive the significance of the information that he was passing to us. I perceived the significance of it.
Do you have any knowledge as to whether he passed that information on, that potential conflict, to Donald Regan?
I have no knowledge of that at all.
Did the Attorney General give you any indication when he met with Donald Regan and the President the following morning that Donald Regan seemed to be aware of the conflict that he, the Attorney General, was at that time bringing to the attention of the President?
I don't remember having received any information on that question.
Now, moving to the afternoon of the 21st, in your interview with Mr. McFarlane, you testified, you were present, you took notes, and your notes are an exhibit here. Now, with regard to that exhibit, Exhibit 15, I would direct your attention to the 4th page of those notes. In Exhibit 15, in the upper right corner, there's a number, a document identification number 3096. Do you have that in front of you?
Yes, sir.
I would direct your attention to the, about 3/4 of the way down the page, Mr. Cooper, there's an entry for December 7th that starts off with M said we should, and then something's crossed out, provide arms, no talk regarding problem with arms already given by Israel. Looks like that.
Right.
These are your notes, are they not?
They are.
And I wanted to ask you if, upon reviewing these notes at a later time, that you reached any conclusion as to whether or not that statement that I just referred you to was incomplete or incorrect in any way.
Yes, my note is incorrect.
How would you like to amend that today?
The note says, McFarlane said we should provide arms, blah, blah, blah. but it was McFarlane's position throughout our interview that he had consistently recommended in the various meetings and in all his many counsels on this with the President and others that we not provide arms. And the rest of my notes are consistent with that view. This is a mistake on my part. The word "not" is omitted, but there was not an occasion in our interview in which Mr. McFarlane suggested that he had recommended that we provide arms.
And you have an independent recollection of that word not being included in there.
Oh, yes.
And
Yes.
you've testified to that in your depositions previously before the committee's counsel.
As well as before other bodies.
Okay, fine. Now, with regard to one further aspect of that interview that afternoon, Mr. Cooper, you've testified to an aside between the Attorney General and Mr. McFarlane after the meeting took place, and that the Attorney General later shared with you, the contents of which. And I believe you testified as to what it was that McFarlane said to the Attorney General, and you paraphrased it along the lines of his desire to help the President and to protect the interests of the President, words to that effect. I don't believe you testified as to what the Attorney General told you his reaction was and what he said to Mr. McFarlane after Mr. McFarlane said that to him.
Yes, perhaps I didn't, but I do have a equally general recollection that that the Attorney General reiterated at that point for Mr. McFarlane what he had opened our interview with, which was that the way to assist and protect the interests of the President in this matter is to be entirely forthcoming and to not engage in any activity that could be interpreted as an effort to conceal facts.
Okay. Now, the following morning when you interviewed Secretary Schultz together with the Attorney General, was that the first time you'd met the Secretary personally?
Yes, it was.
Okay. And that was over at the State Department, was it not, at his offices?
Yes.
Now, I believe you've testified as to what Secretary Schultz told the Attorney General and yourself with regard to Mr. McFarlane's statement to him as to the Hawk missiles. I don't recall you testifying as to what Secretary Schultz told you his reaction was to Mr. McFarlane upon learning that there were Hawk missiles about to be shipped from Israel to Iran.
Secretary Schultz maintained then that he disapproved of the idea and that he did not think it would work and that it was a bad idea. He registered his position, was my understanding, and that was that.
Do you register it with Mr. McFarlane alone, as far as you know?
That's all. That's my understanding. Yes.
And did he, the Secretary, give you and the Attorney General the impression that he believed at that time that this was a fait accompli?
No. The transfer itself, I don't think he believed at that point was a fait accompli. I think he was being informed that the transfer was in the offing. Perhaps it was beyond recall, and he may well have had that impression. But he also stressed that he did not understand from the context and statements in the meeting that he was being asked for approval on it, but rather being informed.
Now, with respect to the diversion memorandum and the informing of the Attorney General of the existence of that memorandum on Saturday morning, would you characterize the Attorney General's reaction to learning that, besides what he said, one of proceeding cautiously to determine the truth or falsity of the memorandum and where exactly it had gone?
Well, first, I don't think it was Saturday morning. I'm pretty
Saturday
sure it wasn't
lunch, I should say.
Right, Saturday early afternoon, lunchtime. I have only a general recollection that first I've already expressed my recollection of his reaction and his surprise. And beyond that, I do recall him expressing a sense of very serious concern and worry, and obviously the need to verify whether or not this event actually happened.
Do you think it would have been premature at that point for the Attorney General to change an internal investigation, which is what you were conducting at that point, into a criminal investigation based upon a memorandum undated and unaddressed?
Well, I don't know whether, I can't imagine that that would have been something that was indicated or required at the moment, whether it would have been, I've forgotten the formulation you used, but, you know, there was just, no, it didn't occur to me, and I must suspect it didn't even remotely occur to anybody that a criminal investigation of the West Wing of the White House be launched based upon that tentative information. The first thing was to confirm with Mr. North whether or not the event had taken place, and we obviously recognize that would be one of the most important elements of our conversation with Mr. North.
For that matter, did you see any, just on the existence of that memorandum alone, did you have any clear legal theory in your mind as to whether or not there would be any criminal consequences to such a memorandum?
No, none at all, although there were legal implications. We were at least, I was at least, I should say, sensitive to the fact, or at least the grave likelihood that there were legal implications for this. I was familiar in a nodding way with the Boland Act and what have you. But I think the Attorney General probably was more sensitive than I was to the potential legal implications at that moment, because he was more familiar, I'm sure, with the Boland Act than I was.
Now, when you met with Colonel North on Sunday afternoon, following afternoon, you've already testified that he had made a joking or passing reference to your colleagues, Reynolds and Richards, with regard to having an attorney. Did that issue of his having an attorney come up at all on Sunday afternoon?
No.
Do you
Not to my recollection, it didn't.
Do you recall any statement to the effect by Oliver North throughout that interview on Sunday afternoon? Any statement to the effect, after being shown the diversion memo, any statement to the effect that, does this count since you haven't given me my rights?
No, I do not recall any such statement to that effect.
Do you recall him making any reference to either wanting his rights, so to speak, or not having gotten his rights?
Nothing of that kind, even remotely resembling that kind of remark or reference, was made in my recollection.
And it's not included in the notes of that afternoon that you've reviewed, is it?
No, it's, well, if it is, I missed it. I don't think that it is. It's not in my recollection.
Now, with respect to your chronology, Exhibit 1, I believe you have before you, I'd like to solidify a date with regard to an event that you testified to earlier today. If you turn your attention to your chronology on the fourth page, I believe it is, might be actually sixth page. It's got the number in the upper right corner, J7699.
What's the date on that, Counsel?
It'd be November 25th's events.
Yes, sir.
There's a reference in the chronology to a meeting on November 25th at 2:30 in the afternoon, a meeting with the Attorney General, yourself, Brad Reynolds, Stephen Trott, Judge Webster, and Arnold Burns. Is that the meeting you were referring to earlier today as when the Attorney General assigned Mr. Burns the responsibility of securing the documents?
Yeah, it is. It's my recollection that that's when that directive was issued.
So that was on Tuesday, the 25th.
That's my best recollection.
And turning back one page, you have a reference to a meeting later that day at 5:45 to 7 o'clock that was misplaced on November 24th with the Attorney General, Stephen Trott, Bill Weld, and others. Would that be the meeting you referred to in which Mr. Burns noted that he had not yet done what the Attorney General expected him to do?
Well, yes, I think that is the meeting, although I note that my chronology doesn't reflect that Mr. Burns was there, but that's my best recollection.
It was clearly the same day, was it not?
I can't say that. I can't accede to the term clearly. It is my best recollection, and it's reasonably confident, but it's not clear to me.
What was the Attorney General's reaction as you perceived it to learning that Mr. Burns had either misunderstood his orders or had failed to carry them out?
I obviously feel awkward discussing this, but Mr. Burns was embarrassed, and he felt very badly because the Attorney General was he exhibited a rare flash of irritation at that. And Mr. Burns immediately exited to accomplish the task.
Now, focusing back on the events of the weekend, did you at any time or any members of the investigation team have any reason to think that the diversion memorandum or any other documents that you reviewed were about to be or in jeopardy of being shredded, altered, or destroyed in any way, shape, or form?
We had no basis at all. I entertained no suspicion of that.
And was that ever discussed even as a possibility among the four of you?
You know, it is my vague recollection that there was some joking between us, or at least perhaps me and John Richardson or Brad, not to the effect that there were documents being shredded, but perhaps that the documents had been examined or were incomplete in their production. But as I say, we did not have any basis for suspicion of that fact, and entertained no idea of any such activity.
Okay, fine. Now, I've placed before you a copy of a transcript that's unclassified of Judge Sofair that was referred to earlier in your testimony today. I'd like you to take that so you can follow along with me. This is a transcript of a deposition taken on June 18th. Now, had you ever seen this before today?
This deposition transcript?
Yeah.
No, I have not.
Okay, and I would like you to direct your attention to pages 69 to 70, which contain a reference in Judge Sofair's testimony to a conversation between you and him on Sunday evening, the 23rd. And if I direct your attention to line 14, I would like to read that into the record, if you care to follow along, with regard to Judge Sofair's account of his conversation with you that evening, and then ask you if this comports with your recollection of that event. Answer by Judge Sofair: yes, November 23rd, I was interested in knowing where the investigation stood, and Cooper was interested in seeing the notes. So we were on the phone together. I don't know who called, but we were probably calling each other. He said, have you arranged to make sure that I can get to see the notes? And I said, don't worry, I'll see to it. Let me stop there for a second. The notes he's referring to are Mr. Charles Hill's notes, the executive assistant to the Secretary of State, are they not?
I'm certain that's true.
Picking it back up on line 20. And I asked, how did it go with the Secretary, and how is it going generally? He was exhausted, I could tell from his voice. It was late at night on Sunday, and he said it's just a real mess and that they had found out a lot of things. And he asked me, he mentioned that I had mentioned earlier that I was concerned about a surplus of funds. Question, how did he know that? Answer, I had mentioned it to him. Question, to Cooper? Answer, sure. And he said, how did you know about that? What had led you to that? And I explained to him that I just thought there was a spread, that cost price and sale price might be very different. He didn't say anything, but he led me to believe that that might be significant in the story. He did not explain to me what had happened. Question, Cooper didn't tell you on the 23rd that the day before representatives of the Attorney General had found the so-called diversion evidence? Answer, no, he didn't at that time. I told him that, at a minimum, I was scared that Southern Air Transport had been given a lot of money for its arms shipments to the Middle East to subsidize it, in effect for doing the work it was doing in Central America for the FDN. Question, but these were concerns that you were generating based on inferences. You at that time knew nothing about the fact of any diversion from the Iran program to Contras or elsewhere. Answer. Not until the Attorney General's press conference. Question. On the 25th of November, answer, yes. Having reviewed that, Mr. Cooper, does that sound consistent with your recollection of your telephone conversation with Judge Sofair on the evening of the 23rd?
It does. It sounds remarkably familiar, in fact.
He comments in his transcript that you sounded exhausted on that evening. Were you?
Yes, I was.
It had been a strenuous few days before that, or weeks.
Yes, it had.
There had been a lot of firsts for you during that time period. Your first meeting with Mr. Poindexter, I believe you testified, with Mr. Casey, Mr. Schultz. The first time you'd ever seen a finding. Your first exposure to a lot of documents that you'd never seen before at the National Security Council. Isn't that correct?
That's true.
Was it the first time you'd ever been involved in an investigation of this kind?
Of this kind, yes.
Would you say that was a baptism by fire?
I would not quarrel with that characterization.
Would you say that the hours have been very long and arduous on each day?
I would consider that an understatement.
And that it was a complex set of events?
That is quite true.
Would you say it was a little bit, to draw an analogy, a little bit like navigating down an unknown river in a small boat, where there are new twists and turns around each bend, and the pace of the river kept escalating as you went along?
All of those things sound quite descriptive and accurate to me.
Let's go over some of those facts that were revealed to you in a very short period of time. On the 17th, your investigation, up to that point, the 17th, was just into the Hawk shipments, was it not?
The Hawk shipments,
Pre-January events?
the pre-January events, right? This
And on the-
September and November.
And on the 17th, for the first time, you learned about pre-January events, was it not, when you got the chronology?
Yes, I believe it was.
And on the 19th, the President had a press conference where there was an error that you brought to the attention of the White House staff, did you not?
That is correct. In the President's press conference, I'm certain all will recall, was one in which the President was apparently not very well briefed by his staff. That was certainly my conclusion. That was a conclusion and a very serious concern of the Attorney General.
And the Attorney General was so concerned about it that he made it a fact to be there the next day to ensure that the testimony that was anticipated on Friday next would be consistent and factually accurate.
That was part of his motivation.
And later that afternoon, it came to your attention not only 2 days after learning about the pre-January events for the first time, you learned about a major conflict between cabinet officers, did you not?
Yes.
And that certainly was a major revelation and a major new concern, was it not?
Yes, it was indeed.
And the next afternoon, after the President gave you the green light to conduct an internal investigation, and you only had 72 hours to do it in, you had the testimony of Mr. McFarlane to you that you yourself said raised serious questions of credibility. And that was a major concern, was it not, that escalated the pace of the events?
It did.
And then lunch the very next day, now only 3 days into this, you had another major revelation of an even greater proportion. I think you once described it as a nuclear type of problem.
It had that potential.
And now you had only 48 hours to resolve all of these matters to report to the President in the next 2 days. And the next,
At this point, I became quite seriously doubtful that we could resolve these matters in that period of time.
and the very next day you had an interview with Colonel North in which he confirmed many of the fears that you recognized just the preceding day when that bombshell exploded at the luncheon. Did he not?
Yes.
Raising serious questions with regard to high government officials surrounding the President.
Yes.
Well, I go through these points, Mr. Cooper, because I want to give you an opportunity to state, as I close now, some sense of context in which these events were transpiring and how you felt, because there will be Monday morning quarterbacking, I'm sure, by historians for years to come as to these events and your participation in them and other people's participation in them. The Attorney General was at the helm of this boat, and you were there with him at his side, and I think it's important for you to have the opportunity to express some sense to this committee of what it was like to be in the middle of that very fast-whirling set of events. Why don't you take that opportunity?
Well, you're most kind to afford it to me. However, out of respect for the time of this committee, I would simply say that I do believe that the flavor for the moment, so to speak, that you have really just provided is quite accurate, and throughout this period, I think we all acted with a sense of grave urgency, and urgency that seemed to become graver and graver with each passing interview, with each passing moment, and I think we acted with a very serious concern about the events that would undoubtedly follow in train, as they certainly have followed in train, and the period that our country and the American people would go through in consequence of it. But beyond that, I really have little more to say about it.
It certainly wasn't an experience you expected to have when you were confirmed as an Assistant Attorney General by the Senate a little over a year ago, was it?
No, I did not expect any such experience as this.
Is it your testimony today that you did your very best at every stage along that process?
And that is certainly my testimony.
I have no further questions, Mr. Chairman.
Mr. Kaplan.
Thank you, Mr. Chairman. Mr. Cooper, I've been told that I'm going to get a medal if I limit my questioning to under 10 minutes. Well, since I've never received the medal either from the Congress or from the Department of Justice, I'm going to do my best to meet that challenge. I want to direct your attention to a meeting that you had with Thomas Green, an attorney here in Washington, on Monday, November 24.
Yes, sir.
How did that meeting come about?
The meeting was set up by Mr. Green, who contacted Brad Reynolds and asked if he could come in and talk with him about the Iran initiative. I think he contacted him Monday morning or something like that. It was
to your knowledge, why did Mr. Green contact Brad Reynolds?
He contacted him because he, at least he represented, he wanted to give us some information that it was important for us to have.
Mm-hmm. Did Mr. Green know Mr. Reynolds, or Mr. Reynolds know Mr. Green prior to that morning contact?
Yes, they were both and are D.C. lawyers. They had litigated against each other, as I understand it, and had litigated on the same side as well. So they were well acquainted with each other, and they had, as I understood it, they were, had high professional and personal regard for one another.
Did Green say how he knew that the Justice Department was conducting a fact-finding inquiry into the Iranian arms initiative?
In his meeting with Mr. Reynolds on Monday?
Well, in the discussion with Mr. Reynolds or in the meeting with you later on that day?
Actually, I don't know what else may have transpired in the discussion with Mr. Reynolds over the telephone, other than what I've made known. In terms of the meeting, I attended the meeting that did ensue on Monday, and I don't recall him stating specifically anything that answered your question, but there were many references wherein it was quite obvious that he had talked with Colonel North, since the time we had, and we had spoken with him the evening before. And it was also clear that, and he indicated he had been talking with North and Secord for a period of time.
Mm-hmm. When did the meeting actually occur?
It was Monday, as I recall. Monday at Monday, according to my chronology, and this squares with my memory, 2 o'clock to in the neighborhood of 3:15, according to my chronology.
Did the meeting take place at the Department of Justice?
Yes, it did.
And who was present at the meeting?
I was, Mr. Green, and Mr. Reynolds.
Did Green say who, if anybody, he was representing in connection with that meeting?
He opened his presentation with the statement that he represents or represented North and Seacord. At that point, however, and he wanted to make it clear to us that he was not there in the capacity of a lawyer representing a client. And in fact, he was rather cagey, and that's my word, but it was just not clear to me exactly who it was that he did represent as a lawyer, if anybody. But by the same token, it became quite clear to me he had been discussing this matter with at least North and Seacord, and probably Mr. Hakim as well. And in fact, I felt certain and received information that at that time that he discussed this matter with Mr. Hakim, or at least that appeared clear to me. So that's about what the exchange was on his status.
Is it fair to say then that it was at best unclear whether he was representing anybody during that meeting, and possibly he was appearing as a legal representative of no one at all?
Well, it was clear to me that he was not there as a lawyer to a client. He might have been, at the time he was there, representing people, but on that I was unclear. Okay. But it was clear that he was not there as a lawyer representing a client. He wanted to make that clear to us.
Can we take that explanation as a clarification of your handwritten notes of the meeting that appear as Exhibit CJC 19?
Yes, you may. Yes, you may.
Can you describe for us the substance of the meeting?
Well, again, I would... I have very little from memory that supplements my notes, although certainly that exchange we just had does. But Mr. Green presented an understanding of the thing that sticks out in my memory, an understanding of the Contra diversion that was at odds with the one that we had received from Colonel North. And he opened his discussion of that element of it by saying that Colonel North is, your ultimate Marine, and he wants to step forward and take the spears in his own chest. And I think that's the formulation he used. It sticks in my mind. But that it's important for us to know that there's another, a little different version of this whole matter.
Mm-hmm. And was there any resolution to the meeting? How did you leave things after Green went through an explanation of his knowledge of the diversion and of the participation of North, Seacord, and Hakim as evidenced by your notes?
There was the conclusion of it, at least on this part, was along the lines that this matter, if made public, this contra element of it all, would be there could be lives lost, and he expressed an earnest hope that it would not be necessary to make it public.
Did you or Mr. Reynolds make any representations to Mr. Green in that regard?
There was an understanding reached. We certainly did not respond one way or another to that point. But Brad did assure Mr. Green, as I recall, that he would do him the courtesy of letting him know prior to the time that the matter was made public.
And what was done by you or Mr. Reynolds with the information that Mr. Green conveyed to you during that meeting Monday afternoon?
We outlined it to the Attorney General and probably to others in the room. I don't remember who was gathered on that occasion, but we did. I do recall in the Attorney General's office outlining the alternative version.
Were any recommendations made to the Attorney General on the basis of the information you received from Green?
I don't, well, I don't recall any, none in particular. You might be able to refresh my memory, however.
Do you know whether Mr. Reynolds did in fact call Mr. Green prior to the disclosure of the diversion on Tuesday, November 25?
No, he didn't.
He did not.
Right.
Are you aware of any further meetings between Justice Department officials and Mr. Green relating to the matters at hand in these hearings?
Yes, I understand that Mr. Reynolds met again with Mr. Green and someone else from the Justice Department some few days later. I don't remember, however. I was not present, and I just don't know what transpired at that meeting.
And you don't know anything about what transpired at that meeting?
I certainly don't recall what transpired.
Okay. What about other phone conversations that you or Mr. Reynolds had with, or might have had with Mr. Green sometime in between the two meetings? Were there any?
Well, there certainly were no phone conversations between me and Mr. Green.
Mm-hmm.
But and I know of no conversations that Brad Reynolds had with Mr. Green.
Okay. Now I'm going to direct your attention to a telephone call that I believe you received from Mr. Casey on Monday or Tuesday, November 24 or 25. It's reflected in your notes as Tuesday evening in Exhibit CJC1. Do you actually recall which day that telephone call came in?
I can't improve my chronology on that. The chronology reflects some uncertainty even when I wrote this entry.
Right.
And my memory hasn't improved on that.
What time of day did the call come?
It was in the evening.
Evening.
It was in the evening. It was dark outside. That much I do remember.
Where did he reach you?
In my office.
In your office. Was anyone else in your office at the time the call came in?
Yes, there was.
Who was that?
At least John McGinnis. And I don't know of anybody else, but it's possible that somebody else was.
Are you aware as to whether there was anyone else on Casey's side of the line?
No, I have no knowledge of that.
Okay. Was it common for Casey to call you directly?
No, it was not.
Okay.
It never happened.
But before that evening, approximately how many times had Mr. Casey called you directly?
I had never received a telephone call from Mr. Casey.
And can you describe the substance of the conversation that you and Mr. Casey had?
It was a very, very brief and, well, it was just a very brief conversation. He asked me whether in all of this research we were doing, if we had come across the name Lakeside Resources. At least that's what I understood him to say, and that's what I recalled him to say when I wrote this entry.
Mm-hmm. And what was your response?
My response was, that name has some vague familiarity to me, but I'll be darned if I could tell him whether I had or not. It seemed familiar, but I couldn't place it.
Was there any other conversation prior to him hanging up?
I feel confident that I said, well, is this something that, I mean, why do you want to know that? And I don't remember getting any edifying response.
Okay. I think I've earned my medals. I don't have any further questions, Mr. Chairman. And Mr. Cooper, thanks very much for your cooperation today.
Thank you, sir.
Chairman Rodino.
Thank you very much, Mr. Chairman. Good afternoon, Mr. Cooper.
Good afternoon, sir.
Mr. Cooper, I'm trying to settle in my mind the team that was put together by Attorney General Meese. On the afternoon of November 21st, testifying before the Senate committee, he stated that he had assembled a team of 3 lawyers who had experience with this type of matter to conduct the inquiry into the Iran arms sales matter. Now, besides you, there was Assistant Attorney General Bradford Reynolds. Is that correct?
Yes.
And Special Assistant to the Attorney General, John Richardson. Is that correct?
Yes, sir.
Now, all of you are not career employees. You're political employees, are you not?
Yes, sir.
And neither you nor Mr. Reynolds nor Mr. Richardson have worked in the criminal division. Is that correct?
Yes, I don't believe any one of us has worked in the criminal division.
As a matter of fact, Mr. Reynolds is the head of the Civil Rights Division. Is that not correct?
Yes, sir, he is.
So is it fair to say that none of you really had any extensive experience investigating in matters dealing with national security issues or who had any particular expertise in the matter of Iran or Central America? Isn't that fair to say?
I think that's fair to say, but I don't think the inference to be drawn is fair, because the question that we were trying to get at was, who knew what on November?
Well, did it turn out to be who knew what?
Oh, no, it certainly didn't. No, but when this...
As a matter of fact, I think it was Mr. Leon who characterized your experience here as a baptism in fire, your first experience. Isn't that right? Since you really haven't had any extensive investigative experience.
Mr. Chairman, Chairman Rodino, I think that all four of us got a baptism in fire that weekend. I think the Attorney General, who is a very experienced prosecutor and criminal prosecutor, has never been through anything like we went through that weekend.
Well, did it occur to you, as a member of this team and seeing what was confronting you, that maybe there might have been a need to develop a team that was more experienced in this kind of an investigation, or that it was necessary to turn it over to the criminal division or the FBI? And I know that you stated that at some time you didn't feel, at least immediately, that that was the case. But this is the way it turned out, isn't it?
Well, and yes, we did turn over this matter to an exceedingly large team of investigators and criminal lawyers.
Did anyone raise any concerns about the composition of the inquiry team, or as to where the investigation was being conducted?
Certainly, I have seen reports of such concerns in the media, but you mean by
in the department, by individuals in the department?
Well, not to me, no. I can't say that some weren't raised.
Someone else?
And not to my knowledge, but I previously described, I guess, a sense that I got when this matter was turned over to criminal investigators.
Well, let me ask, given the fact that there was a November 24th deadline, and knowing that you had so many documents to review, and the number of people who were involved that you had to contact and interview, didn't you consider it a problem to be able to conduct this investigation with just a few of you?
Well, I think we all appreciated this would be an arduous task with that team, but that was the team the Attorney General assembled, and we felt like it was one that was adequate to accomplishing the task. Interviewing witnesses. all of us had had reasonably extensive experience in that. Mr. Reynolds certainly has a wealth of experience doing that. The Attorney General has vast experience. I even have some modest experience in terms of interviewing and deposing witnesses. So I don't think Mr. Richardson does, but that is the task that I think we thought we had to deal with at the time. It was much more like a civil discovery. That's how I looked at it, not a criminal.
Let's go on from there, Mr. Cooper. Oliver North and John Poindexter were named as possible subjects of an independent counsel inquiry as a result of a request made by the House Judiciary Committee on October 17th after the Hassenfuss crash. And the criminal division had canvassed all the components of the Department of Justice regarding North's activities, and they pursued an investigation at that time. Did you talk with the prosecutors in that case?
No, I don't believe that I did.
Did you not consider it important to do so during the course of your inquiry?
I don't think I was acquainted with these facts that you're suggesting. I'm pretty confident that I wasn't. I mean, I imagine that if all the components received a routine request for information along the lines that you've described, that my component, the Office of Legal Counsel, did, but we typically would not have anything to contribute to such a matter.
In other words, the fact that there had been an ongoing inquiry into North's activities, this was not a matter that you were supposed to be aware of, view the fact that it did relate to North, and immediately following the Hassenfuss crash.
I don't think I was aware of that. I don't think I was aware of that. Or I was aware of the Hassenfuss controversy, and I probably was aware that there was some Justice Department activity that was generated by it, but I don't recall having associated North with that.
Well, let's reflect on what you've already testified to, and as I understand it, on about November 17, 1986, prior to the weekend inquiry, you received 2 chronologies from the NSC about the Iranian arms sales. Isn't that correct?
We did receive at least 2 chronologies, yes, sir.
And you did state that you were troubled about the scarcity of information regarding the hawk shipment. Isn't that correct?
I was nagging them for information prior to the time I got the chronology, yes, pretty consistently.
And you called the Attorney General, as a matter of fact, and told him that prior involvement by the United States in Israeli shipments raised, as you said, potential legal problems. Isn't that correct?
I outlined some legal concerns that I had about that.
And on November the 20th, you met in Poindexter's office along with Attorney General Meese and Poindexter himself, Casey North, and others to review Casey's proposed testimony before the Senate. And at that time, North, who you said dominated the situation, insisted that there be a deletion of any reference to the CIA and insisted instead in inserting that there was no U.S. government knowledge at all, no U.S. government involvement.
Yes, sir.
Isn't that correct?
That is true.
And no one objected at that time concerning the North insertion and the North deletion. Is that correct?
That is correct.
And immediately after that meeting, State Department Counsel Sofer told you that not only was the testimony wrong, but that he would resign if it wasn't changed. That's correct, isn't it?
Actually, that's not the formulation, but we had a telephone conversation where that's what I discerned from it. I've testified previously as to that conversation.
Well,
yes, sir.
let's take it from there. At this time, following all of this, number one, you were troubled by the chronologies. You had advised the Attorney General of possible legal problems, and you'd been confronted with apparently false draft testimony that you were aware of, and so Farrah did make these statements, which you became aware of, that he thought that the statement was false and that he probably resigned. How did you view these events? Were they simple mistakes? Didn't they give you some concern? Wasn't this a red flag at this time?
Yes, sir, indeed it was.
And wasn't this the time then to call in in the course of your inquiry?
I don't think I was acquainted with these facts that you're suggesting. I'm pretty confident that I wasn't. I mean, I imagine that if all the components received a routine request for information along the lines that you've described, that my component, the Office of Legal Counsel, did, but, you know, we typically would not have anything to contribute to such a matter.
In other words, the fact that there had been an ongoing inquiry into North's activities, this was not a matter that you were supposed to be aware of, view the fact that it did relate to North, and immediately following the Hassenfuss crash.
I don't think I was aware of that. I don't think I was aware of that. Or I was aware of the Hassenfuss controversy, and I probably was aware that there was some Justice Department activity that was generated by it, but I don't recall having associated North with that.
Well, let's reflect on what you've already testified to, and as I understand it, on about November 17, 1986, prior to the weekend inquiry, you received 2 chronologies from the NSC about the Iranian arms sales. Isn't that correct?
We did receive at least 2 chronologies, yes, sir.
And you did state that you were troubled about the scarcity of information regarding the hawk shipment. Isn't that correct?
I was nagging them for information prior to the time I got to chronology, yes, pretty consistently.
And you called the Attorney General, as a matter of fact, and told him that prior involvement by the United States in Israeli shipments raised, as you said, potential legal problems. Isn't that correct?
I outlined some legal concerns that I had about that.
And on November the 20th, you met in Poindexter's office along with Attorney General Meese and Poindexter himself, Casey North, and others to review Casey's proposed testimony before the Senate. And at that time, North, who you said dominated the situation, insisted that there be a deletion of any reference to the CIA and insisted instead in inserting that there was no U.S. government knowledge at all, no U.S. government involvement.
Yes, sir.
Isn't
that's
that
true.
correct?
That is true.
And no one objected at that time concerning the north insertion and the north deletion. Is that correct?
That is correct.
And immediately after that meeting, State Department Counsel Sofer told you that not only was the testimony wrong, but that he would resign if it wasn't changed. That's correct, isn't it?
Actually, that's not the formulation, but we had a telephone conversation where that's what I discerned from it. I've testified previously as to that conversation.
Well,
yes, sir.
let's take it from there. At this time, following all of this, number one, you were troubled by the chronologies. You had advised the Attorney General of possible legal problems, and you'd been confronted with apparently false draft testimony that you were aware of, and Sofer did make these statements, which you became aware of, that he thought that the statement was false and that he probably resigned. How did you view these events? Were they simple mistakes? Didn't they give you some concern? Wasn't this a red flag at this time?
Yes, sir. Indeed, it was.
And wasn't this the time then to call in the criminal division and others who might be better able to pursue this, or the FBI?
No, sir, not in my opinion. I can't
And you mean
imagine.
regardless of the fact that all these things were occurring and they gave you these concerns, you still did not feel it was appropriate or timely to do anything that might have immediately brought to the attention of the people what was really going on?
It was not the time to call in the FBI, no, sir, in my opinion.
You didn't you think that maybe all of this was going to be construed at some time as a possible cover-up?
Oh, that's precisely what I feared, and that's why I undertook measures to prevent the event from happening that I feared would happen, that inaccurate information would be shared with committees of this body. But at that time, I didn't know which story was accurate. I had reason to place credibility in the State Department story, certainly when I learned of its source first, and secondly when contemporaneous notes were alleged to exist that corroborate it. But at that moment, the important thing was to prevent what was in the offing and to discover what the truth of the matter was. There was no criminal activity. There was no hint of criminal activity. The question was, let us prevent an error from being made, and even worse, the worst spin you could put on it was that there was going to be a knowing error made with respect to the representations to Congress. But the important thing was to prevent it and find out what the facts were. The notion that the FBI would have been sent into the White House at that point, I mean, you don't...
What do you mean, prevent it? What were you going to prevent?
Going to prevent the director of the Central Intelligence Agency from expressing and relating to the Senate Intelligence Committee and the House Intelligence Committee an understanding of the facts which we no longer had confidence was true and had reason to believe it was not true. That was the critical thing to deal with at the moment.
Well, it still bothers me to think that with all that was going on at this time, talking about preventing something such as preventing false testimony from being actually produced before the Senate committee, on the other hand, there was no concern on your part that what had already taken place was something that was serious enough to call in people who were equipped to do the investigating, people such as the FBI or others.
Senator, the only thing that had taken place at that point, excuse me, Mr. Chairman Rodino, the only thing that had taken place at that point was that a draft testimony had been crafted which at worst contained an error in it which somebody knew to be an error. Now,
Are you saying that the North statement that was included was just an error?
I'm saying that the worst spin that I knew to put on this thing
But you knew there was
was
a
that
deletion.
somebody knew that the error was an error. That's what I'm saying. I'm not denying or saying that I didn't recognize the possibility, a distinct possibility, that those who had authored that statement knew or had reason to know that it was not accurate. I fully appreciated that possibility.
On November the 23rd, Attorney General Meese, William Reynolds, Richardson, and you interviewed North, and according to your testimony, North was surprised that the Attorney General had found a copy of the diversion memo, and North immediately asked if the Attorney General had found a cover memo. And I think when we talked about the cover memo a while ago, there was a question as to whether or not a cover memo existed. Why would not a cover memo exist if Colonel North called attention to it?
I think it's very important to try to deal with this business about a cover memo based upon some of the notes that that Mr. Richardson took of our interview with North, notes which comport with my recollection of that event.
My time is slowly getting up, so will you?
Well, this is a very important point, I see.
I know it is.
Those notes, I'm sure the committee has them, but they comport with my recollection, as I say, of the questioning of Colonel North on this point. The Attorney General very methodically asked him who knew about this diversion, who might be knowledgeable in the United
Did he
States.
ask him at that time if there had been any documents which had been shredded or destroyed?
No, there was no conversation about shredding or destroying documents. But
There was no need to ask that question either?
I had no basis upon which to ask the man that question.
But you were conducting
In fact, we
an
had
inquiry, Mr. Cooper, which was a serious inquiry, and this is the reason why I emphasize the fact that you, the three of you, who were conducting this inquiry, with all due respect to your ability as a lawyer, but none of you had that professionalism, hadn't been in the criminal division, hadn't been career employees, and certainly, while we don't want to draw any inferences, but you were political appointees, and as such were conducting this kind of an investigation, which was a very serious investigation, in which all of us continue to ask questions about the presidency's knowledge, and it would seem to me that the investigation would have been better served if it had been conducted completely comprehensively.
I believe we conducted the investigation as in the circumstances and based upon the information we had as comprehensively as we could.
Is that why all of these new revelations come to the attention of this committee now, which your inquiry never revealed?
This committee's been impaneled for many weeks. It has investigators and extraordinarily skilled staff combing the country. Its deliberations have been patient and thoroughgoing. It has not confined itself to a weekend to discover all of the facts relating to this matter. I'm sure that all of the facts
Well, maybe
will
it shouldn't have
ultimately
been
out.
a weekend investigation then, Mr. Cooper.
My reference earlier to the need to disclose the Contra diversion put the end point on our investigation. But I would like to return, if I may, Congressman
Chairman,
Rodino. Mr. Chairman.
My time is up, but the chairman will permit.
The witness may respond.
Thank you very much, Mr. Chairman. As I mentioned earlier, the Attorney General, in his examination of Mr. North and his questioning of Mr. North, very deliberatively attempted to discern who might know of this Contra diversion in the United States government by either word of mouth or by virtue of documents which would reveal the existence of the Contra diversion. And after concluding that Mr. North had discussed the matter with no one other than McFarlane and Poindexter, the Attorney General asked the questions relating to where documents might be located that would reflect this. And one thing that was unclear in our minds and which needed to be established was where this memo went, if anywhere. The memo, by the way, was a draft. It had hand strike-throughs on it. I would not expect to find a cover memo on a document of that kind, though it might certainly happen. But according to Mr. Richardson's notes and according to my memory, the Attorney General asked questions like, if the President okays something, okays a proposal in a memorandum of this kind, a copy of that would get into the working documents, the working files of the NSC, wouldn't it? And North indicated, yes, that it would. He asked if the President, if RR approved it, you'd have it. You'd have a copy of this. The answer was yes. He doesn't think that it was. I think it is at that moment, at that point, in which Mr. North said, is there a cover memo with that document? I think that's when he said it. That's all I can tell you. The Attorney General continues. Are there other files that it could be in to verify that it didn't go forward? That is where Mr. North suggests he will check. But we did not discern any information beyond that with respect to any cover memos or anything. But with respect to the destruction of documents, the document we had was the best evidence they hadn't been destroying documents. Still, you know and I know that documents were destroyed. They were being shredded. They were shredded before we ever met with Colonel North, it now appears.
Those questions were never asked.
Well, that's true. That's true.
Mr. McCollum?
Thank you very much, Mr. Chairman. Mr. Cooper, I want to clarify a couple of things with you before I ask some specific different questions. You got involved, according to your testimony, for the first time at the request of Attorney General Meese on November the 7th of 1986. Is that correct?
Yes, sir.
At that time, the Attorney General was interested in exploring the facts around the whole affair as was known in the press at that time, he had not actually gotten charged by the President with a specific investigation, had he?
No, no, he hadn't.
Now, your specific task based on the Attorney General's instructions on November 7th was what?
On November 7th, just to basically prepare myself to be involved in this matter. Prepare myself to examine legal issues.
So you started to slowly look into these things and ask questions and get involved and bring yourself up to speed. And then several things happened, and on November 20th we went to this meeting with the Attorney General on the Casey testimony. But it wasn't until the morning after that, Friday morning, the 21st of November, that the President actually charged the Attorney General with an investigation of some sort. Am I correct in that?
Yes, sir, that's true.
And at that point in time, was there any change in your task that the Attorney General had given you? Did you do anything different? Did he tell you to do anything different than what you were doing? Did something change at that point on Friday, November 21st?
Yes, it did. It changed.
What?
I became enlisted by the Attorney General as a part of the small group of people that he wanted to assist him in performing his task.
And was there a deadline on this task?
Yes, sir.
What was the task at that point that the small group had?
To try to get our arms around the Iranian initiative, particularly insofar as it related to pre-finding matters, that is pre-January 17 matters, and iron out the discrepancies and the wrinkles that we had discerned and find out who knew what and who was accurate on this.
And as you got into this, as we found out, in about 4 days, it was pretty difficult to do this. It's taken this committee months to get our arms around this thing at this point. You found out it was pretty tough in a few days, didn't you? To get your arms around it?
It is indeed, yes, sir.
You were not, as you said, in conducting a criminal investigation at any point until you started to, well, in fact, you never were conducting a criminal investigation yourself, were you?
That's right. I even, I guess, prefer the word fact-finding to investigation, but it's really a matter of semantics.
What was the deadline you were working under?
The President had requested the Attorney General to report back to him, if at all possible, by Monday. For the NSPG meeting, that was 2 o'clock.
So you really only had about 3 days to do all this in, right?
That's true.
Okay. Now, at any time, did Robert McFarlane, Admiral Poindexter, Colonel North, or anyone else tell you or say in your presence that prior to November 20th, 1986, they had discussed with President Reagan or Donald Regan the diversion of the Iranian arms sales monies to the benefit of the Contras?
No, sir.
All right. Do you have any reason to believe or suspect today that before November 20th, 1986, that Donald Regan knew about the diversion of the Iranian arms sales money for the benefit of the Contras?
I have no reason to suspect that.
From the Prof notes that you've examined and were discussing earlier today on direct examination, and from the revelations that have come to your attention since November of last year, it's pretty clear, isn't it, Mr. Cooper, that at the time of the November 20th meeting regarding Director Casey's testimony that you've said you attended with Attorney General Meese, that Colonel North and Admiral Poindexter and Mr. McFarlane and Director Casey all knew that there was United States involvement in the 1985 Hawk shipment to Iran. It is clear, isn't it? They all knew that at that time.
I'm not sure I can say that. I think it's pretty darn clear that North did and Poindexter did, although at the time, on that November 20th, their non-reaction to Mr. North's changes in the testimony was entirely unremarkable to me. I had been given to understand, and I think it is true, that Mr. Casey was out of the country during the November Hawk episode, or during that time frame, and didn't have any personal knowledge of it.
Well, let's just assume it's, in this case, Poindexter, North, and McFarlane. Let's just leave Casey out of it. We don't know what he knew.
Yes, I think it's pretty clear that...
That those three did know, didn't they? I mean, after all, McFarlane, in his case, so fair has already said, and you got involved in this at the time, that it was McFarlane who told Schultz about it.
That's right.
So those three knew, and the evidence is very clear. It's clear to me. I think it's clear that Casey knew, too. I'm trying to be as objective as I can, listening for weeks and weeks on this, and I'm still holding back judgment on a lot of things, but it's pretty clear that they knew that it was an involvement of the United States on that date. They knew that at the time. And it seems it's also equally clear that they knew that there were missile parts involved. It wasn't just a question of there being some oil drilling equipment, as they said. They all knew it was missile parts, too, didn't they?
Now, that's certainly the view that I have come to, and you know a lot more about this than I do now.
So when Colonel North told Attorney General Meese on November 20th at that meeting regarding the Casey testimony that there was no one in the United States government in 1985, in November 1985, who was aware that there was a Hawk missile shipment going into Iran, and that they didn't find out about that until January after that, he was lying, wasn't he? Isn't that a fact? And isn't it also a fact that when Admiral Poindexter and Mr. McFarlane and Director Casey, well, at least I think it was so with Casey, but certainly when Admiral Poindexter and Mr. McFarlane were silent, and they didn't refute that fact in the Attorney General's presence on November 20th, and let this testimony apparently be put that way with regard to the Hawk missiles and the lack of awareness. They too were lying, weren't they?
I believe so.
And after the Attorney General was formally charged with the investigation the next morning, and he spoke with Mr. McFarlane, had a meeting with him, and Mr. McFarlane told the Attorney General he didn't know there were missile parts in the November shipment until he came back into the picture in May of 1986. He was lying then too, wasn't he?
It appears that he was.
And when Colonel North told the Attorney General on Sunday, the 23rd of November, that he had first thought that the shipment of the 1985 things over to Iran on that plane load were oil drilling equipment, and he didn't learn until later from General Secord that there were missile parts. He was lying even on Sunday when he said that, wasn't he?
Yes, sir, I believe he was.
So the point of it all is that we had a group of people, at least three of them and possibly four, in Colonel North, Admiral Poindexter, Mr. McFarlane, and probably Director Casey, who were deliberately deceiving and lying to the Attorney General of the United States about the involvement of the United States and the shipment of these missiles in November 1985. Isn't that a fact?
I think it is.
So if we want to call it a cover-up or whatever it is, we can still say for sure that we had one Attorney General who got pretty darn mad when he began to realize this fact as you were revealing certain portions of this to him, didn't he?
Yes, he was.
And as far as I can tell up to this point in the testimony we've had before us, he's the first person in the administration of any of the cabinet members or high-level officials who went into the President of the United States and said, Mr. President, you got a real problem, and we need to have a really thoroughgoing investigation. Isn't that a fact, too, as far as you know?
Yes, sir. He certainly did do that.
I am concerned about a few details. That seems to me those points needed to be made. I must say, in all candor, that I'm deeply disappointed in those gentlemen who did the acts that they did in not being straightforward about this from the very beginning, right or wrong. But I think we do need to clarify a few other things in some of the details that haven't been up to this point in time. When the Attorney General first got involved in this question of findings in January, before all of this, we're talking about November 1986, an investigation. I'm going to move you back to January 1986. When he first got involved and was asked to talk about findings back then, from what you've learned of that affair and his involvement in January 1986, he wasn't told by anybody about a presidential finding or a proposed presidential finding for shipments or activity with regard to Iran and the hostages before then, was he, back in November of 85 or earlier? So,
no, he wasn't.
If you want to trace this down, he was in fact indeed misled about that. You've had the exhibit that's been before you, number 12, that was the Casey memoranda exhibit dealing with that particular proposed finding. And at that particular time, in that finding, if he had been told about it, the Attorney General would have read that the particular involvement that the President was to sign a finding on involved munitions, involved weapons. The word munitions is in your exhibit number 12 in that proposed finding. But he was never told about that in January when he first was asked to look at the findings question by the same people we're talking about here in this case in the November meetings, was he?
No, sir, he was not.
So we have a whole series running from November 1985 through November 1986, and where at least 3 or 4 specific instances, the Attorney General of the United States, our top legal officer, one of the closest men to the President of the United States, was being misled and was not being fully informed, and yet was being called upon to make judgments and decisions. I think that itself may well be a crime. If it's not a crime, it's certainly one of the highest acts of insubordination and one of the most treacherous things that's ever occurred to a president, it seems to me, in our history. Let me ask you another question about something unrelated. I want to follow up a few details. During this time, you had a conversation, that is November, when you got involved with your portion of all of this, November 1986 again. You had a conversation with Assistant Secretary of Defense Armitage at some point, didn't you?
I did.
Did Mr. Armitage tell you that he knew about these Iranian arms transactions?
I do not recall him having told me that.
He did not tell you that he knew as early as December 1985?
I do not believe that he did.
All right. Just wanted to clarify that on the record. With respect to the investigation that you were undertaking, Bradford Reynolds' name has come up. He was the head of the Civil Rights Division, right?
Yes, sir.
The Civil Rights Division also has a criminal section in it, doesn't it?
Yes, sir, it does.
So some have suggested that perhaps your small team that really had a very short period of time to operate under didn't have the expertise on it of anybody who knew anything about criminal matters. And while that wasn't indeed your function you've already told us was not to look at the criminal side of it, at least Mr. Reynolds did have a responsibility in the white-collar criminal area. He did indeed have a criminal investigatory background and was himself involved, and the Attorney General himself was a former prosecutor, wasn't he?
Yes, the Attorney General certainly is a very experienced criminal prosecutor.
So while we may have a lot of discussion about what people knew or didn't know with regard to their abilities to handle looking into this matter, you had assisting you, in fact, the Attorney General running this operation, people who were steeped in the experience of investigations, albeit that they were under a time constraint that turned out to be miserably slim. Would you, if you had to go back and do it again, suggest to the Attorney General that the President's deadline of Monday was a little short? They should have perhaps extended it?
Certainly I would now, but at the time that the President set the deadline, it did not seem impossible. And at a minimum, the President was entitled to have whatever information we'd been able to collect confidently at such time as he required it. But we wanted to give him as complete a picture as we could by that time frame.
Well, as I recall, that there was no real thought about doing any criminal investigation until after the night of Monday, the 24th, I guess it is, of November. Am I correct? You just didn't enter anybody's head till after then?
No, I think it started entering our heads on Monday. You know,
during the day.
Yes, we were examining. I and Mr. McGinnis, my assistant on the matter, were combing the what we thought would be the applicable criminal statutes.
But
and based upon our subsequent conversations with the criminal division supervisors, Mr. Weld and Mr. Richards, we didn't do all that bad a job in identifying the statutes.
Well, that was within and you did that within 3 days of the President charging the Attorney General with doing some looking into this formally. Is that not right?
All of this activity, yes.
And so, as you've testified earlier, you were virtually taken out of the picture because it got turned over to the criminal side of this within another couple of days. Isn't that right?
I was out of the picture effectively Wednesday and not clamoring to get back in it.
And there was, in fact, a turning of all of this over to an independent counsel, a special prosecutor, within a matter of a very few days after that. Wasn't that true, too?
It was not long thereafter. I think it was in the neighborhood of a week or so, at least, that we requested the independent counsel, and of course the appointment then took some additional period of time.
I have one curiosity question. The other day, Fawn Hall was testifying, and she was asked, I guess, who fired Colonel North? She didn't know. Who gave him the word? She didn't know. By any chance, do you know?
Who fired Colonel North?
Yes.
Ultimately, the president, I guess. The president.
You don't know who informed him?
Who informed him of that? No, sir, I don't.
Do you know when he was informed of it?
I vaguely recall a press account to the effect that he was informed of the fact when he learned from the Attorney General on the television.
Well, I am running out of my time, but I am very dedicated and myself and to details, and I think you were obviously too. Personally, my observations, listening to your testimony, indicates to me that we owe you a lot of gratitude for unearthing some of these things, that if it hadn't been for your persistence on the dates of the 20th and 21st in particular, the Attorney General might not have been aware of certain things, and this might have gone on a lot longer than it did. And I think that the nation owes you some thanks, Mr. Cooper. So thank you for being here today, and thank you for what you did.
Congressman Cullum, I truly appreciate that remark. And it's my pleasure to be here to assist this committee.
Thank you, Congressman Cullum. Senator Sarbanes.
Thank you, Mr. Chairman. Mr. Cooper, what was it that the officials in the Department of Justice learned that precipitated the reference of this matter to the Criminal Division?
We learned that there was potential criminal liability, we believed, relating to the diversion of the Contra, diversion of monies to the Contras, potential criminal liability.
Because of the fact of the diversion?
Yes, sir.
When did you learn the fact of the diversion? On Sunday?
Yes, sir, Sunday night.
And when did you refer it to the Criminal Division?
Tuesday.
On Tuesday?
Yes, sir.
And when was the matter considered for reference? I mean, at the time you learned the diversion, is that when you began to consider the question of reference to the Criminal Division?
That's when we began to consider, in a very serious, determined way, if this had criminal implications. The Boland Amendment obviously was uppermost in our minds. That is not a criminal statute, but there are, of course, associated and general statutes of various kinds that might well be applicable to such activity as we suspected might have happened here. The most important question in our minds was this United States money? And that is not an easy question, but we undertook to discern whether this was United States money or whether there was a substantial argument to that effect. We believe that there was a very substantial argument to the effect that it was, that is, the monies that were generated, and that, therefore, any monies that were then not returned to the United States taxpayers should have been.
And you began to consider these questions on Sunday after you learned, well, actually, you learned about the diversion before Sunday, did you not?
We learned as early as Saturday at noon, at least I did, at lunch, of the possibility that the diversion took place. Yes,
Right,
sir.
and it was the diversion then that raised in your mind the possibility of criminal matters. Is that correct?
Yes.
You learned that on Saturday noon The reference to the criminal division was made on, when on Tuesday?
I think that
I thought you said your meeting was on Wednesday before they actually got drawn into the matter.
Well, that is when we collected, the criminal team had been put together and collected with me and the others of us who had the information to share with them and the documents to give to them and what have you.
So
that
on
did take place on
Saturday,
Wednesday.
you learned the fact that eventually, after the passage of a few days, was the basis on which to go to the criminal division. Is that correct?
Well, I really don't think that is. We learned, we received the first evidence of that fact, and we became sadly convinced that indeed it was a fact Sunday night.
When did the Attorney General give the order to secure the offices of Colonel North?
I believe it was at Tuesday at the 2 to 2:30 meeting. As soon as he came back from the press conference, we had a meeting.
So that order was not given until Tuesday either, is that correct? The order to secure the office.
I think that is accurate, yes, sir.
Why wasn't
That's
that
my-
done sooner, just as a matter of prudence?
Well, I think the Attorney General ordered that an order be given to the White House counsel to seal the NSC office contemporaneously with making his decision that the matter should be investigated criminally. But in any
But you
event,
could
he
give
did...
you could give one order, you could give the order to secure on the basis of concerns well prior to deciding that you had to go to the criminal division, could you not?
Yes, I don't disagree that you could have.
When did members of your team go to North's office to look at records?
Saturday morning.
And they went on the basis of the Attorney General having told Poindexter that they were coming over to look at records?
Well, the Attorney General did tell Mr. Poindexter that we would be requiring access to the NSC documents relating to this, and they should be gathered and made available.
When did he tell him that? On Friday afternoon?
That is my understanding, yes, sir.
And when do you understand that the North Hall shredding party occurred with respect to North's documents?
I hear it was Friday afternoon.
Or Friday evening, subsequent to the notification by the Attorney General to Poindexter that that your people would be coming to look at documents. Is that
Yes,
correct?
sir. That's my understanding.
Now, did you have any knowledge or involvement in any of these matters prior to November 7th when the Attorney General, I gather, drew you aside after a management meeting and enlisted you in looking into these matters?
No, sir, I did not.
So this was your first contact in this matter?
It is. Yes, sir, it was.
All right. Now, I take it you must be one of the youngest assistant attorney generals in the history of your division, are you not?
I think that is probably accurate.
Now, how did you find yourself then vetting the Casey statement to the Congress? I mean, as I see this thing, you've just been drawn into this matter, not had much experience, any contact with any of these matters, and the next thing we know, in very short order, on the 20th of November, you're at a meeting with Meese and Casey and Poindexter and North reviewing Casey's statement. How did that come about? In fact, I think you earlier in your testimony said, well, you were very deferential at that meeting. You said others weren't, but you said that you certainly were.
Yes, sir. Well, I was asked by the Attorney General to attend the meeting with him, and my understanding of my purpose there was, keep in mind I had been looking at the legal issues, identifying the legal issues that had been raised in the media and otherwise been identified by my assistant and myself, and had studied them. I had previously, in fact, done a very brief legal memorandum to the Attorney General on some of the issues that we had spotted. It is one of the exhibits. And so my understanding of my purpose there was in case a legal issue came up, that my presence might be useful.
Now,
But there's no doubt, Senator Sarbanes, that I was the least important member of that meeting. I was there just in case I could be useful.
Well, now, the problem with the Casey statement were the facts, was it not?
Yes,
They're accurate statements.
Well, certainly that was the problem that eventuated.
Now, then you went to the CIA the next morning, as I understand it, to review the final version of Casey's statement?
Yes, sir.
So, in effect, you had become the point man to review the Casey statement, is that correct?
Well, I think that's putting it high. What I did was go out there just to, out of an abundance of caution, really, to ensure that the statements that were questionable, or the statement that was questionable, was deleted or revised in an appropriate way.
And I take it you were doing that at the instance of the Attorney General?
Yes, sir, I was.
Did you perceive that the Attorney General had become the, in effect, shaper of the content of the Casey statement? That no statement would be made by Casey that didn't have the clearance of the Attorney General?
No, sir. That was not the atmosphere or the reality. Certainly, no statement would be made by Mr. Casey or anyone else that was under a cloud of uncertainty regarding its accuracy.
Was the previous day the first time you had met Casey?
I think that it was, yes, sir.
And then the meeting the next morning took place in his office where you reviewed his statement?
Yes, sir.
Just you and Casey?
Oh, no, there were, Mr. Doherty was there. There were 2 or 3 people that I did not recognize and know, and I would not know today. But there were people milling around.
Now, on the Hawks, at what point did you learn that McFarlane had contacted the Prime Minister or the Foreign Minister of a country in order to expedite the movement of this shipment of material?
I believe that this is what Mr. McFarlane, I'm sure it's what Mr. McFarlane told us. Whether that's the first time I learned it or not, I have to think it was.
And at that time it was being asserted that the material being moved was oil drilling equipment, is that correct?
Yes, sir.
Did it strike you as strange that the National Security Advisor should have to call the Prime Minister or the Foreign Minister of a country in order to get clearance to move oil drilling equipment through?
Well, it does seem strange, yes, sir.
Was McFarlane asked about that when you and the Attorney General met with you? I mean, McFarlane's telling you, I gather from your testimony, that this is a shipment of oil drilling equipment. And at the same time, McFarlane is telling you that he had to interrupt his activities at the summit, the Geneva summit, in order to make a telephone call to the officials of this country in order to help move this oil drilling equipment through the country. Now, didn't that strike you as passing strange?
The account of the event was that the Israelis, through North, essentially, were making requests upon McFarlane to use his good offices with the people in the third country regarding landing rights and while one would not normally, I guess, think there would be trouble with landing a plane that has oil drilling equipment on it, I don't recall having registered any impression at the moment that that's particularly strange, but now that you mention it, it does seem strange.
Well, if you'd have known it was arms, you wouldn't have been at all surprised that they were having difficulty getting transit rights for the material, would you?
I would not, and I fully believed it was arms.
At the time?
At the time.
As you listened to McFarlane?
As I listened to McFarlane.
On what basis did you believe that?
I just had come to the conclusion that there were, I mean, we knew, nobody denied that there were arms on it. The only thing that people were denying was the state of their knowledge about what was on that plane. But I was not entirely confident that indeed the state of knowledge was to the effect that there was oil drilling equipment on that shipment.
This morning, in response to one question about knowledge of the diversion, you enumerated the people within the government, and then questions went outside of the government. And you mentioned Secord, and then you said, and a couple of other people. And the question was put to you, who, and you said Calero, and then you did not go on to name the others, other or others, and I wondered who they might be.
Well, did I name Mr. Neer? Mr. Neer is alleged to have, by North was alleged to have been the person who came up with the idea. There's Mr. Calero, Mr. Secord. The following day, I learned there was Mr. Hakim who was knowledgeable. I also now recognize in the notes of the North interview that he suggested, in response to the Attorney General's question, if the CIA was handling any of the money that was going to the Contras, that he did not think that they know about it, but that some there may suspect. So that's all I can think of at the moment in terms of other individuals.
When North was shown this diversion memo in the interview in the Attorney General's office, I take it on Sunday afternoon.
Yes, sir.
You said he showed some surprise.
I don't think he showed. My recollection is that the surprise he showed was at the Attorney General's oral reference to the $12 million or the money to the Nicaraguan resistance, not to the handing him of the memo and the recognition of North that we had got this memo. Now, my recollection on that may well be entirely wrong, but my recollection nonetheless is that his surprise was shown at the question regarding the Contra diversion.
Well, of course, North knew there was such a memo. I mean, he talked to McFarlane about it just that morning.
Well, yes, he did know there was such a memo.
I guess North's surprise was that you had the memo.
I don't.
You being the Attorney General's people, that you had this memo.
Indeed, he may well have been surprised that we had the memo, but I do not recall him registering surprise when he saw the memo.
Was he asked during that interview whether the diversion plan had been approved?
Yes, he was.
And what did he say?
He said that he didn't know. He didn't think so. That he did not believe that the President had ever received the memo or any memo like it, or that the President had been briefed on this.
And was he asked why in that interview, why he had recommended changing the draft Casey testimony to falsely state that no one in the U.S. government knew that the November 1985 shipment to Iran contained arms?
No, he still maintained that he believed it was oil drilling equipment at the time, and made the reference I think I've identified earlier about a lie detector test. He did, however, concede that the portion of the testimony, or one of the testimony drafts, and that the chronology, and perhaps he just referred to the chronology, but the portion that described the return of the Hawks as being an U.S.-inspired event was wrong, and that in truth the Iranians were furious with the Hawks that they had received. They were not the ones that they needed, and so he cleared that portion of the chronology. I don't recall him attempting to clear any others, and we were basically taking his evidence.
Senator Hatch.
Thank you, Mr. Chairman. Mr. Cooper, as I understand it, your involvement in this matter was generally limited between November 7th and November 25th, 1986. Is that correct?
Except for my legal involvement, that is my examination of legal issues, which did continue.
So that's a grand total of about 18 days that you really had, other than your legal involvement, that you had an involvement in this.
Yes, it is.
In what you would call an investigation. During that time, it was basically your job to try to figure out what happened. I take it, is that right?
That's what we were attempting to do.
From what you've told us, it appears to me that your effort during the first week to 10 days was went quite smoothly. There wasn't any real difficulty, and you had one of your deputies commence work on the legal opinion that was completed by November 13th or so, and then you met with Mr. Thompson and Admiral Poindexter at the White House, where you were shown a copy of a presidential finding which seemed to authorize the whole affair. Is that correct?
Yes, sir.
Okay, and as I have reviewed the legal analysis that was prepared under your signature, you concluded that the Iran initiative was not a violation of any laws. Is that correct?
As of November 13th, yes, sir, we did conclude that it was proper.
Well, turning your attention just briefly to that legal opinion, Mr. Cooper, can you tell us how you saw Section 501 of the National Security Act as applying to the facts of the Iran initiative?
Well, Section 501 is the reporting requirement under the National Security Act for intelligence activities.
Yeah, it begins to the extent consistent with all applicable authorities and duties, including those conferred by the Constitution upon the executive and legislative branches of government.
Yes, sir.
Based on your study of those words, what do they mean?
Well, those words, when one examines the legislative history, it seems clear that Congress and the President, at that point President Carter, were contesting over just exactly what the President's constitutional prerogatives are. The President Carter maintained that the Constitution permitted him in extraordinary circumstances to withhold prior notice of an intelligence activity. And apparently there was disagreement along those lines, but the matter was compromised, and this is a reference, an explicit statutory reference to the constitutional prerogatives that are at play in the area of national security.
I see. Now, do you feel that under Section 501 that the President, by virtue of his constitutional authority, was justified to withhold prior notice to Congress of the covert arms sales to Iran?
I believe it was within his constitutional authority, yes, sir.
He had a right to do that.
And within the National Security Act.
Okay. Do you continue to feel that your legal opinion is reflected in Exhibit C2 is valid, and that the Iran initiative, regardless of whether it was a good or bad idea, was at least justified as a matter of law?
That legal opinion deals with post-finding events, and yes, sir, my view has not changed with respect to all the events that took place after the finding.
So you feel it's still valid, that legal
Yes, sir.
opinion, and that the actions were at least justified by law?
Yes, sir.
Okay. Whether they're right or wrong.
I rendered no judgment on that in the opinion.
Now, after the first 10 days or so, it did appear, it looks to me like things got a little more complicated for you. On November 17th, that's when you first received a copy of the National Security Council's chronology. You learned for the first time that there had been shipments of arms to Iran on 2 occasions prior to January 17th and to the January 17th finding. Is that correct?
There had been 2 such shipments according to those chronologies.
Then on November 20th, you ran into an even more difficult situation when you had cabinet officers disagreeing as to whether or not U.S. government officials knew about arms being involved in the November 1985 shipment. You had attended a meeting in the early afternoon, which has been described here, of the 20th regarding Mr. Casey's proposed testimony to the House and Senate Intelligence Committees. Is that right?
Yes, sir, it is.
Okay. And at that meeting, Admiral Poindexter, Mr. Casey, and Colonel North all agreed that no one in the U.S. government had known that the November 1985 shipment contained arms. Is that right?
Yes, sir.
They all maintained that, even though they knew otherwise.
Well, North maintained it and nobody objected.
I see. And shortly after that meeting, you were told by Mr. Sofair, the legal counsel to the State Department, that Secretary Schultz recalled Mr. McFarlane telling him in November of 1985 that Hawk missiles had been involved in that shipment. And as I recall, Mr. Schultz even had a contemporaneous note to that effect. Is that correct?
Yes, sir.
Okay, so then after trying your level best to sort out the discrepancy, you decided that evening to get on the secure phone to Attorney General Meese, who was at West Point, and you basically asked him to get back and look this matter over. Is that correct?
Yes, sir.
Okay. And then Mr. Meese returned to Washington early the next morning, and you were informed later in the morning that Mr. Casey's testimony had deleted any reference to the fact that no U.S. government official had been aware of arms involved in the November 1985 shipment. Is that correct?
Yes, sir.
Okay. Now, at that point in time, Mr. Cooper, did you have the feeling that figuring out what had happened might not be as easy as you had originally anticipated or thought?
Yes, sir.
That's when it started to dawn on you that this is a pretty big problem.
Oh, it dawned on me.
Before that?
Yes, it did.
But it certainly became enhanced with that knowledge. Is that correct?
Yes, by then I thought it was a very serious matter.
And then the next day, Friday the 21st, Mr. Meese recommended to the President that there be a further, more expeditious fact-finding effort undertaken. Is that correct?
He did. Yes,
And there
sir.
was reason for that at that point because of what your preliminary investigation had discovered. And then you spent the next 4 days working pretty well around the clock trying to put this thing together. Is that right?
Yes, sir, it is.
Okay, now, it was during that period that the undated memorandum, which is referred to as the diversion of funds memorandum, was found in Colonel North's files. Is that correct? You found it?
Saturday morning, yes.
It was Saturday morning within that 4-day period.
Oh, yes.
You were going around the clock trying to get the fix on this particular set of problems.
Yes, sir.
Okay, what exactly was it about that memorandum that caused you and Mr. Meese to be so concerned? Did it appear illegal to you, or was it bad politically, or just what was it that caused you to gain such great concern? Because there's only really one basic paragraph in here that says $12 million will be used to purchase critically needed supplies for the Nicaraguan Democratic Resistance Forces. This material is essential to cover shortages in resistance inventories resulting from their current offensives and Sandinista counterattacks, and to bridge the period between now and when congressionally approved lethal assistance beyond the $25 million in defensive arms can be delivered. So what caused you to be alarmed?
I think we recognized potential legal implications of that information if it proved true, and certain political implications.
Was there a feeling among your investigating team that the discovery of that memorandum placed an urgency on the situation that really had not been there before?
It I think, intensified the urgency, although, you know, we were quite urgent about clearing up the pre-finding matters.
You were at that point of time, it seems to me, in what I think was a very unique position, because you had the opportunity to call Colonel North and to interview him at that time without his knowing that you knew about the memorandum. You had the advantage of hitting him cold and to ask him if the President knew about the diversion. And as I understand your testimony you've just given in response to Senator Sarbanes, you did ask him that question, and again, repeat, what did Colonel North say?
That indeed the diversion had taken place.
But what did he say with regard to whether the President knew about it?
He said he did not think so, that the President, certainly the matter had never been discussed with the President while he was in the room, and it was his belief and knowledge that the only people in the United States government who knew about this matter in the USG were McFarlane, Poindexter, and himself.
Did he hesitate in answering that question?
No.
Did he?
I don't recall any hesitation.
Was there any indication to your mind at that particular time, or to your vision, that he wasn't telling the truth?
I did not disbelieve him on that.
In other words, you believed what he said?
Yes, I did.
Okay. In your meeting with Tom Green, the attorney, on Monday the 24th, what is it you understood that Mr. Green was asking you to do?
To receive from him some additional facts that were very important that we needed to, I guess, stir into the mix here.
Did Mr. Green ask you to refrain from going public with the details of the operation until after General Secord and Colonel North and Mr. Hakeem had a chance to tell you the full story?
He may well have asked that. My recollection is that he asked us not to go public at all, but at a minimum to accord him some notice prior to the time we were going public.
Why was it then you decided to go public with it at a press conference on the 25th? Give us the reasons for that.
Well, once this matter was shared on Monday, by virtue of the Attorney General's questions of other individuals, including the President, regarding their knowledge, the matter accelerated substantially, and it took me really quite by surprise on Tuesday to be called by the Attorney General and begin the course of events that ultimately led to the news conference. I didn't realize that the matter was going to be made public at that time, notwithstanding the fact that all of us realized that it had to be made public promptly, very promptly.
I see. Now, in hindsight, Mr. Cooper, do you feel that it was a good idea to give the National Security Council staff a full day's notice, really, that Colonel North's files would be reviewed?
It obviously was not.
It seems to me that that was a mistake that was made.
Yes, sir. It was.
Well, Mr. Cooper, I think that your testimony has emphasized, as I view it, some of the serious implication pitfalls that the Iran and Contra initiatives were subject to because of the manner in which they were carried out. Even those persons whose motivations seem to me to have been purely in the best interests of our country appear, it seems to me, to have recognized the folly of some of the means that they employed when those means were fully reviewed in the light of retrospection as we look back on it. It's always easier to look in retrospect and see what happened here. There were half-truths, outright misrepresentations that you encountered in your efforts to get to the bottom of this matter and to find out what happened. And I think they were indicative of what went on at that time, and certainly we can't countenance that. But I think your testimony also emphasizes that the Department of Justice, under the discretion of the Attorney General, did have some good basic instincts in investigating this and jumping right on it. And to try, as you said earlier, as you said, the Attorney General stated, to get your arms around the situation before it got away from you. And I think it's safe to say it did get away from you because of the fast breaking of the process and the problems, and because of some of the misrepresentations and difficulties that you had to encounter. And unfortunately, I'm afraid that when it did get away, your investigation then became part of ours. But I have to say this to you. If you hadn't done as good a job as you did in those 18 days, and particularly those 4 days, I don't think we'd be where we are today with all the knowledge of the facts and information that we have. I don't think the Tower Commission would have had as much information, and I don't think we could have been in the position we are today to basically be in a position to accomplish the end goal of bringing 100% of these facts to light for the American people. So it's easy to criticize. There are only 18 days, and really only 4 that were the most intensive days, but they were around the clock. But I think you deserve a lot of credit for doing what you did do during that time. And I think it's had a good effect in helping us to arrive at a lot of the details and a lot of the facts that we have today. I have a lot of respect for you, Mr. Cooper. I've watched you for the last number of years down at Justice. I know that you're very articulate, very bright. You do a terrific job. And even though some of what you did could be criticized here, in retrospect, what you did in prospect really was extraordinarily good to the extent that you were able to accomplish it. So I just want to compliment you with that. And I think the questioning that I've gone through points out a number of the defects in the system. Thank you.
Thank you very much, Senator Hatch.
The committee is going to take a brief recess, but I just want to caution everyone that because we are running late and the chairman does wish to finish with the witness today, I'm sure the witness would like to finish today, we're going to convene promptly at 4:15.
uncertainties and
In
concerns
other words,
about.
the events to which the finding referred to by way of ratification.
I assume that that paragraph was in there to cover at least the November event. Yes, sir.
Well, obviously, if you got a finding that ratifies previous acts, it had to be some previous act.
Yes, sir. Yes, sir.
So you were setting out to find out what the previous acts were and who had the knowledge of those previous acts.
Yes, sir, although that finding you referenced was in no way an impetus for this. I've already described, I guess, the impetus for it.
I understand. And there were 3 of you altogether that basically had this job.
Oh, no. I assume you're not counting the Attorney General, but the Attorney General was the...
I always count him.
Oh, well, then there was 4. There was the Attorney General, myself, John Richardson, and Brad Reynolds. And I should add that John McGinnis of my staff was a full member of this, even though he did not meet with the Attorney General during the whole time.
Now, in response to Senator Hatch, I got the impression that you kind of coasted along easily for about 10 days. Then all of a sudden you found something. And I assume that what it was you found, based on my recollection of your answers, was you ran across a memorandum that all of a sudden turned you guys on night and day, 24 hours around the clock. Is my impression correct or incorrect?
Well, we weren't turned on night and day on November 17th. We, however, were alerted to the pre-funding events, I think, by that time, by November 17th, and we definitely wanted to inquire into all the facts we could on that score, because those were the legal sore spots.
Now, which did you do first as part of this investigative team? Did you interview people or you look at documents?
Our first activity after the Attorney General got his commission from the President was to interview Mr. McFarlane. But contemporaneously with that, we were trying to identify the documents that we would need to look at. We've already discussed the fact that we anticipated reviewing all of the NSC documents, and we asked that they be gathered and made available. We also, that evening, went to extraordinary lengths to review certain materials at another agency, materials with which this committee is familiar. I also was in touch with Dave Doherty in an effort to obtain from them any documentary materials that they might have as well.
Did I understand then that...
The CIA, that is.
That on or about the 24th or whenever it was, that Sunday, while the Attorney General was at West Point, you came across differences in statements or positions or recollections that troubled you?
Yes, sir.
And you called the Attorney General on the telephone and said, you better get back here and straighten this out?
Yes, sir, that is true.
I see. Now, on the 25th, the Attorney General went public, am I correct?
Yes, sir.
And he made it clear with a disclaimer that this investigation or study was not totally complete, but he had some statements to make.
Yes, and then actually he kept referring to the fact that the status of our knowledge was continuing to be improved.
It was a sensible disclaimer, in other words.
Oh, yes, yes.
Now,
I thought.
Your recommendations, your findings, your observations to the Attorney General were made how? Hourly? Daily? Over the telephone? In writing?
During that weekend, they were made quite regularly, not in writing, but there were conversations just repeatedly, and we were meeting all the time and discussing the matter. And
all right, tell me what you recommended to the Attorney General, please, sir, about the knowledge of people who were involved that you had interviewed. Poindexter, McFarlane, anybody else that was, quote, in the White House. What did you tell the Attorney General?
Well,
I mean, you did have a briefing, am I correct? I mean, you had to brief him before he went on television, before he went before the media.
the Attorney, yes, but the Attorney General was at the center of this whole weekend. I didn't have to brief the Attorney General. We were briefing, you know, this was an effort wherein the group would receive information. You know, each member of this group that received information would then gather and collect it and discuss it, what have you. I didn't have to brief.
Excuse me for interrupting you, but my
Yes,
time
sir.
is so limited that
Yes.
I'm trying to visualize how you did this in the excitement of the last 3 or 4 days that Senator Hatch was talking about. Was there a command post in the in the Justice Department in which the Attorney General sat so that you could get to him immediately, make decisions about what was going on or the information he had to have? Or was he conducting business and you reached him by telephone? See, I don't know how this excitement carried on in order to keep the boss, the head man, totally informed, so that whenever it was that he finally went out there on November 25th, he knew so much about it, you didn't even have to brief him.
Because the Attorney General was a hands-on participant. In fact, the dominant and moving force participant of the entire effort. He interviewed McFarlane. He interviewed North. He interviewed Schultz.
You were there the whole time.
I was there for those, yes, sir. He, you know...
And that was the basis of him making the statement that they didn't know anything about them.
I beg your pardon?
That was the basis for the Attorney General making a statement that the people that you just named and others did not know anything about the prior events that you were investigating. Because that's what he said.
I don't recall that, but...
Well...
How's that?
He said, according to this transcript of the Attorney General, assuming that it's accurate, and I'll assume for the moment that it is, and if it isn't, the transcript itself will be the best evidence. General Meese, who in the NSC was aware that this extra amount of money was being transferred, etc., or under their control? Did Poindexter specifically know? Who else knew? Did the CIA know? Was the CIA Director William Casey aware of this? Answer: the only persons in the United States government that knew precisely about this, the only person was Lieutenant Colonel Oliver North. Admiral Poindexter did know that something of this nature was occurring, but he did not look into it further. And one, if I could follow up on, sir, what about CIA Director Casey? It says CIA Director Casey, Secretary of State Schultz, Secretary of Defense Caspar Weinberger, myself, and the other members in the NSC, none of us knew. Was that based on your recommendation?
That is entirely consistent with my knowledge of the facts.
Right. Now, did you also decide that the diversion of money that occurred was U.S. money?
No, sir.
I see. Well, I misunderstood you then.
No, we certainly developed a serious enough concern that it was that we launched a criminal investigation, or an investigation was initiated into potential criminal liability.
But you weren't sure, is what you're telling me.
That is true.
Well, did you brief the Attorney General on that issue, or did he just decide to go public on his own with that?
At that point, whether this was U.S. money was something that, you know, there was... In fact, the Attorney General at that point seriously doubted it was. But there was a sufficient possibility that the potential criminal implications could not be discounted, and we pursued a criminal investigation.
All right. Mr. Chairman, let me finish this reading, if I can, from this transcript, because I think it's important if this Mr. Cooper says it is consistent. Question was, could you say that since that money was owed to the U.S. government, the $30 million or $40 million, are you going to? Answer: No, it was not owed to the United States government. All that money was owed to the United States government, was paid to the United States government. There's no if, and, buts, or doubts on that statement. Question: are you going to require that the additional money that went to the Contras go back to the U.S. government? Answer: we have no control over that money. It was never United States funds. It was never the property of United States officials. So we have no control over that whatsoever. Now, what you're telling me is that's totally consistent with your investigation.
In fact, when the Attorney General said that, I was concerned. I was concerned.
You had a reservation, but the Attorney General didn't.
He did. I had a reservation, and the Attorney General later, in his press conference, I was pleased to hear, suggested a couple of times with respect to that fact specifically, that our examination of this continues, whether or not these were U.S. funds. Your reading of the transcript, however, is certainly comports with my recollection of the press conference.
Thank you, Mr. Chairman.
Thank you very much. Before proceeding, without objection, documents identified as exhibits SS-19 through and including SS-21 will be made part of the record. Senator Cohen.
The candid testimony here today. Congressman McCollum, I thought, engaged in some rather perceptive examination, a line of examination earlier this afternoon. And as I understand it, you said that based upon your understanding of the statements by Colonel North, Mr. McFarlane, Admiral Poindexter, an attempt was underway to construct a false and misleading chronology as to the fundamental facts involving the United States participation in the sale of arms to Iran. Is that your conclusion?
We certainly now know that to be the case. Yes, sir.
And when Mr. McFarlane talked about gilding the President's record, that was a reference to trying to insulate the President from having any role in the sale of the weapons to Iran?
I'm not acquainted with that reference.
Mr. Leon, I think, engaged in an appropriate metaphor. He said it was as if you were riding down a fast-moving river or stream, and I think that was an appropriate way to describe it. I would change it a bit and conclude that Colonel North and the others were attempting to take you over Niagara Falls in a barrel with that particular chronology they were providing you.
I think that's entirely apt.
You think that's apt?
I certainly do.
Now, with respect to the diversion memo, you indicated this was a fairly significant event, the revelation about the diversion memo. In fact, it prompted the Attorney General to engage in an expletive deleted, if we can.
And that is very, very rare.
That's very rare. And so it was something of substance on his mind, you would conclude, as of noon that afternoon. But that evening, he went to visit Director Casey at Mr. Casey's home. Are you aware of that?
On Saturday afternoon?
That evening.
Oh, yes, I am aware of that.
Would you have expected him to ask Mr. Casey about the diversion memo since it was such an explosive item?
Not necessarily, but it would not have surprised me if he did ask him about it.
Would it surprise you that he didn't ask him about it?
It doesn't really surprise me that he didn't, no, sir.
Why would something of that significance that caused him to utter an unusual expletive deleted and perhaps dominate the conversation at that point suddenly dissipate over a few hours, not to be raised to the Director of Central Intelligence as to whether he was aware of a diversion of money to the Contras?
I don't know what went through the Attorney General's mind when he made the decision not to ask that question. I do know what went through mine when I made precisely the same decision not to ask any questions of that kind as I dealt with people on Sunday morning, and Friday night, on Sunday morning, a number of people at the CIA, and I know what went through my mind on that.
Well, I'll ask you that in just a moment.
Okay.
You've given the committee an impression of Mr. McFarlane, Mr. Charles Allen, in terms of their candidness during the course of your investigation. I think you characterized them as being less than candid in response to some of the questions.
Only that was my impression, yes, sir.
Well, was that your impression?
It was, Yes, sir.
You didn't refer to your impression about Colonel North's activities. And I wondered because apparently he was prepared to send Mr. Casey into the breach armed with a deliberate lie, namely to send him up here to Capitol Hill to testify about a matter which would be a deliberate lie. What is your impression, or what was your impression at that time, having learned of that attempt to do that, with respect to his candidness or quality of testifying?
Well, I find the event most regrettable and the whole thing quite inconceivable, actually.
One other point I'd like to raise, Mr. Chairman, is an exhibit I would like to offer into evidence. Mr. Cooper, you drafted on December 17, 1986, a memorandum for the Attorney General, and it deals with the timely notification requirement of Section 501B of the National Security Act. And if I could, I'd like to summarize what I believe your conclusions are, and if I'm incorrect, you may certainly correct me on it, Mr. Cooper. But I think you indicated that, in essence, since the statute acknowledges the President's right to not to give prior notice, it necessarily follows that the President has sole and absolute discretion to determine what constitutes timely notice after the action is underway. And that timely notice could be a matter of days, could be a matter of weeks, it could be a matter of months, or in this case, even a year and a half before the so-called Gang of Eight were notified, because you give the total discretion to him until the action is actually terminated or completed. And I would concede one point. You indicated that Section 501B is clumsily drafted, and I would concede that 501B might be clumsily drafted. But the fact is that even if we were to employ the considerable talents of someone like yourself and to draft it in a very concrete fashion, that under your interpretation, Congress could not constitutionally require the President to report a covert action within any specified time period. So even if we didn't draft it clumsily, we still couldn't draft it in a way to specify a time frame. Now, Senator Nunn made a very, I think, important point yesterday. He indicated that Congress necessarily has to recognize the need for flexibility in giving the President as much as possible in covert actions, and I agree with that. But unfortunately, flexibility is too often taken as license. And then, after the fact, it's rationalized as a constitutional power that cannot be diluted or diminished by congressional action. And that leaves Congress with two essential options. One option is to treat the presidency as a monarchy with absolute powers in foreign policy. That might be what I would lightheartedly call the Hyde view. The second option that we have, I put him on notice so he knows I'm going to say that. The second option would be for Congress to refuse to appropriate any funds for covert actions in the future, which I believe would be a mistake and a serious one, and I would call that the hidebound rule. And I think that comedy is important, but it has to run in two directions on Pennsylvania Avenue. And if it doesn't run in two directions, I think that we're going to find ourselves in a very debilitating, confrontational paralysis, unless that comedy flows in both directions. And unfortunately, I find under your interpretation, you may be correct, under your interpretation of the notification requirement, we really don't have much in the way of options other than those two, and you may be correct. I hope it's not the situation. I would offer this, Mr. Chairman, as an exhibit in the record.
Mr. Chairman, may I have just a moment for a response?
Please do.
First, I'm duly chastened by your reference to my use of the term clumsily. I wish I had not used it, obviously, now, and I should not have used it then. I make no pretense that I could draft a statute in this area with any greater precision than the Congress did when it did in 1980. I think that the theme of this opinion, and certainly my own opinion, is that the President has to have the discretion to decide when notifying even the 8 the so-called Gang of Eight of a covert intelligence activity will not jeopardize the success of that activity. He is the only one he is the only one with information on that question and on which a sensible and deliberative judgment can be made. And if the President is going to be the principal and dominant branch in the foreign affairs field, which I think our history suggests that he is, and common sense suggests that he should be, then that kind of constitutional discretion has to be accorded to him.
Could I just interrupt for one point?
Yes, sir.
Just to point out that in your analysis you made it very clear that Congress did not distinguish between short-term types of covert actions or long-term types of covert actions, which this one conceivably could be over a period of years of trying to establish a relationship with Iran, and therefore, under your interpretation, until that action were in fact completed, which may last for years conceivably. And there was discussion about when notice could be given when the President finally leaves office, there would not have to be any notification until that time. And it seems to me that that is a very expansive view of the timely notification requirement.
And I would pull back from the outline that you have just given. The requirements of secrecy. When a President is dealing with a situation as I believe the President believed he was dealing with, here, the requirements of secrecy extend, certainly in this case, to the potential loss of lives and American lives, as well as individuals with whom we were, as the President was given to understand, trying to develop a constructive relationship. And on the question of comedy, I am very sensitive to your point, and I think that comedy should be the hallmark of the relationship between this body and the executive branch, and that one need not have a law like 501 for the President in matters of sensitive intelligence, national security, and foreign policy concern would visit with the Congress and receive its advices and its consultations. But this President, as I understand it, has on every occasion, and there are members of this body who are acquainted with other covert operations, and it would be improper for me to suggest a number, but are acquainted with the fact that on every prior occasion, this President made known his intent to engage in some kind of covert operation, as I understand it, as I've been given to believe. There is precedent established by the previous administration wherein on a couple of occasions prior notice was not provided. This President did exert what is his constitutional prerogative to make that extraordinary and hopefully very rare decision. It's easy in the aftermath of it to second guess it and criticize it, but the fact is, unless he has the authority and the discretion to do it when he believes it is necessitated, then he really can't engage in these activities at all, and they're in the national interest. I'm sorry for droning on like that.
Mr. Carter.
Thank you, Mr. Chairman. Mr. Cooper.
Yes, sir.
You said that with respect to the November Hawk shipment that was carried out by Israel to Iran, that when you and Ed Meese spoke with Oliver North, John Poindexter, and Mr. Casey, that they were less than candid with respect to that, and in essence either lied or did not correct a lie that was being uttered by one of the three.
That's That is my belief.
Do you know whether any one of these individuals, Mr. Poindexter, North, and Casey, lied to either you or Mr. Meese about the diversion of profits from Iran weapon sale to Central America?
I guess I need to back up because I'm not at all satisfied that Mr. Casey knew about the Hawks. It's possible that he did, and we've heard, and you may know better than I do, but I don't have information to that effect. No, I do not understand that Mr. North, when we were interviewing him, lied to us about the Contra diversion. He conceded that it had taken place.
In your investigation, did it uncover any other written document or memorandum or letter that referred to either directly or indirectly the diversion of monies from Iran to Central America?
I don't recall it if it did, but I did not go through personally the NSC documents, the documents we got from NSC.
Referring your attention again to the first part of my question with respect to the lack of candor, at least on the part of Mr. North and Mr. Poindexter, if not Mr. Casey, on the Hawk shipment, can you posit to me a credible reason why they would be less than candid? I can think of 3 reasons why they would, and 2 perhaps why they wouldn't. One reason, obviously, is the fact that if they were less than candid, it would be a lie. Now, the second, they were talking to Ed Meese, who, and since it was his department that drafted the findings, surely knew of the arrangement about weapon sales to Iran. And third, they were knowledgeable of the fact that Ed Meese was specifically appointed by the president to bring all the relevant information to the president. It would be like lying to the president. There's 3 good reasons why they should have been candid to you. Can you think of any reason why they were not? What were they trying to accomplish by that?
To keep, to prevent or at least to delay the truth of the matter from surfacing. It was, I mean, that was apparently their purpose. I really don't have a good sense for what was the immediate motivation, what personal goals or purposes they sought to accomplish.
That was the result of their not being candid or lying, but I just don't see that that's a motive at this particular juncture when the whole world is falling in, when the President of the United States is on the line, when he appoints Ed Meese to gather all the facts. It's just not logical to me. The only 2 reasons I can think of is, number 1, protecting Israel at the expense of the government of the United States, which doesn't seem logical. And the other reason, and I'd like your opinion on this, is perhaps they felt that the presidential finding had no retroactive effect and therefore did not cover the first shipment.
That well may be what they concluded, and this was some kind of an effort to keep from disclosure the failure to get a finding for the November matter. That's entirely possible.
I see that my time is up. Thank you very much, Mr. President.
Senator Heflin.
A couple of your colleagues about discussing with Mr. Green on Monday, November the 24th. It's my understanding that there was a second time that Mr. Green came to the Department of Justice and discussed with you the events and Mr. Reynolds. In order to save time, I'm reading from a memorandum of an interview with William Bradford Reynolds taken on, the date of it's May 18, 1987. This memorandum states of what Mr. Reynolds had told the committee investigators. On Monday, December 1st, Reynolds was called by Green a second time. Green stated that he wanted to talk with personnel at DOJ before the government did anything stupid like seeking the appointment of an independent counsel. Green had called Reynolds in the morning. They met in the afternoon, In addition to Cooper and Reynolds, William Hendricks of the Public Integrity Section attended the meeting. Is that a correct statement?
No, sir. I do not recall having attended that meeting. I do not believe that I participated at all in that meeting.
So you do not recall any of the contents of what might have been discussed in the meeting with Mr. Green and Mr. Reynolds on Monday, December 1?
That's correct.
All right, sir. Let me ask you this. You testified about Colonel North telling you at some time, and maybe in jest, that he had gotten a lawyer. When was that in relationship to the discovery of the diversion memo, which was on the Saturday? Was it before that that he had said that, or was it after that on Sunday when you were part of the team that interviewed him?
He said that to, it was reported to me, he said that to Brad Reynolds and John Richardson sometime prior to the time they came to lunch. Or at least it's my recollection. I learned of it at lunch.
In other words, before the diversion memo was discovered?
No, they had already discovered the diversion memo, because it's my recollection that I learned at lunch of both of those matters.
Now, after you learned of the diversion memo and before the criminal division was called in, was there any other information that was gained that would indicate that there might have been violations of criminal law?
Yes, sir. We attempted to find out from the Department of Defense facts and the process for Economy Act transfers. Those are transfers between one agency to another. And the transfers of these arms that ultimately got to Iran were from the Department of Defense under the Economy Act to the CIA. They then went at the Economy Act price, ultimately, to Israel or Iran. In other words, the CIA received the Economy Act price for them. What we were wondering is whether that price is full and fair market value. Did the United States taxpayers receive everything they were entitled to from these arms? And if not, could it be said that the amount that they did not receive that was full and fair market value was therefore due and owing to them and could be said to be U.S. monies? Now, since then, that was the analytical process that we were engaged in at that moment. And we were, reference has been made to my conversation with an assistant secretary at the Defense Department. I had conversations with the general counsel at Army, Susan Crawford, a couple of them, and in fact she brought over about half a dozen military men to my office Monday or Tuesday night, I can't remember which, and outlined in detail these particular transfers and the Economy Act implications of them. We were trying to figure out the money on this. Subsequently, it became my opinion that that really wasn't particularly relevant, all of that. That in fact this was a transaction from the United States to Iran, not from the United States to Israel. We came to the view that this was not a situation where we were in essence selling to a retailer in Israel, and Israel in turn turning around selling to the ultimate purchaser. So we came to the conclusion that a good argument could be made that the monies, the price charged for these arms were due and owing to the United States, minus any reasonable fees or costs incident to the transfer among whoever might have been participating in it. But that ultimately became my view anyway.
Mr. Cooper, only one last question. The Attorney General has been criticized by some for the failure to give the Miranda warning to Colonel North as he interviewed him. What is your position relative to that?
I have to confess that Miranda warnings never entered my mind, and it was not a matter that any of us discussed, but I suspect that it didn't enter anyone's mind. We were interviewing with respect to Colonel North, the President's staff, a member of the President's staff. There was no criminal investigation. It was clear that nobody was insisting that Colonel North be with us. He was not. There was no coercion. He was not under any requirement to be there. In fact, we postponed, now much to our chagrin, evidently, his interview at his convenience. It just didn't occur to us, Senator Heflin. Maybe it was a mistake. I don't know, but I don't think that it was.
That's all, Mr. Chairman.
Mr. Stokes.
Thank you, Mr. Chairman. Mr. Cooper, I've seen some documents that indicate that you believe that with reference to covert action policy that you can have oral findings. Is that correct?
Yeah, I do believe that, yes, sir.
Right. And what do you base that upon?
A lengthy, thoroughly researched analysis and an opinion that I've provided to you, I believe, and dated December 17th.
All right. Now, are you familiar with a document known as NSDD 159, the National Security Decision Directive, a classified document?
I know of its existence. I would not be able to describe it to you, but that title is familiar to me.
Okay. Let me tell you, yesterday, Chairman Jack Brooks put into the record a copy of that document. And it's signed, it's dated January 18th, 1985. And I have an extract from the document which reads, Covert Action Policy Approval and Coordination Procedures. It further reads, Approval Procedures for Intelligence. 1. Presidential findings. The President shall approve all covert action findings in writing. This document is signed by the President of the United States and has now been declassified for the purpose of these hearings. You're not familiar with that document?
As I say, now that you remind me of it, I am acquainted with the document.
Okay. Now, if the President has in fact signed this directive, do you still think that he can sign, that he can approve oral writings, oral findings, rather?
Well, I think that he can. I don't think that there's any statutory limit on his ability to do that. The NSDD is a internal intra-branch directive, and obviously the President can deviate from requirements that he places upon himself.
It doesn't make much sense, does it, for the President to sign a directive that all findings must be in writing and then say, oh, I'm not going to follow my own directive? That doesn't make much sense in government, does it?
Well, presumably, he had good reason for requiring them in finding and a finding in writing, but I don't think it changes the fact that he can deviate from his own requirement.
Let me ask you this, Mr. Cooper. Is there any doubt in your mind today that the chronologies that you were first given in November of 1986 were designed to cover up the 1985 November Hawk sales to Iran?
Yes, I believe they were designed to portray a fictitious portrayal of those events.
And had Director Casey given to Congress the testimony in that November 20th draft, he would have perjured himself, would he not?
No, sir, I don't know that to be the case. He would have reported to the Congress a fact that was not true, but whether he would have reported to the Congress a fact he knew that that it was untrue is a different question. Somebody, however, would have been responsible for, ultimately responsible for providing to the Congress a fact known to be untrue, which would be perjury.
Even the testimony as of the 21st of November, the revised testimony, as you look back at that testimony, was it complete and factual, that testimony which was given to us?
No, sir, it was not. I'm sure it was not complete, although I think that insofar as it did, at least I was quite confident when I left the CIA that those facts that it did report were factual, or I had no inkling that they were not factual.
Right. And lastly, when you and the Attorney General interviewed Colonel North, he was not under oath at that time, was he?
No, sir, he was not.
Okay. Based upon your testimony here today, would you agree that, or evaluate the testimony that he gave you at that time as being false?
I believe it was false in some respects, yes, sir.
Right. Based upon everything you know about Colonel North, as a result of your contact with him, your interview of him, let me ask you this: would you believe him under oath?
Congressman, I would not, but I personally don't believe an oath in any way enhances the obligation of truthfulness.
And in effect, you're saying you would not believe him, whether he's under oath or not.
That's, well, I have to regretfully say that. Yes, sir, I have to say that.
Thank you very much, Mr. Cooper. Thank you, Mr. Chairman.
Thank you very much, Senator Boren.
Mr. Chairman, Mr. Cooper, let me say that in a series of proceedings in which we have often been confronted by disappointing lapses of appropriate standards of behavior by public officials, I want to congratulate you both on your testimony and on the very sincere way in which you conducted yourself in the course of the inquiry, in which you were given some responsibility. I think it's clearly come through that you have acted with integrity. When you found that it was planned to give misleading testimony, you did everything in your power to try to prevent that from happening, and that you conducted yourself in an appropriate way, and I want to express my appreciation to you for your behavior during that period of time.
Thank you very much, Senator Boren.
And to follow up on one question that was referred to by Senator Cohen, you mentioned, Senator Cohen asked you why you thought, after the shocking disclosure of the diversion memorandum, that the Attorney General did not question Mr. Casey about the diversion or his knowledge of diversion when he met with him later that day. You indicated that you also did not ask questions about diversion immediately afterward to those that you were asking questions, and that you had your own reasons. I wonder what those reasons were.
I thought Senator Cohen was going to let me off the hook on that one. I guess they were twofold. First, whether or not the Contra diversion was a fact was something obviously we did not know from the memo.
Yes.
But also, I thought it important that that the questioning of Colonel North on that point be questioning that, if at all possible, kind of take him unawares on that question.
So you did not want to mention the diversion or the fact that you knew about the diversion to anyone else, because it might then have been, that information might have been transmitted to Colonel North before you had a chance to question him.
I did not have confidence that it would not
Yes,
be.
understand. I'd like to go back now to the question of the money. You indicated that, in your opinion, the funds generated, even though a third party might have been used or a commercial cutout, as it's been referred to in earlier testimony in the finding, might have been utilized, that if property of the taxpayers of the United States was sold, you felt ultimately that the taxpayers were entitled to have whatever was paid for that property returned to them less the normal costs of or expenses of carrying out that operation. Is that still your opinion?
Yes, sir, it is, less whatever fees or costs were properly agreed upon
right.
between the United States and whoever it was that assisted in this matter.
So in this case, we've had earlier testimony from General Secord and Mr. Hakeem that would indicate that these weapons, the major sale, total sum $30 million in terms of what they received for these weapons. They also indicated to us that they experienced, if we take them at their word and accept their figures, $3.1 million in expenses. We know the government was paid back $12 million, so if we add that 3.1 onto it, that's at least $14.9 million. Now, there are some funds. We've received various estimates, somewhere in the range of $8 million, apparently still in the Swiss bank accounts of various companies that we collectively call the enterprise. It was in charge of actually selling these weapons or transmitting these weapons and transferring them. In your opinion, then, would those funds, or as much of the $14.9 million as we can possibly recover, would that be the property of the United States government?
It certainly possibly would be, and I really don't want to, and I think that would depend upon the factual background, but it very certainly, possibly, and even likely would be, in my opinion.
Do you know, we have taken action, this committee, in fact, took action to request that certain equipment be returned that was still in the custody of the enterprise. In your opinion, would it be appropriate for the Department of Justice to take under consideration whether or not to make a formal request for a return to the Treasury of the United States and the taxpayers of the United States of any funds that are proceeds from that sale once the legitimate expenses have been paid, so that they could be returned to the taxpayers? As I understand it from hearing Mr. Hakeem and General Secord, they've not received any kind of official request other than the statements that some of us have made as individuals that we think they should return that money to the taxpayers.
And you're asking if it would be appropriate for the department
to consider whether or not to make such a formal request and to lay claim to those funds for return to the taxpayers.
Actually, I think under the circumstances of that now prevail with the independent counsel, it probably wouldn't. But I should think that the independent counsel is pursuing all those avenues that are appropriate to be pursued.
But if these funds, and I will just cease with this question, Mr. Chairman, if those funds really are the property, or possibly the property of the taxpayers, as some of us believe, at least if they're not all the property of the taxpayers, we should certainly be collecting some taxes on those proceeds if they're indeed private profits. Shouldn't the government of the United States be taking some steps to protect the interests of the taxpayers, or at least be examining the possibility of taking some steps to make sure that when the legal proceedings are all concluded, that we will be able to make an appropriate, take an appropriate action to protect the interests of the taxpayers in getting that money back?
Absolutely, Senator Bourne, and I really have every confidence that all appropriate measures are being taken by the independent counsel.
Thank you, Mr. Cooper.
I wish to announce that members of the House panel have left the hearings to respond to a roll call which is now in progress in the House of Representatives. Senator Rudman.
Thank you, Mr. Chairman. Mr. Cooper, I want to join in with my colleague from Oklahoma characterizing your testimony today.
Thank you.
And I may sound critical of some things, but I am no way being critical of you. I want you to understand that you find yourself in a situation, and I believe you did the best you could under the circumstances. I am struck by one part of your testimony, and I think Congressman Stokes got to the very heart of it when he asked you about Colonel North and his credibility to you. At that meeting, Mr. Casey aside, Attorney General Meese, chief law enforcement officer of the country, was there with you, and you were trying to determine the facts for the President of the United States. Am I correct?
At the meeting in Poindexter's office?
No, I'm talking about the meeting in which the denials were made of U.S. participation, attempts were made to change the documents and so forth.
In our interview of Colonel North Sunday evening.
I'm talking about the meeting at the White House, I believe it was November 20th or 21st.
Yes, in Admiral Poindexter's office, yes.
And who was present at that meeting?
Admiral Poindexter, Mr. Casey, somebody with him, me, the Attorney General, Paul Thompson, Colonel North. I think that's all.
And statements were made to you in that meeting that you now know, and we all know, were patently false.
Yes, sir.
And at the time, the Attorney General of the United States was there on an assignment from the President, not only as the President's chief law enforcement officer, chief legal officer, but as one of the President's very close and longtime friends. Am I correct?
Actually, Senator Rudman, that is the meeting that led to the discovery of a discrepancy, and not until the following day did the Attorney General go to the President and say we've got a problem that has to be ironed out pronto.
No, I understand. I'm not leading to that at all.
Oh, yes.
I would not anticipate where I'm going because I'm not sure you know.
I just I'm sorry, I was confused.
And at that meeting, under several lines of questioning, deliberate attempts were made to deceive the Attorney General of the United States.
Actually, there was no questioning at that meeting, and I think I must be confused about the meeting you're referring to. At that particular meeting, we were going over Director Casey's testimony, and yes, some deliberate falsehoods were obviously told, but there was no questioning of it. North was understood to be the only person there with any basis for knowledge of the facts. And so nobody questioned him when he said no one in the U.S. government knew that there were hawks on this plane. Nobody questioned him. And
Admiral Poindexter heard him make that statement.
Yes.
And Admiral Poindexter obviously knew at that time that statement was false.
Yes, he did, it appears.
Mr. Casey, we don't know about. We will leave it at that.
I do not know about.
So the President's National Security Advisor and one of the top assistants to the National Security Advisor are telling the Attorney General, either by active misstatement or by silence, facts which are patently false, correct?
Yes, sir, I think that's correct.
What strikes me is why they were doing it. They knew the Attorney General was there on behalf of the President. Am I correct?
No, actually, he wasn't there on behalf of the President. He was there as the Attorney General, as someone who had participated in at least a minor way in the inception of the Iran initiative, and who himself had some factual background and some factual contribution to make with respect to that very minor element of it, but he had not yet been deputized, so to speak, by the President to get his arms around this problem.
I understand that, of course. But the Attorney General, Mr. Cooper, is the chief law enforcement officer. Whenever he appears in any office in this town, he is representing the President of the United States.
Yes, and in that sense, certainly you are correct.
And my point, of course, is that when these two gentlemen who are, quote, loyal servants of the President are either lying by deliberate misstatement or deceiving by silence on a key point. Were they protecting the president?
I don't know what their motivation was.
Well, do you perceive that by that deception they were helping the president?
Oh, no, sir. We have evidence here before us to the effect that they were not, in many, many ways.
So if they obviously wanted to help the president, they certainly were not doing it in what you might consider to be a proper way.
No, sir, I don't
As a
think
matter of fact, they were serving the president very poorly. Am I correct?
That is my opinion, sir.
And further, the president has a period in there which we all look at with aghast, making statements which, in my view, the president believes are true, but the president is not being told the truth by his own people. Am I correct?
I think that's accurate.
Chairman, if I could have one more minute. Just make an observation here. You have a very distinguished background. I believe you clerked for Justice Rehnquist.
Yes, sir.
You were in a major law firm, I believe, here in the city.
Actually in Atlanta, Georgia.
In Atlanta.
Yes, sir.
And you practice corporate law of some sort, administrative law?
Corporate commercial litigation practice, yes, sir.
Mr. Reynolds, also a very distinguished lawyer with an excellent reputation, Civil Rights Division, major law firm.
Here in town. He's the one who was here.
Civil litigation, corporate administrative experience.
All of those things. The Solicitor General's office in the 70s.
The gentleman who was with you, Mr. Richardson, a very young man who essentially his legal career has been with the Justice Department.
That's true.
The Attorney General of the United States, although at one time in the distant past a district attorney, assistant district attorney in California, that was a long time ago. No recent criminal law experience, correct?
I expect that is true, yes, sir.
And with all of the signals that you had, and there were some pretty good signals, and I think this is not a hindsight, this depends on what your background is. And I say I'm not in any way being critical of you, Mr. Cooper, because I think you deserve a lot of plaudits from people. But in fact, on November 20th, you had an indication that somebody was trying to do something with testimony. That was your first warning, made you a little nervous, uneasy. November 20th, you find out that Schultz knows something that evidently nobody's telling you about. And then you go on Friday and you find out that the CIA knows something about a pilot knowing about hawks. And the next day, mid-afternoon, you start to have the diversion memo. So you have a whole lot of signals coming your way, but nobody recognizes the signals for what they eventually turn out to be, correct?
No, I think, Senator, we didn't recognize them at that instant.
Well, let me just ask you this question.
We recognize.
You know Stephen Trott?
Certainly.
You know Bill Weld?
Yes, sir.
You know a lot of senior FBI people?
Yes, sir.
I would submit to you, Mr. Cooper, and again, I say this to you not critically. It can't criticize you. You were put on this assignment. That you didn't have the right people on the team, that they're an experienced FBI agent, an experienced criminal prosecutor, a good detective from the 3rd Precinct of Washington or from the New Hampshire State Police, listening to this story unfold would have raised immediate questions about somebody is starting to cover something and why. Isn't that reasonable for somebody who was experienced?
We raised those questions. We recognized that possibility. Our effort immediately was a mistake had not been made insofar as we could see. A mistake was in the offing. It was clear, but we wanted to prevent it.
The records weren't sealed, which is the first thing any criminal investigator does when things like this happen. I'll tell you.
Sure it is, but we were not in a criminal investigation.
Well, of course you weren't, because neither you nor Mr. Reynolds nor the Attorney General nor Mr. Richardson had come close to a serious criminal case, either ever or in your recent career. And I don't say that critically. You're a very good lawyer at what you do, and you shouldn't be expected to know that. I will wind up, Mr. Chairman. You know, I think what happened here is it was almost like we had a group of the world's best cardiologists trying to do neurosurgery. It just doesn't work. And I will never understand, and I intend to ask General Meese when he gets here, why didn't you get Bill Weld or Trott or a 20-year FBI veteran or somebody on the team, because you had to assume at some point that something had a very strange odor to it.
We obviously came to that distinct conclusion, and we took the appropriate action, and I think we took the appropriate action when it was warranted.
You did the best you could, but by the time you took the action, and there's other evidence you are unaware of, and only the committee is aware of, about shredding, you will hear other evidence that I think will make you feel even probably worse than you feel now. By the time you got to looking at things, there was enough shred to fill up a half of a boxcar. And you telegraphed what you were doing to North on Sunday morning or Sunday afternoon, and North knew exactly what to do when he heard what you had. Thank you, Mr. Chairman.
Mr. DeWine.
Thank you very much, Mr. Chairman. Mr. Cooper, during these hearings, I've tried to assume a posture or position of listening to the evidence and waiting until all the facts came out before making some conclusions. I hope I've done that, and frankly, I intend to continue to do that. But based upon your testimony today, and based upon the other evidence that this committee has heard in public session, I think several things are abundantly clear. First of all, I think the evidence clearly shows that Ollie North lied to the Attorney General of the United States. I don't think there's any doubt about that. I think the evidence also clearly shows that Bud McFarlane lied to the Attorney General of the United States. And it further shows that Admiral Poindexter, at best, failed to speak up when he was hearing what to him had to be very clearly lies. The evidence, though, also shows that the Attorney General of the United States is really the one who blew the whistle. He's the one who went to the President and said, Mr. President, in essence, I don't know these are the exact words, but in essence said, we've got a problem. I can't get a straight story. We're getting different stories. We've got to find out what really happened. We've got to find out what the truth is. The evidence clearly also shows, in my opinion at least, that after that it was the Attorney General's men, his own men, who found what has been thus far the key document, namely the diversion memo. That in fact it was Brad Reynolds, and we can talk about whether you all had a lot of experience in the criminal area or not, but it was the head of the Civil Rights Division who ultimately is the one who actually grabbed this document, hid the document, got it out of there, and turned it over to the Attorney General. And then it was the Attorney General who went to the President of the United States and reported on what was going on and what your investigation had disclosed. I think the evidence also clearly shows that while you have been criticized, that at least in my opinion, hindsight is always wonderful. You all have been criticized for conducting too quick an investigation. You've been criticized for conducting too slow an investigation. You've been criticized, some people on this committee have criticized you and said, well, what you should have done is you should have called in the Justice Department's criminal division. You should have got the FBI involved very quickly, and you all should have backed out of it very quickly. Maybe that's true. But again, hindsight is always 20/20. You've also been criticized for not doing a thorough enough investigation. In fact, an allusion today was made to the fact that you had not uncovered certain evidence, and that this committee was able to uncover a lot of different evidence that you all were not able to uncover. That's true. But this committee, committee staff who've done, I think, a very, very good job of investigating this, the basic facts are that this committee staff has been at work for months. The facts also are that, according to the count I get, that we have a staff of over 125, and that staff is growing as we work. And it's a good staff, and it's a staff that's done its job. But I think we need to point that out to keep everything in its proper perspective. Let me talk, if I could, for a moment about the criticism. Like several other members on this panel, I'm a former prosecuting attorney. I've been involved in a lot of investigations. I've been involved in investigations where, when we started out, we really didn't have a criminal focus. And I know, and can tell the committee and tell all of us, that it is tough to determine when that focus exists. And at some point, as an investigator, you make a decision, yeah, this is a criminal case. Yeah, we've got to do the things that we need to do. There's a focus, as the law talks about. We've got to give Miranda rights. We've got to do this and thus. But it's not really clear, and it's always a judgment call. And what I suspect is different also about this particular case is, yes, you were getting signals, but I'm not sure, very early on at least, they were signals that indicated a criminal problem. Maybe they were. Hindsight clearly shows they were. But the signals clearly demonstrated that there was a political problem, that there was a policy problem, that there was something that you had to get resolved. And so I don't know whether you should have acted sooner than you did. I don't know whether you should have got the criminal section involved. Hindsight would indicate that probably you should have. But it's a close call, and it's a subjective thing, and I think it's a very, very tenuous argument to make that you should have done it earlier than you did. If I could have just one more minute, Mr. Chairman, I'm almost done. Thank you. I think that at worst, the worst argument that can be made for what your department did was that you didn't move quite fast enough in sealing the records. You didn't move in there and make sure that Ollie North was not involved in the shredding that we now know existed. That's the worst, I think, criticism that can be made. The real problem here, I think, is that the people who I've mentioned, Admiral Poindexter, Lieutenant Colonel North, Bud McFarlane, did not really understand the lessons of history. They didn't understand what we have learned in this country through a tortuous process. They didn't really understand what your boss, what the Attorney General of the United States, told Bud McFarlane. They didn't understand, to quote the Attorney General, that you serve the President best by telling the truth. But the best way to protect the President is to tell the truth completely and get the facts out. The Attorney General understood that. Unfortunately, these other individuals did not, and because they did not serve the President well, nor did they serve the country well. Thank you very much.
Thank you, sir.
Senator Mitchell.
Mr. Cooper, you are the Assistant Attorney General for the Office of Legal Counsel, and you testified this morning that the Office of Legal Counsel analyzes and prepares legal opinions on the important legal issues facing the executive branch of government. For words to that effect. You are, in effect, it has been said, the lawyer for the President's lawyer. That is, you are the Office of Legal Counsel to the Attorney General of the United States. Is that correct?
Yes, sir.
Mr. Cooper, I have before me a memorandum for the Attorney General prepared and signed by you dated December 17, 1986, 18 pages in length. I'm going to ask, Mr. Chairman, that this be made a part of the record. I would like to simply read to you,
without objection, so ordered,
one paragraph from your memorandum, Mr. Cooper, before I place it in the record, because I think it is relevant to much of what has occurred in these hearings prior to today. You wrote in your memorandum, and I quote, "The National Security Council clearly falls within the definition of an intelligence agency given in Section 403B1 of the Intelligence Authorization Act." And then you quoted the Act, "Any department, agency, or other entity of the United States involved in intelligence or intelligence-related activities," close quote. Mr. Chairman, I'll ask that this be placed in the record. I want to ask you, Mr. Cooper, as the principal member of the executive branch charged with the responsibility of rendering legal opinions, prior to that time, had you ever been asked by anyone within the executive branch for a legal opinion on that particular question?
On the question addressed in footnote 10?
Yes.
No, sir.
All right. Now, Mr. Cooper, in response to a question from Senator Hatch, you said you believed what Colonel North told you when he said that the President didn't know of the diversion. Do you recall that response?
Mm-hmm.
You do?
Yes, I think I do.
You also believed, did you not, what Colonel North said when he told you on November 20th that no one in the United States government knew at the time that Hawk missiles were shipped to Iran in November of 1985, did you not?
Yes.
In fact, at the time these events occurred, you believed everything Colonel North told you, didn't you? You had no reason to disbelieve in it.
On the 20th, that is true.
Right.
On Sunday, that is not true.
Yeah. So the fact that you believed what Colonel North said is not evidence of the truthfulness of his statements one way or the other, is it?
Of course not.
No. Now, you testified this morning in response to a question by Ms. Naughton when she asked your impression of Mr. McFarlane's credibility following your meeting with him and the Attorney General on November 21st, and you said, and I believe I wrote down exactly your words, he was not entirely straightforward and was not entirely forthcoming. Let me ask you more directly. Did you mean that you thought he wasn't telling the truth?
I really would resist that characterization. I did not have confidence that he was telling me the truth. I suspected he was not telling us the truth.
Right. So I want it in your words. Your words are you suspected that he was not telling you the truth. That would be your characterization of his...
I am comfortable with that characterization.
All right. Now, when you met with Colonel North on that Sunday, you had had a meeting with him a few days before that, and that's been covered at great length, so I won't go into that, regarding his active encouragement of the Director of Central Intelligence and the National Security Advisor to come before Congress and make statements which it is now obvious he knew were untrue. And you had the meeting with him in the Attorney General's office because the previous day you had discovered the memorandum referring to the diversion. And that was a significant discovery insofar as your inquiry was concerned.
Yes, although we fully planned to interview him even if we hadn't discovered that diversion memo.
All right. Now, in the course of it, he was shown the diversion memo, and then you testified, and I think, again, I wrote down your words exactly. He asked, this is Colonel North, asked, did you find a cover memo? Mr. Reynolds responded, no. The Attorney General said, should we have found a cover memo? And Colonel North said, no, I was just wondering. And then you testified he volunteered to go back and look for one if you wanted him to. My question to you is, in the context of what had occurred, did that arouse your interest or curiosity?
Senator, I tried shortly after the lunch break to better express the moment and context in which I recalled that exchange to have taken place. The one that you have just reported, I do not think is accurate. The memo by that time had been in Colonel North's hands for some time. He had been questioned on several aspects that were, by comparison, non-controversial. The exchange, as I recall it, that you're referring to, took place after the questioning about the Contra diversion had been begun and was in train, and it had been established that there had been a Contra diversion. and that some funds had been transferred, though he didn't know how many, that how much money, that insofar as he knew, the following people knew about it, and he did not think other people knew about it. And then the Attorney General attempted to find out if there are other ways for him to discern who else might know, as opposed to word-of-mouth knowledge of this, but by documentary knowledge of this. You keep in mind this is a memo that on the face of it appears to be a draft. So there was an exchange in which the Attorney General asked if this thing had gone forward to the President, would there be a record of it in your files? And so therefore we would have it, presumably. To which he said, yes, yes, we keep records of stuff that goes to the President. And a couple of other questions along those lines. It is at that point, I think, that North said, asked the question to the effect, was there a cover memo on this or something? Why? Was there a cover memo? Something along those lines. And the Attorney General responded, or I think actually Brad Reynolds responded, that there had not been a cover memo. And that seemed more to accord with his understanding. He would have been surprised if a cover memo had been on this thing.
So when you say the question was inaccurate, it was not inaccurate as to what was said, but merely you wanted to make clear that there was a gap in time and intervening questioning between the presentation of the diversion memo to Colonel North and his raising of this question of a cover memo.
Yes, and to provide you with at least my best sense of context. It was not he was handed the memo and he immediately blurted out, was there a cover memo? I mean, there was nothing that seemed furtive about it at all.
I understand that. And really, what you're saying, I think, is that he very skillfully raised the question at a time and in a manner so as not to arouse your interest or curiosity.
It may well have been the product of skill. Yes, sir. I do not know.
One of his many skills which have been displayed before this committee. Thank you very much, Mr. Cooper, for your testimony. Thank you, Mr. Chairman.
Congressman Jenkins.
Thank you, Mr. Chairman. Mr. Cooper, I'll be very brief. If you didn't have experience in November, I assume you do now, so that if you're ever asked again. In addition to the figures that you have indicated that either lied to you or misled you of North, Poindexter, McFarlane, possibly others that you named, do you know of anyone else that did not tell you the truth that you questioned? Are you aware of anyone else?
No, sir. Not that I can think of.
All right. When you, incidentally, when you decided, when you were preparing to come here, did you meet with anyone to go over your proposed testimony in the Department of Justice?
No, sir. I didn't meet with anybody, but certainly I've had conversations with a number of people throughout all this.
All of the Attorney General?
I haven't had a conversation with the Attorney General for some time. He's been out of town now for a couple of weeks. And I haven't had a conversation with the Attorney General on this subject matter in many weeks that I can recall.
I'm not trying to imply that you were preparing your answers in a way that is not truthful, because I think your testimony has been truthful. I'm just curious as to whether or not you discussed the problem areas with members of the Department of Justice that may arise in your testimony.
No, sir. I have asked throughout this process. Understand I've spent upwards of 25 hours with the excellent staff of this committee, providing what information I could, and I've spent a very large number of hours with other bodies investigating this. And throughout this time, I have had conversations with others whose memories might be able to supplement my own, where I found a flaw or something like that. But that's the extent of it.
As I understand, on your November 21st activities, you were informed that the President and Mr. Regan had met with the Attorney General on that date. Is that right?
I'm sorry, what date was that?
November 21st.
Yes, sir. Oh, yes, sir, that's correct. Yes, that was Friday, the 21st.
From my notes, and at that time the President was told of the problem with the 1985 shipments. Is that what the Attorney General indicated?
I honestly can't tell you if he identified the precise nature of the concern. He may well have, but I just don't know.
The Attorney General did not indicate that the President had been aware or not been aware of the 1985 shipments?
I cannot recall him having reported to me any information on that.
But that would have been a critical question, I assume, if there had been an absence of a finding.
Oh, yes, sir, it would indeed.
But you don't know whether or not that question was asked of the President?
I don't know whether it was asked on that Friday. I think it's been asked by at least the Tower Board since. But I don't know whether he asked that question or not.
All right. Let me ask you one further area. Did you do any investigation as to donations or gifts by third countries other than the $10 million gift?
No, sir, I didn't. That part of it was not at all something that came into our fact-finding. This was not something we discovered, the $10 million gift.
So you did not look into any of those areas whatsoever?
None of those areas.
All right. My time is up. I want to thank you for your testimony today.
Thank you, sir.
Senator McClure.
Thank you, Mr. Chairman. Mr. Cooper, I believe you testified this morning that during the ride back to the office after your luncheon meeting where Mr. Reynolds first informed the Attorney General and yourself about the diversion memo, that the legal significance was still not clear to me. I think that was your words this morning. I believe you added it's still not clear to you today. Is that a fair summary of your statement?
I think that is a fair summary of my statement, yes, sir.
What do you mean by saying the legal significance is not clear to you?
I have not examined a lot of the issues and arrived at any conscientious judgments upon the issues that are raised and implicated by that diversion.
Would it be fair to say that then and now you're not certain in your own mind with respect to the possible violations of law that may be indicated by that memo?
It is certainly fair.
Do you have in mind all of the several acts that you've referred to, the Economy and Government Act, the Export Arms Control Act, the various other statutes dealing with fraud?
Well, actually, I have examined the Arms Export Control Act in some detail, and I think the record now will reflect some lengthy legal memoranda that my office has prepared on several of the issues, but the so-called diversion issues are not issues that I have arrived at any judgments on.
Right. With whatever relevance, you're no more certain with respect to the Boland Amendment so far as the diversion memo is concerned?
Yes, sir. I have not examined the Boland Amendment and arrived at judgments on that.
Mr. Cooper, when you interviewed Colonel North regarding the diversion memo, he stated that the President had not seen the memo. Is that correct?
Yes, sir. To his knowledge, he did not think that he had.
Did Mr. Poindexter or Mr. McFarlane indicate that the President had seen the memo?
On the contrary, they both said that, or at least I'm certain that Admiral Poindexter said no, but I'm not sure McFarlane would have known one way or another, but he did say that he didn't know that the President knew about it.
This morning you testified that you'd been told that it was Mr. Neer who had come up with the idea of a diversion to the Contras, and that Neer was portrayed as eager to help the U.S. and the Contras. Is that correct?
That is the understanding that Mr. North provided us.
It was Colonel North who told you that?
Yes, sir.
What exactly do you recall Mr. North saying about Mr. Neer's involvement?
That it was Colonel North's recollection that it was Neer who approached him with proposals to try to assist in efforts to assist the Contras. And that Colonel North indicated that Neer had proposed a couple of things that would have been, by North's reckonings, unlawful. But that when he came up with the idea of using profits, excess funds from the arms transactions, that they went forward with that.
You've testified that you have come to the conclusion in your own mind that at least a good case can be made that the proceeds of that sale, the net proceeds of that sale, are monies that belong to the United States government.
Yes,
Is that
sir.
correct?
Yes, sir.
You were somewhat less than totally dogmatic about that statement.
It is my view.
Yeah.
It is my view.
And then you have indicated that it took you some time to come to even that point in your discussion or in your thinking about that question.
We analyzed the issue quite extensively.
Is it conceivable that those that were involved in this transaction might have reached a different conclusion?
Oh, certainly. Yes, sir.
That's not so off the wall as to be a ridiculous and obviously wrong or self-serving.
There are some propositions that would not answer to your description, but the proposition that I have heard, the notion that certain countries or individuals between the United States and Iran were the owners of the arms and could do with them essentially what they would, including sell them to Iran, that is a proposition that does fit the description, in my opinion, that you have provided.
Mr. Chairman, if I might, I have one further inquiry. I'm not certain that I understand how it was that Mr. Green was talking to you, in what capacity he was talking to you and the Attorney General or to Brad Reynolds, whoever it was he was talking to. Did I hear you correctly to say that he'd indicated that he was not talking to you as counsel for these parties?
That is my recollection for his position. Yes, sir.
All right. He was not approaching you as attorneys for the parties. What was his ostensible purpose in talking to you, and what was your reason to be talking to him about these matters?
He had information about this Iran initiative that was important, and it was very important information. It was very important that we have it. That was his presentation.
That was his approach to you, but when it came down to it, his important information was you shouldn't go public with it.
Well, that was one of the propositions that he advanced. Yes, sir.
Well, no, he said they were not. Said they were not. I want to share with other members of this committee the commendations they've made about your appearance here, and also to say that I don't regard the fact that you didn't jump to conclusions earlier as being any indictment of your perception. Some people arrive at conclusions faster than others. I would say to my friend from New Hampshire, he's smiling, he knows I'm talking about him. The second point that I think ought to be made is I don't think
we should leave the record unclear on one point, and that is at least some of us don't think you're too young to handle the job. The Constitution of the United States says you're qualified, at least by age, to be a member of the House of Representatives at age 25. And I assume if you're qualified to be a member of the House of Representatives, you might also be old enough to be an Assistant Attorney General. Thank you very much.
Thank you, sir.
Senator Cohen.
Mr. Chairman, I had one other question that I just wanted to put to Mr. Cooper. Earlier
Yes,
today, you indicated that while you were interrogating or investigating the matter with Colonel North, you asked him whether he was told or believed that there was a shipment of oil drilling equipment. And his response was, no, but I could probably pass a lie detector test if I had to. And he said it in a joking fashion. And I was struck by the curious response that he gave you. Why would he suggest to you that he could pass a lie detector test if he had to?
I think his point was simply that he was told it was oil drilling equipment. He had, doubts about whether it was really oil drilling equipment, and in fact, if he had to say, he would probably have said, I don't really think this is oil drilling equipment. But he nonetheless had been told it was oil drilling equipment. It is on that basis that he proceeded. That was the essential pitch.
But doesn't it sound like a curious follow-up statement to say that, but I could probably pass a lie detector test if I had to?
It was a curious formulation, and it stuck in my mind.
Do you think he was testing you?
Well, I don't know. I just don't know. He may well have been. I don't know.
Sir.
Mr. Cooper, it's been a long day, and apparently I will be the last person to question you, sir. In response to a question by Chairman Stokes, you indicated that Colonel North would lie even under oath. When did you reach that conclusion?
Senator, in a way, I guess I really feel bound to say that I regret that I've come to the opinions that I have and have expressed regarding the events and the truthfulness of certain people in those events. I feel very awkward about it because I do truly believe that some individuals fell into grievous error in this event, in this matter. But I feel very sorry for them. I think, by and large, they are probably decent and honorable men who, as I say, fell into an error on this occasion, but not that these men are given to this kind of behavior or anything of the kind. I just wanted to make clear that I do not relish having come to the conclusions or sharing with them publicly, as I have today, these conclusions about what these men said.
On November the 23rd, when the Attorney General and you, together with others, met with the Colonel and confronted him with the diversion memo, were you convinced at that time that he was capable of being less than candid?
I approached it with sensitivity to that prospect, yes, sir. I wasn't convinced of it at that point, but it was not with blinders that I participated in the meeting.
So on the 23rd of November, you had doubts as to Colonel North's veracity and honesty.
That's really, I guess, in a way, putting it too strong. I knew that there was a serious collision between what he reported and what appeared at that point to be the fact, because I was absolutely convinced that the Secretary of State and Mr. Hill were candid and correct. But by the same token, I did not lightly, by that time I hadn't come to that conclusion. I have certainly come to that conclusion now. And the questions that I have received regarding whether or not certain statements were true or false have all been phrased in the context of my judgment and belief now. Now we all know that they were not. But I also have to say that that I found Colonel North entirely believable on every occasion that I met with him. His demeanor was, there were no indications in his demeanor or anything else that suggested to me that he was not being truthful. On the contrary, I found Mr. McFarlane ill at ease, and that's one of the things that led me to be concerned that he wasn't being straightforward and thoroughly candid, as I mentioned earlier.
In fact, you have testified that on November the 21st, you had serious concerns regarding the candor of Mr. North and Mr. Poindexter, and yet the Attorney General told Mr. Poindexter that a search of the files of Colonel North would be conducted the next day. Isn't that correct?
The Attorney General asked the head of the National Security Council to have the documents prepared and available.
That was November 21st, and we have testimony now that tells us that that evening we had the famous shredding party.
Yes, sir. That appears to be the fact.
Do you believe Admiral Poindexter warned Colonel North?
Somebody did, it appears. I mean, Colonel North was there Saturday morning. Somebody obviously made him aware of the fact that we were going to review the documents.
The day after the shredding party, the 22nd of November, Mr. Reynolds went to the office and found this diversion memo.
The day after the shredding party? Oh, yes.
Yeah,
yes,
the 22nd.
Yes, sir.
Did Mr. Reynolds tell the colonel that he was taking this memo from the files?
I just don't know the answer to that.
Do you
I
believe
doubt
it?
it very seriously, extremely seriously. In fact, I would say that the answer to that is no. Colonel North was surprised when we had the memo, or at least he was surprised when the reference was made to the Contra diversion in the memo. And I am absolutely certain, let me just escalate my confidence to that level, that Mr. Reynolds and Colonel North had no conversation about that memo.
And on November the 25th, I gather that the Attorney General was compelled to call a press conference to advise the nation of the discovery of this memo.
Yes,
and
sir.
in the interim, you had heard from the Secretary of State and others, which confirmed your doubts about the Colonel's veracity and honesty. Isn't that correct?
We were getting wary of it, yes, sir.
At the time of the press conference on that day, the Attorney General directed that the office of Colonel North be secured. Isn't that correct?
He did direct that, yes, sir. On
When
Tuesday.
was the office actually sealed? Now, the orders were given on the 25th of November. When was it sealed?
I defer to counsel that the FBI sealed it on Friday. I think I understood her to say, I don't have personal recollection of that fact. But it is my understanding, however, that in the second meeting, when the miscommunication was discovered between the Attorney General and the Deputy Attorney General, it's my understanding that Peter Wallison was made, was directed at that moment to have those offices secured. Now that apparently wasn't the FBI, its official sealing of the offices, but Peter Wallison was advised, it is my understanding, that he should secure them. And as I recall, Colonel North was not, his pass and what have you were confiscated.
I'm just curious, why did it take so long to secure this office? Because on the 7th of November, you were beginning to have doubts. The 17th of November, you were quite clear that something was wrong. On the 20th, you felt compelled to call in the Admiral and the Colonel. On the 21st, the Admiral was told that the office would be searched. On the 23rd, you confronted the Colonel with the memo. On the 25th, you called a press conference. And in the interim, we had shredding parties. Why did it take so long?
Again, Mr. Chairman, not until the 25th was a decision made that we indeed could and should go forward with a criminal investigation. During this period of time, obviously, evidence was lost, and that is regrettable. And in hindsight, obviously, one wishes that extraordinary measures of some kind had been taken, that people had perceived the need to take extraordinary measures. But not until the 25th did we develop an understanding of the implications of the diversion that satisfied us that there was a potential criminal predicate, and therefore go forward with the investigation. It was at that moment.
On the 25th of November.
That is my recollection, yes, sir.
But yet it was about 5 days beyond that when this office was sealed.
Yes, sir, and well, by the FBI. And I really don't have a good understanding for why that is true.
When did the Attorney General meet with the President to advise him of the discovery of this memo?
Monday the 24th.
24th of November.
Yes, sir.
Do you know whether the President called Colonel North on that day?
I have no knowledge that he did that. No, sir.
Do you know whether the President did call Colonel North?
Do I know if he did not or did?
Whether he did.
I have no knowledge either way. I just don't have any knowledge at all about that. I've never heard that he did.
Wasn't that important information for you?
If the President called Colonel North on the 24th?
Yes.
Well, it would be important information, I guess, but I have no knowledge that he did, no reason to think that he did.
If you were the President of the United States and a firestorm was breaking all around you with this disclosure, and the Colonel's name is splattered all over the front pages, would you have called him in?
I think I misunderstood the date, that yes, on the 25th, when this thing was made public, I might have done so, yes, sir. I don't know whether the President did, however. I might have called him in, certainly.
To
But
find out
I don't
what-
know whether the President did or not. Excuse me?
Is that what a reasonable man would have done?
Call in Colonel North?
Yeah.
Well, I mean, I don't know. I think a reasonable man would have. I think a reasonable man might not have. I don't think it was unreasonable, in other words, for him not to have if he didn't. He had just fired him, apparently.
None of us here have ever sat where you're sitting now, and so none of us can ever know how it feels to be a witness. But in a small way, I can sympathize. It's been a difficult day for you. And therefore, with all sincerity, on behalf of the Joint Committee, I thank you for your assistance.